That's not an issue, is it?
No, Your Honor.
Okay, so that's granted, you can do that. All right. So then what's your issue, Mr. Administrator?
Well, Your Honor, as you know, I wasn't present yesterday, but it's my understanding that an issue with regard to one of the jurors and an interaction, I believe, with our court reporter. And I was hopeful that we might be able to get that on the record and sort of flesh it out a little bit.
With the juror?
Oh, not yet, juror.
Okay.
I think before we take that step, I'd like to have a full understanding on the record of what exactly the interaction was, whether or not, and most importantly this morning, whether or not the court received any notification from that juror that there was an out-of-court interaction.
I did not receive any correspondence from the juror. Nothing from the jurors. I'm just asking a bit check. Okay. So the full interaction, and I reported this yesterday, my understanding is the Taylor, our court reporter, spent the court reporter for most of the trial, went to dinner on Tuesday night. And the place where she went to dinner is apparently where this juror must work, because the juror was working as a hostess or a waitress. When the court reporter made eye contact with the juror, the court reporter told me they seemed to recognize each other. And the court reporter said to the juror, can't say anything about it. And the juror either said agree or nodded affirmatively, and that was it. That was it in terms of the verbal contact, although I understand that she then was the waitress or the person who brought the food and stuff to the table.
I see. Okay.
And that was the juror number. Yes. Else on that issue?
One moment.
Yeah.
Well, if you're satisfied that this interaction was benign, as you related, it appears to be, then we're satisfied that there will be no need to voir dire.
Okay. I am satisfied with that, and I think it's similar to, like Attorney Boylan said yesterday, that church experience that some of you, or I think it was you, Mr. Administrator, and everybody but Mr. Mendenhall. Yeah. I'm still wondering why he wasn't in church with you guys.
In all honesty, I missed the other side. He was trying.
All right, so that issue is resolved. Anything else in from plaintiff? Okay, attorney.
Yes, sir.
Okay.
I had a request. That's something.
We're gonna need a microphone, portable microphone. Also.
Okay. It's right on the podium. You're gonna be the first to use it, so if you want to use it now or get ready to use it, I read the instructions first.
Right.
So you're probably gonna have 20 to 30 minutes of, getting organized.
Sounds good.
Okay. Attorney Guzzi?
As I was preparing my closing argument last night and going through the verdict form, and I'm not challenging anything on the verdict form, but it occurred to me that I needed some clarification, or we needed some clarification on the scope of plaintiff's argument.
On what?
On the scope of plaintiff's argument.
Okay.
It seems to me that the counsel's closing argument must be limited to breaches as identified in the enumerated questions on the verdict. In other words, they can't.
I don't think that's true.
I think it is. I think this is the form they agreed to. This is the form that's the breaches or alleged breaches that the jury is to consider. And I think for them to bring in any other argument or any other allegation of breach of standard of care gets us into the territory of the Merkel case and the concept of negligence in the air. And if there is any such argument about a different or alleged breach of the standard of care, I believe that's grounds for mistrial. And if that occurs, just like in the opening statement, Judge, I will not make my motion during plaintiff's argument, but I will make it at the next break, because I don't think it's appropriate.
Well, I'd encourage you to do it during the argument then, because I think we're talking two different things. When the verdict form was drafted, I specifically indicated that paragraphs 1A through 1D, 3A through 3C, and 5A through 5G are not limiting answers to number 1, 3, or 5 respectively. So I think it would be a consistent verdict to answer yes to 1, but answer no to 1A, 1B, 1C, and 1D. And so if they're arguing other breaches in the standard of care that would fit under questions 1, 3, or 5, but are outside the scope of the subparagraphs of those numbers, in my opinion, that's not outside the scope of this case. It's not outside the scope of the presentation of their case. And in no way did I create those paragraphs to limit arguments. I did it, as I explained yesterday, there's a lot going on in this case. And there's declaratory judgment decisions that I'm going to need to make. And I thought it was appropriate to ask the jurors questions on that without signaling it. But also getting answers from them on things that are important to get answers to. So understanding your argument, but again, it's not inconsistent. In my opinion, if we get a verdict that answers 1 yes, 1A no, 1B no, 1C no, and 1D no, I think that's fine. That means that Dr. Schokar, in their opinion, violated a standard of care that I didn't enumerate in 1A through 1D. If you remember their proposal, they wanted me to ask 21 different subcategories. I'm not doing that.
I understand that.
But they can argue those 21 because it would still fit under number 1. But I think you made your record. But if you're in this closing argument and it goes outside the scope of what I just said, then I want to address right away, because I think I'll be paying attention and understanding. But if it's outside the scope of 1A through 1D, for example, but not the scope of number 1, then your record's made.
So, for example, they can bring up the issue of informed consent as it relates to precedents. That's not something that's even within the consideration of those enumerated questions.
No, I think it'd be inappropriate to argue that Dr. Schokar was responsible for the informed consent on precedents, because he wasn't there on October 6th or 7th. The way that it was asked in paragraph 3A and 3B of the verdict allow them to talk about his take, or Dr. Shokar's take, when he arrived on October 12th at 6 o'clock in the morning, and the ongoing administration of it.
And that's the example. The scope in terms of precedents is limited to those 2 days. So any argument suggesting anything outside of those 2 days, to me, would be grounds for mistrial.
I don't want to argue their case for them, but if they were to argue that a reasonable doctor would have looked at the charts or the records and said, there was this medical event on October 7th and another medical event on October 8th, and the doctor should have informed the family about it on October 12th, knowing that they hadn't been informed about it, which is what I think their argument's going to be. I think that's fair. But not linking him to the errors or the alleged errors that happened prior to October 12th at 6 o'clock.
Judge, I can represent from plaintiff's perspective that we've structured this closing argument so as to avoid the issue that Mr. Goosey's raised.
I'm satisfied with the record I've made, and
okay,
if need be, I'm going to jump up and down and holler mistrial, but I will.
Has to approach.
Ask to approach out.
Yeah. Okay, Mr. Frankowiak.
I would concur with what Attorney Goosey just said, and I would join, obviously, his representations.
Okay, so we're going to take a break, Mr. Administrator, at 9:30. And so on that clock. So if you see it's getting close and it's 9:25 and that's a good spot for you to take a break, feel free to leave, tell us then. Or else at 9:30, I might remind you, how much longer, and then we'll just try to break. Okay,
Sounds good.
all right, you may bring the jury in. All right, everyone may be seated. Good morning and welcome back, members of the jury. Hope you enjoyed your day yesterday. I missed seeing all of you. But we have a full day today. And before we get started kind of in the part of it, I just, on behalf of the parties and the attorneys and those of us who work in this building every day, I just want to say thanks for your commitment, your efforts, and all the time that you've put into the 3 weeks. It's admirable. It's inspiring. And I think it shows all of us that living in Outagamie County, when we have individuals like you who are serving in this capacity that you didn't choose to do, and you're given all those sacrifices, that we're very fortunate. So thank you. I'd like the bailiffs to approach, and I have 2 stacks of papers for the jurors, and so they're going to be handed to you. And I'm going to ask that you each get one of those, and I'm going to wait till you have those in your hands, start explaining things. So each juror should have a packet, and on page one of them, it has a number 100 on top. If you look at that packet and just make sure that you have 18 pages. So the last page is 18 of 18. The other packet on the front page is called special verdict. And on the bottom of that special verdict page is 1. And then when you go to the last page, it should be page number 10. Okay, and it appears that each of you have both packets. So I discussed with counsel yesterday, and we're all in agreement that you have in front of you documents that you're each going to be able to take into the jury room with you. So when you're sitting around the table, you'll be able to go through it and not have to stand over somebody's shoulder, not be able to visualize it. You're also going to have these documents when I'm reading them to you. I'm obligated to read to you the jury instructions, which is this packet of 18 pages. That's the law that we had talked about, at the beginning of this case. When you became jurors, I said at the end of the case, I'm going to instruct you to the law. So that's the law. The special verdict form, which is the 10-page document, are the questions that you're going to be asked to answer. And when that verdict gets complete, you'll return to this and the clerk will read that into the record. I'm going to start my introductions or my comments before I read this law to you. I'm just going to tell you that this verdict form can be complicated, but I think it is simple if you just read the directions and kind of follow along. And all I'm going to do is look at page 1 as an example. So on page 1, question number 1 needs to be answered yes or no. When you get done answering that, in bold under that question are some directions. So you'll see on the verdict form throughout that the black bold is directions to you based on whatever your previous answers were. And for example, it says answer, questions if you answered yes to question 1. If you are a dissenting juror by answering no to question, then you should answer no to each of those additional questions. Okay? And then throughout. I will tell you, and you'll hopefully make sense when we go through it, that number 1 and 2 are kind of connected. Number 3 and 4 are connected. Number 5 and 6 are connected. And then 7 and 8 are connected. So it's really 4 sets of 2 questions. So I'm now going to start on page 1. You don't have to follow along if you don't want. As I'm reading, some people learn better by reading and seeing, some people listen, and some of us do better by both. So do whatever is comfortable for you. Members of the jury, this case will now be submitted to you in the form of a special verdict consisting of 8 questions, numbered question 1 through question 8. There are an additional 13 questions, numbered question 1A through 1D, question 3A through 3C, and question 5A through 5F that may need to be answered depending on your answers to previous questions. Your duty to answer those questions, which according to the evidence and my instructions, it becomes necessary for you to answer to a completed verdict. It then becomes my duty to direct judgment according to law and according to the facts as you have found them. Evidence is defined as follows: testimony of witnesses given in court, both on direct examination and cross-examination, regardless of who called the witness. Second, deposition testimony presented during the trial. Third, admitted by me, regardless of whether or not they go to the jury room. And number 4, any facts to which the lawyers have agreed or stipulated to, or which I have directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. You are to be guided by my instructions and your own sound judgment in considering the evidence in this case during these questions. Do not concern yourself about whether your answers will be favorable to one party or to the other, nor with what the final result of this lawsuit may be. The court has allowed the use of charts to organize the evidence and to assist you in understanding it. The charts are a summary of some of the evidence that was presented. However, it is the evidence that controls. You should rely on the charts only to the extent that you believe it accurately and properly summarizes the evidence. The remarks of the attorneys are not evidence. If any remarks suggested certain facts not in evidence, you should disregard that suggestion. Hear carefully the closing arguments of the attorneys, but their arguments, conclusions, and opinions are not evidence. Draw your own conclusions and your own inferences from the evidence and answer the questions in the verdict according to the evidence and the instructions given to you by me. The lawyers for the parties have a duty to object to what they feel are improper questions. Do not draw any conclusion for each side if an objection was made to a question and the witness was not permitted to answer. If any member of the jury has an impression that I have an opinion one way or another in this case, you should disregard that impression entirely and decide the issues, view the evidence. You, the jury, are the sole judges of the fact, and the court is the judge of the law only. I ordered certain testimony be stricken during this trial. You should disregard all stricken testimony and do not let it affect your answers to any of the verdict questions. Some questions in the verdict are to be answered only if you have answered a preceding question in a certain manner. It is important for you to read the introductory portion of each question carefully before you answer it. Do not answer questions you are not required to answer. I'm going to just full transparency here, okay? So if you go to page 1 of the verdict form, I don't know how many times I've read this verdict form. It's over 100 times in the last week. But you guys catch the error that I have on there? I see one juror shaking his head. You're not supposed to shake your head yes that you saw an error. You're supposed to say, no, it looks great. So in that bold where it says, answer questions number 1 through A, everybody, you see where it says through 1C? It should be 1D. So I'm going to modify that during the closing arguments, and the verdict, this is the official verdict form that I'm going to give to the jury room, and that will be in that one respect. So it's going to be 1A through 1D. But that's an example of why it's important to read those introductory paragraphs, okay? Agreement, I'm back to page 3 of the instructions. Agreement by 10 or more jurors is sufficient to become your verdict. Jurors have a duty to consult with one another and to deliberate for the purposes of reaching an agreement. If you can do so consistently with your duty as a juror, at least the same 10 jurors should agree in all the answers. I ask you to be unanimous if you can. At the bottom of the verdict form, you will find a place provided where jurors, if there are any, will sign their names and state the answer or the answers on the verdict questions in which they do not agree. Either the blank lines or the space below them may be used for that purpose. Certain questions in the verdict ask that you answer the questions yes or no. The party who wants you to answer the question yes has the burden of proof as to that question. This burden is to satisfy you by the greater weight of credible evidence to a reasonable certainty that yes should be your answer to that verdict question. The greater weight of the credible evidence means that if the evidence in favor of a yes answer has more convincing than the evidence opposed to it. Credible evidence means evidence that you believe in light of reason and common sense. Reasonable certainty means that you are persuaded based upon a rational consideration of the evidence. Absolute certainty is not required, but a guess is not enough to meet the burden of proof. In considering the amount to be inserted by you in answers to each damage question, the burden rests upon each person claiming damages to convince you by the greater weight of credible evidence to a reasonable certainty that the person sustained damages with respect to or elements mentioned in the question and the amount of those damages. The amount you insert should reasonably compensate the person named in the question for the damages from the occurrence. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider the following factors. Whether the witness has an interest or a lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity that the witness had for observing and for knowing the matters the witness testified about, the reasonableness of that witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and then all other facts and circumstances during the trial which tend either to support or to discredit that testimony. Then give to the testimony of each witness the weight you believe it should receive. There really is a way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of a witness is entitled to greater weight than that of another witness or even of several other witnesses. It's not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proven indirectly by what's called circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Usually, witnesses can testify only to facts they know, but a witness with expertise and/or specialized knowledge in a particular field may give an opinion in that field. In determining the weight to be given an opinion, you should consider the qualifications and credibility of the expert and whether reasons for the opinion are based on facts in this case. Opinion evidence was admitted in this case to help you reach a conclusion. You are not bound by any expert's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other and consider the qualifications and credibility of the witness and the reasons and facts supporting their opinions. During the trial, the court received portions of published treatises and evidence. Evidence was not received to establish that the views expressed by the author are undisputed truths or absolute standards. The author's views should be considered as any other expert witness's opinion. You are not bound by the opinions expressed by any more than you are bound by the opinion of any other expert witness. During the trial, a witness with expertise and/or specialized knowledge in a particular field was told to assume certain facts and asked for an opinion based on those assumed facts. This is called a hypothetical question. Consider the opinion in the answer to that question only if you believe that the assumed facts if you find that the assumed facts in the hypothetical question have not been proved, do not give any weight to that opinion. In providing care and treatment to Grace Schara, Dr. Gavin Shokar was required to use the degree of care, skill, and judgment which reasonable hospitalists who are in the intensive care unit a doctor who fails to conform to the standard is negligent. The burden is on the plaintiffs to prove that Dr. Gavin Shokar was negligent. A doctor is not negligent, however, for failing to use the highest degree of care, skill, and judgment, or solely because a bad result may have followed his care and treatment. The standard you must apply in determining Dr. Shokar was negligent is whether Dr. Shokar failed to use the degree of care, skill, and judgment that reasonable hospitalists in the intensive care unit would exercise given the state of medical knowledge at the time of the treatment in issue. If you find from the evidence that more than one method of treatment for Grace Schara's condition was recognized as reasonable, given the state of medical knowledge at the time, then Dr. Shokar was at liberty to select any of the recognized methods. Dr. Shokar was not negligent because he chose to use one of these recognized treatment methods rather than another recognized method, if he used reasonable care, skill, and judgment in administering the method. You heard testimony during this trial from doctors who have testified as expert witnesses. The reason for this is because the degree of care, skill, and judgment that a reasonable doctor would exercise is not a matter within the common knowledge of lay people. Standard is within the specialized knowledge of experts in that field of medicine and can only be established by the testimony of experts. You, therefore, may not speculate or guess what the standard of care, skill, and judgment is in deciding this case, but rather must attempt to determine it from the expert testimony that you heard during this trial. In determining the weight to be given an opinion, you should consider the qualifications and credibility of the expert and whether reasons for the opinion are based on facts in the case. You are not bound by any expert's opinion. Question number 2 on that verdict form, which is on page 3 of the verdict form, asks, was such negligence by Dr. Gavin Shokar a cause of injury and/or death to Grace Schara? A person's negligence is a cause of plaintiff's injuries or death if the negligence was a substantial factor in producing injuries to Grace Schara and Grace Schara's death. This question does not ask about the cause, but rather a cause. The reason for this is that there can be more than one cause of an injury or a cause of death. You heard evidence that Grace Schara had COVID-19 in October 2021 and entered St. Elizabeth Hospital on October 6, 2021 as a result of COVID-19. The negligence of one or more individuals can cause an injury or death. In addition, the injury and or death can be caused jointly by a person's negligence and also the natural progression of the COVID-19. If you conclude from the evidence that the death of Grace Schara was caused jointly by Dr. Shokar's negligence and also by the natural progression of Grace Schara's COVID-19, then you should find that Dr. Shokar's negligence was a cause of her death. The evidence indicates without dispute that when Dr. Shokar started providing care and treatment to Grace Schara on October 12, 2021 at 6:00 a.m., she was inpatient in the intensive care unit at St. Elizabeth Hospital. Grace Schara's physical condition at that time cannot be regarded by you in any way as having been caused or contributed to by any negligence on the part of Dr. Shokar. This question, referring to question number 2, asks you to determine whether the condition of Grace Schara's health as it was when she placed herself under the doctor's care has been aggravated or further impaired as a natural result of the negligence of Dr. Shokar's care and treatment. Grace Schara sustained injuries before the treatment by Dr. Shokar. Such injuries had caused Grace Schara to endure pain and suffering and incur some disability. In answering these questions on damages, you will entirely exclude from your consideration all damages which resulted from the original COVID-19 condition. You will consider only the damages Grace Schara sustained as a result of the treatment by Dr. Shokar. It will therefore be necessary for you to distinguish and separate, first, the natural results and damages that flow from Grace Schara's original COVID-19 condition, and second, those that flow from Dr. Shokar's treatment, and allow plaintiffs only the damages that naturally resulted from the treatment by Dr. Shokar. Question number 3 on the verdict form asks, was Dr. Gavin Shokar negligent in informing Grace Schara and or her power of attorney about the availability of reasonable alternate medical modes of treatment and about the risks and benefits of those alternate modes of treatment with regard to the care and treatment on October 12 and 13 of 2021. A doctor has a duty to inform his patient about reasonable alternate medical modes of treatment available to the patient and about the risks and benefits of the treatments that a reasonable physician in the same or a similar medical specialty would know and disclose under the circumstances. If a physician fails to perform this duty to inform, he is negligent in his patient. A physician's duty to inform his patient does not require disclosure of detailed technical information that in all probability a patient would not understand, risks apparent or known to the patient, extremely remote possibilities that might falsely or detrimentally alarm the patient, information in emergencies where failure to provide treatment would be more harmful to the patient than treatment, information in cases where the patient and the patient's power of attorney is incapable of consenting, information about alternate medical modes of treatment for any condition the physician has not included in his or her diagnosis at the time the physician informs the patient. You have heard testimony during this trial from doctors who have testified as expert witnesses. This is because information about the availability of reasonable alternate medical modes of treatment and about the risks and benefits of the treatments that a reasonable physician would disclose to a patient in the circumstances of this case is not a matter within the common knowledge of lay people. The reasonable physician standard of a patient is within the special knowledge of experts in the field of medicine and can only be established by the testimony of experts. You may not speculate or guess what the standard of informing a patient is in deciding this case, but rather must attempt to determine it from the expert testimony that you have heard during this trial. In determining the weight to be given any opinion, you should consider the qualifications and credibility of the expert. Reasons for the opinion are based on facts in this case. You are not bound by any expert's opinion. A physician has a duty to provide the patient or patient's legal representative with the information that a reasonable physician in the same or a similar medical specialty would know and disclose under the circumstances. If a physician fails to perform this duty to inform, he is negligent in informing his patient or the patient's legal representative. You have heard testimony during this trial from doctors who have testified as expert witnesses. This is because information that a reasonable physician in the same or a similar medical specialty would know and disclose to a patient in the circumstances of this case is not a matter within the common knowledge of lay people. The reasonable physician standard of informing a patient is within the knowledge of experts in the field of medicine and can only be established by the testimony of experts. You may not speculate or guess what the standard of informing a patient is in deciding this case, but rather must attempt to determine it from the testimony that you have heard during this trial. In determining the weight to be given an opinion, you should consider the qualifications and credibility of the expert and whether reasons for the opinion are based on facts in this case. You are not bound by any expert's opinion. Question number 4 on the verdict form asks, was such negligence by Dr. Gavin Shokar in informing Grace Schara and or her power of attorney a cause of injury and or death to Grace Schara? A physician's negligence is a cause of a patient's injury and or death if the negligence was a substantial factor in producing the patient's injury and or death. This question does not ask about the cause, but rather a cause. The reason for this is that there can be more than one cause of an injury and or death. Question number 5 on the verdict form. Were one or more of the nurses at St. Elizabeth Hospital negligent with regard to the care and treatment provided to Grace Schara between October 6, 2021 and October 13, 2021? At the time in question, the nurse intensive care unit between October 6, 2021 and October 13, 2021 were registered nurses serving in this capacity at St. Elizabeth Hospital. As registered nurses, it was their duty in treating and caring for Grace Schara to use the degree of care, skill, which reasonable registered nurses would exercise in the same or similar circumstances, having due regard for the state of learning, education, experience, and knowledge possessed by registered nurses at the time in question. A registered nurse who conformed to this standard is negligent. The burden is on the plaintiffs to prove that the nurses and or St. Elizabeth was negligent. A registered nurse is not negligent solely because a bad result may have followed the treatment and care of Grace Schara. The standard you must apply in determining if the nurses and or the hospital were negligent is whether the registered nurses at St. Elizabeth Hospital failed to use the degree of care, skill, and judgment which a reasonable registered nurse would exercise at the time the service was rendered. You have heard considerable testimony during this trial from experts in the field of nursing and medicine who have been called as expert witnesses by both sides. The reason for this is because the degree of care, skill, and judgment which a reasonable registered nurse would exercise is not a matter within the common knowledge of lay people. These standards are within the special knowledge of experts in that field of nursing and medicine and can only be established by their testimony. Therefore, do not speculate or guess what those standards of care, skill, and judgment are in deciding this case, but rather you must attempt to determine this from the expert testimony that you heard during this trial. In determining the weight to be given an opinion, you should consider the qualifications, ability of the expert, and whether the reasons for the opinion are based on facts in this case. You are not bound by any expert's opinion. Question number 6 on the verdict form asks, was such negligence by one or more of the nurses at St. Elizabeth a cause of injury and or death to Grace Schara? A person's negligence is a cause of a plaintiff's injuries or death if the negligence was a substantial factor in producing injuries to Grace Schara and or Grace Schara's death. This question does not ask about the cause, but a cause. The reason for this is that there can be more than one cause of an injury or cause of death. You heard evidence that Grace Schara had COVID-19 in October 2021 and entered St. Elizabeth Hospital on October 6, 2021 as a result of COVID-19. The negligence of one or more individuals can cause an injury or a death. In addition, the injury and or death can be caused jointly by a person's negligence and also the natural progression of COVID-19. If you conclude from the evidence that the death of Grace Schara was caused jointly by the negligence of the registered nurses at St. Elizabeth Hospital and also by the natural progression of Grace Schara's COVID-19, then you should find that the registered nurse's negligence was a cause of her death. The evidence indicates without dispute that when the registered nurses started providing care and treatment to Grace Schara on October 6, 2021, she was positive for COVID-19. Grace Schara's physical condition at that time cannot be regarded by you in any way as having been caused or contributed to by any negligence on the part of the registered nurses at St. Elizabeth Hospital. The question asks you to determine whether the condition of Grace Schara's health, as it was when she entered St. Elizabeth Hospital on October 6, 2021, has been aggravated or further impaired as a natural result of the negligence of the care and treatment provided by the registered nurses at St. Elizabeth Hospital. Grace Schara sustained injuries before the treatment by the registered nurses at St. Elizabeth Hospital. Such injuries had caused Grace Schara to endure pain and suffering and incur some disability. In answering these questions on damages, you will entirely exclude from your consideration all damages which resulted from the original COVID-19 condition. You will consider only the damages Grace Schara sustained as a result of the care and treatment by the registered nurses at St. Elizabeth Hospital. It will therefore be necessary for you to distinguish and separate first the natural results and damages that flow from Grace Schara's original COVID-19 condition, and second, those that flow from the care and treatment by the registered nurses at St. Elizabeth Hospital, and allow plaintiffs only the damages that naturally resulted from the care and treatment. The law provides that a physician is not responsible or vicariously liable for all treatment provided to a patient, including any negligent acts or omissions committed by others providing care and treatment to the patient. Therefore, you may not consider any testimony or argument suggesting that Dr. Gavin Shokar is responsible for the negligent acts or omissions, if any, by any other physician or healthcare professional in providing care and treatment to Grace Schara, just because Dr. Shokar was the attending physician from October 12th and October 13th, 2021. The verdict form contains the following damage numbered 8A through 8C. The question reads, what sum of money will fairly and reasonably compensate plaintiffs for Grace Schara's death with respect to, and line A says funeral and burial expenses. I've inserted the answer to that question, so you don't have to answer it. And that number is $14,237.89. You'll see on the bottom of page 14, I've answered question A because the parties have agreed on the amount to be inserted. And then line B reads personal injuries for lack of informed consent. And line C reads past pain and suffering. I'm now down on the last line of page 14. You should not conclude the fact that I answered question 8A as to the amount of damages that any party has admitted fault or that any party may be responsible for the amount inserted. Finally, you should not assume that because I answered question 8A that a party already has or necessarily will recover that amount. Parties may, as here, agree on the amount of damages without admitting that they are responsible for the damages. In answering the damage, completely disregard any percentages which you may have inserted as your answers to the subdivisions in question number 7, which is the comparative negligence question. In answering the damage questions, be careful not to include or to duplicate in any answer amounts included in another answer made either by you or me. Your answers to the damage question should not be affected by sympathy or resentment, nor should you make any deductions because of a doubt in your minds as to the liability of any party to this action. Determining damages for pain and suffering and personal injuries for lack of informed consent cannot always be made exactly or with mathematical precision. you should award as damage amounts the amounts which fairly compensate the plaintiffs for their injuries. The amount you insert in answer to each damage question is for you to learn from the evidence. What the attorneys ask for in their arguments is not a measure of damages. The opinion or conclusions of counsel as to what damages should be awarded should not influence you unless it is sustained by the evidence. Examine the evidence carefully and dispassionately and determine your answers from the evidence phase. In answering question 8B, you should consider this following paragraph. If you have determined that Dr. Schokar was negligent in informing Grace Schara and her power of attorney, you will insert as your answer to question 8B the amount of money which under the evidence will reasonably and fairly compensate the plaintiffs for the injuries suffered by Grace Schara as a result of Dr. Shokar's negligence. The law provides that the estate of a deceased person is entitled to be compensated fairly and reasonably for pain and suffering in Grace Schara from the time of the negligence up to the time of her death. Pain and suffering includes all physical pain and discomfort, worry, and mental distress. In determining the amount of damages for pain and suffering, you will consider the nature, extent, and duration of all physical pain and suffering, mental anguish, apprehension, discomfort, or sorrow the deceased consciously endured and suffered between the time of the negligence and the time of death, and insert as your answer such sum as will, in your judgment, represent reasonable compensation for such pain and suffering as you are reasonably certain Grace Schara endured and suffered as a natural result of the from the negligence. Now, members, I believe that's where I'm finished until after closing arguments. Okay, so what we're going to do, just to put us on the same path, is I've told the attorneys, just based on the schedule that the jury likes, that we're going to take a break at 9:30, okay, which is an hour and a half from when we started. And we'll take that normal break so all of you can do what you've been doing the whole trial. I've also told them that when I'm done giving these instructions, I'm going to ask all just take the papers that I gave to you and either turn them over and put them on your lap or put them on the floor beneath you or on the ledge around you. I don't want those to be a distraction when they're making their closing arguments. And so instead of collecting them from you and then turning them back, you know, I just ask that you either set them down or, and if they want you to reference, they'll tell you to look at a certain page and, or if they have it pulled up on a screen, they might tell you to follow along if you want, but I'm going to let them do that without those papers interfering. I also had mentioned that the plaintiff gets to go first in their closing arguments and they get to go last. So you're going to hear the plaintiff and then you hear from each of the defense and then you're going to hear from, and whenever that's finished today is when you're going to begin your deliberations. Mr. Administrator. Yes.
Good morning. Can everyone hear me? It's been a long road to get to this point. So first I want to thank you. I'm sincerely grateful for the fact that you folks have come to us promptly, daily, and you've given us what I consider to be your rapt attention to the evidence that we presented in this courtroom. What's wrong with it? I think he's altered it in my absence. Maybe. Okay. As I said, you've been incredibly attentive. And as the judge said to you, and I know that he was sincere when he said This has been a real treat for him, and he is truly appreciative uh, as to the level of attention that you've shown. And we can tell that because this is what we do on a daily or weekly basis. Try these lawsuits, and you folks have asked pertinent and relevant questions, poignant questions that show us that you're paying attention. And we know that you've taken notes. We've watched as you wrote things down based upon this testimony, and we recognize that it's not easy in a case like this. If you remember when we first had an opportunity to talk to one another in the voir dire process, when we were doing jury selection, we talked about the fact that this was going to be this is among the kinds of lawsuits that you could potentially serve as a juror. This is probably among the most complicated, because we're asking you to apply what you've learned in this room regarding medicine and law. And those are two, as you can appreciate, very complex, among the most complex of things that we consider as a society. Judge, I want to thank you also personally on behalf of our team and the Schara family. When you mentioned that this was a treat for you, conducted yourself admirably to the highest levels expected of our profession. We have had several disagreements, many of which were done in your presence. Many were done outside of your presence, and all of those were resolved amicably by true professionals. And as the judge said, you're not to consider those things, only to consider the evidence. Since you were here last, we've worked diligently to resolve many of the technical legal issues, but as the judge indicated to you in the instructions of law, there are 4 claims that are remaining for you to decide. The medical battery claim has been removed from your consideration by the court. You're not to consider anything or make any kind of an inference regarding that claim. It is not for you to decide. As I said to you folks at the outset, we have the burden of proof. And we talked about this during the voir dire process also, and we talked about what that meant. And I know that a lot of people have heard about the burden of proof being beyond a reasonable doubt. And we distinguished that burden of proof because it applies only in a criminal case. The burden of proof that the judge today, that the law requires you to apply to the facts and the evidence in this case, is by a preponderance of the evidence, right? You may recall that I said to you at the very beginning, if you envision the scales of justice and you place one feather on those scales, if we were to place one feather, that is sufficient to prove this case by a preponderance. Literally, that's all it takes. We don't have to prove this case beyond a reasonable doubt. We don't have to prove it by clear and convincing evidence. One feather. I also told you during that voir dire process when we were going through jury selection that we already knew what the evidence was going to show. And as you've heard throughout this case, when we talked to the experts, for instance, from both sides, this case has gone on for over 2 years. And the discovery portion of it, meaning our ability to go out and uncover their opinions, has gone on for a number of years. And we knew what they were going to say. So I told you with confidence when we first began that we felt we could prove this case by a preponderance of the evidence. throughout that 2.5-year period, we have worked for years to bring you the evidence. We've conducted numerous depositions. We've crisscrossed this country from Santa Barbara to Baltimore and Florida, from a donkey ranch in Kanab, Utah, as you heard Dr. Goldberg say, and ultimately to Snellville, Georgia, in order to find out what these paid defense experts were going to try to convince you of. This case represents thousands of hours of work, and we appreciate your willingness to participate in the process and to take the opportunity to truly make an impactful decision. Grace died before she had a chance to live out her hopes and dreams, and this is her final say. We hope that the evidence that we have in this courtroom has helped you to sufficiently understand the medicine, as complex as it is. Your decision is designed to interpret whether the hospital and nurses and Dr. Shokar violated what we call the accepted standards of medical care, and that those violations contributed to the cause of Grace's death. You won't get that kind of guidance from the defendant's experts. The issue of credibility and what the judge described to you as the tests for credibility is crucial. So now, perhaps you understand, now that the judge has given you the instruction, understand why it was that we took great pains to talk about how much money these defense experts were charging. You know, Mr. Fleiter had an opportunity to cross-examine Dr. Garibaldi, and Dr. Garibaldi from Northwestern down in Chicago admitted that he charged $12,000 to be here that day. For a free box that can say that they can make $12,000 for the amount of time he spent in it. Now, admittedly, he's got a really nice resume. But you remember that John asked him, well, would you do it for $10,000? And he said no. So he was adamant that $10,000 was his price. They spent hundreds of thousands of dollars to find experts that were willing to come into this courtroom and try to convince you that all of the defendants were perfectly clean, that they were perfectly acting within acceptable standards of medical care. It's for you to judge what that credibility, whether or not they had that level of credibility, made that witness tell the truth. We know for a fact, we've known throughout this country for years, that simply because a witness raises their hand to the bailiff and says that they swear to tell the truth, the whole truth, and nothing but the truth, that's not necessarily the case. So you need to look at the tests for credibility. You need to look at whether the witness has an interest or a lack of interest in the result of this trial. And that test goes primarily to the defendants in this case, to the hospital, to Holly McGinnis. You saw Nurse Haynes come in and testify, and Nurse Barkholz, Nurse Fisher, and all of them are still employees of Ascension and that corporate entity. And as current employees of that company, you have to ask yourself whether they have interest or a bias that would perhaps color their testimony. You can also look, as the judge indicated to you, at the clearness or the lack of clearness of a witness's recollection. We had several instances in this courtroom over 2.5 weeks whereby people changed their testimony, whereby people were, it was pointed out, we had to take great pains to point out that in a deposition, a sworn testimony, deposition is a sworn testimony, it's not some street corner conversation or a bar stool discussion, it's sworn testimony. And so in that sworn testimony, they would say one thing and then come into this courtroom and say something completely opposite. When that happens, that goes to credibility. That witness has a lack of credibility, and it's up to you, the jury, to assess what to do about that. Do you disregard some or part or all of their testimony if they show that they have an inability to recall or that they change their testimony from one day to the next? And the court also told you that you can consider the reasonableness of a person's testimony. And that goes toward a lot of those medical experts and whether or not what they tried to tell you about complex medical issues was really in fact reasonable, or did they try to muddy up the waters? You would have to just throw your hands up and say, I just don't understand what this doctor is telling me, or this nurse. So it is up to you to determine what weight to give and whether or not to make an assessment as to their credibility of their witness testimony. So who was Grace? Grace was a sister, she was a daughter, she was an aunt, and she loved all three of those roles. You know, based upon the testimony, that she loved to dance. We showed a video of her at a dance recital. That she loved to fish, and she loved and was taught how to play violin. That she got a great deal of pleasure out of spending time with her dad. Even drove the truck. That she loved Elvis, and she was able to go to Graceland and visit Elvis' home. You also know that before that fateful day in October of 2021, she had never been alone. This is a crucial fact in terms of trying to decide what happened in this case. And we have hammered home throughout. We talked about it to people in voir dire about advocacy, about having an advocate and how important it was to have an advocate in a hospital setting. And this poor girl had never been alone. She always had an advocate. She had her dad by her side every day of her life, including when he ended up taking her into St. Elizabeth's in October of 21. She had the love of her sister caring for her throughout, and her mother. So, these are the facts. There's no dispute about most of these facts. Grace was admitted on October 7th through the emergency department at St. Eve's. She was admitted to the hospital as a precautionary measure because she was having difficulty with breathing. Grace was started on Precedex on admission on October 7th, and you've heard an awful lot about that drug. 10 p.m., they started the Precedex. 20 minutes later, Grace was already showing signs of being over-sedated. We had a great debate throughout the days in this courtroom about whether she was, quote, over-sedated or overdosed. defendant's own expert, Dr. Bruce Goldberger, came in and testified. He agreed it was in fact an overdose. He was a toxicologist. He's the only medical doctor that came into this court and sat at that witness stand and told you from his toxicology perspective that it was an overdose. Nurse Haynes testified that he had to quickly slow down that drug, and her oxygen and blood pressure were crashing. And all of this is in the medical record. You've seen excerpts from the medical record. You've seen the signs and symptoms, the medical notes that indicate that her oxygen was crashing. This was a life-threatening event. Some people in the medical team didn't even know about it because they didn't bother to look back. They were going through this process, changing over from a paper medical record to Meditech, an electronic record. Some witnesses said, well, we couldn't even look back, you know, I mean, it was difficult. We didn't have the ability to look back. Even a matter of a few days, you didn't know what happened to your patient. And this is in the ICU. This isn't like somebody that's just put on 4B, you know, on a medical floor. No nurse ever told Grace's family that she had been over-sedated from that precedent. No one. They never knew of it. This was a clear breach of the standard of. We brought Nurse Susie Eichinger into this courtroom, and she testified right there from that witness stand live, based upon her 37 years of nursing experience in ICUs all over the country, from Hawaii to Cape Canaveral, Florida. She reviewed all these medical records, and she looked at this nursing care, and in her expert opinion, she told you unequivocally that there were 13 itemized breaches of the standard of care for nursing. You can assess her credibility. Personally, it appeared that she was telling the truth. That's up to you to decide. Compare her testimony to that of Nurse Julie Davis, who came in from Snellville, Georgia, and admitted that after being licensed for 2.5 years, she became a nursing expert. And are you kidding me? She was a nurse for 2.5 years and decided to hold herself out as someone who could consult and give expert testimony about nursing. She didn't know anything. 2.5 years, she probably didn't know where the break room was. Unbelievably, the next day, on 10/8, the nurses turned Grace's Precedex back up, and as expected, she experienced a life-threatening overdose when her blood pressure dropped to critical levels. She required a central line. You've heard it called a PICC line. They placed a line directly into her heart in order to deliver the powerful resuscitation that she required. On October 8th, Grace almost died. And her dad, who was sitting in the room, was never told that her condition had reached such a dire level, and it was all as a result of the that they had given her. Not telling Grace's family that she almost died from an overdose on October 8th was a breach of the standard of care. That's one more of the many that tipped the scale. You're going to hear about the rest of them. 2 days later, well, first, In response to that overdose, the nurses turned off the Precedex completely later that day on October 8th. And after the Precedex was turned off, you saw testimony and saw aspects of the medical record which indicated that she was doing much better. Clearly, the Precedex had an impact on her ability to survive. 2 days later, on October 10th, her dad, Scott, was ejected from the hospital by Nurse Allison Barkholz. She came in here and testified that she was the supervisor. She made the decision based upon some complaints from her nurses that he was, quote, turning off alarms. And he testified about that. And he said he had asked the nurses how he could perhaps just turn down the volume or reset the alarm so that it was making such a noise and waking Grace up in the middle of the night every 15 minutes or however long they were going off. If you've ever spent any time in a hospital, you know it's the last place you can get any rest during the night. So, once he was ejected from the hospital by an armed guard and had received no warning, Grace was left without an advocate. You talked about what it's like to not have an advocate. It can be a critical decision. It can affect your ability to survive a hospitalization. You're a Down syndrome patient at age 19 who's never been away from her family, never been alone a single day in her life. The removal of an advocate without communicating any reason and the need to arrange for a replacement advocate was a clear breach of the standard of care. Now, the hospital wants to focus on Scott's behavior in order to distract from the fact that they totally failed to arrange for a replacement for him as an advocate. We call this tactic a red herring. You may have heard that term, red herring. It means a false topic. It means something to distract you. The shiny silver thing, look over here. It was a red herring. Had no bearing whatsoever on what happened in this, in terms of their medical care. This was a breach of the standard. The sheriffs were forced to hire an attorney so Grace would not be left alone with no one there to comfort her. Finally, the next day, you heard testimony that the hospital let Grace have some family. Jessica was in the ICU. She was allowed to stay until visiting hours were over, despite the fact that her father was ejected and she was there to replace him, despite the fact that she was an alternate on the power of attorney in the event that her mother and her father could not serve. We talked about that. They talked about, some people call it a POA. It was a power of attorney. Despite the fact that she had that status as an attorney and was serving as an advocate for a Down syndrome 19-year-old, she was told she had to leave when visiting hours were over. We introduced the hospital policy regarding visitors. What do they need a visitor policy for if their policy is no visitors because of COVID? On October 12th, Dr. Shokar came on board. He did make a care plan, and that included physical therapy and plan to get her up and out of bed. He said that he reviewed Grace's medical chart and knew about the prior overdose Precedex, but he simply kept the Precedex going even though he had the power to shut it off. This is a clear breach of accepted standards of care. You may recall Dr. Burdine testifying that this wasn't a theoretical overdose of a medication that might have an adverse impact on Grace. This was a known adverse impact. This was a proven adverse impact. 3 or 4 days prior, we have that in the medical record. All you had to do was look at it, make a determination that the use of that medication, especially in combination with lorazepam and then morphine, could be the fatal cocktail that caused her death. Clear breach of the standard of care. That same day, Nurse McGinnis came on board, and Grace was her only patient. You heard her testify when I cross-examined her, because Sam Haynes had come in and he testified, oh yeah, he knows Nurse McGinnis. They were on the same ICU floor. In fact, Nurse McGinnis is the one who was the preceptor for him. In other words, the mentor or the trainer when he first came on in the ICU at St. He testified that he was trained, and it's his practice as a nurse in the ICU to spend about 50% of his shift at the bedside. And Mr. Mendenhall cross-examined him, and he admitted that in a 12-hour shift, that would be about 6 hours of actual bedside care. And Nurse McGinnis testified later on. She sat here and heard his testimony, and she agreed with it. And she agreed that was her practice also, to spend about half of her time. In a 12-hour shift, that's 6 hours of bedside care. And becomes critical for you to keep that in mind when you look at actions and her failure to act on October 13th. On the evening of the 12th, Grace was doing good. She had a FaceTime call with her family, and her oxygen levels were at 98 and 99%. Undisputed fact. Evening of October 12th. On October 13th, Grace would be oversedated, overdosed for the third and final time. The day began at 7 a.m. when Holly McGinnis came on shift. The first thing that happened when she came on duty at 7 a.m., the very first thing she did was turned up the Precedex to a rate of 1. You've seen that chart. It will be in evidence. You've heard testimony about it repeatedly. And the purpose of that chart is to show you those vertical bars representing medications that were delivered to Grace throughout her last day, both Precedex, lorazepam, and ultimately morphine, and what times they were delivered. "30 minutes later, Nurse McGinnis turned up the Precedex to 1.1. This is the highest rate that Grace had ever received thus far. Rate of 1, you heard all sorts of testimony about titration and titration within limits, and these are all normal medications in the ICU. Well, they may be normal for other folks. They weren't normal for Grace Schara. That Precedex turned up to a rate of 1 at 7 a.m. on the 13th was higher than the rate that had killed her 5 days previous. So turned up to 1.1, then 24 minutes after that, turned up to 1.2. Around 8 a.m., Nurse McGinnis told Jessica that she needed to leave if she wanted to take a shower. Because it was COVID and these are negative pressure rooms. And you heard Mr. Francoe ask Nurse McGinnis about, well, why is that? Well, in their terminology, it was because if you took a shower in a patient's room, the shower would aerosolize the virus. So they made her go home in order to take a shower. She knew she anticipated that she was going to be there for a long time. So she left. While Jessica was gone, Nurse McGinnis put Grace into restraints. And then there was a dispute with her testimony, and she admitted that she was in error or she didn't remember whether it was restraints, whether it was mitts. She couldn't remember. At trial, she testified first that she didn't put her in restraints. I think we have a clip of the testimony for you. Dr. Schokar, who ordered the restraints? You or Dr. Schokar?
There were no restraints.
There are no restraints at all on the
Restraints,
12th or the 13th?
correct. We used those mitts, those little sack kind of things for her feeding tube for a period of time and then took them off. But those are not, in my place of employment, considered a restraint, again, because the requirement is that she has free movement of her limbs. And so that was not a restraint.
You've seen it before. Dr. Shokar's note. We've highlighted that portion. She required restraints. This goes to credibility. At 10:48 a.m., Nurse McGinnis turned up the Precedex once again to 1.4. You've heard testimony about that. It was the maximum allowable dose. Holly McGinnis totally failed to that Grace had already been overdosed on a much lower dose. This was the point in her testimony when she admitted she had not reviewed the record, and there was all sorts of dispute between the nursing staff as to what you do when you turn over a shift, what you do when you take over. You know, it only stands to reason that if you're going to come off of a shift, someone's going to come in and replace you, that you're going to tell them what happened prior. I mean, it's incomprehensible that you would fight over whether or not you know what happened. Despite the fact that Dr. Shokar knew that Grace had required resuscitation after a much lower dose, he continued to allow the Precedex at the maximum rate for the entire morning, afternoon, and evening until just before Grace died, when he ordered it turned off. This was a breach of the standard of care. And Dr. Bourdain described Dr. Shokar's decision to allow the continued use of Precedex on October 13th as, quote, insane, word he used. 8 minutes after turning up the Precedex to the maximum dose, Dr. Schara entered a DNR order. Holly McGinnis acknowledged the DNR order at 11:08. Despite only one patient and talking to Grace's sister Jessica about YouTube videos and music, she failed to tell her sister that there was a DNR order in place. 17 minutes after seeing the DNR order in the computer, Nurse McGinnis decided to give Grace lorazepam. We know that she was authorized to do that. It had been ordered by doctors. It's a known respiratory depressant. She admitted that she knew. At 11:34, Holly McGinnis inserted a nasal feeding tube, and she used a bridle, which caused Grace to bleed all over her face from her nostrils. Nurse McGinnis never bothered to even clean up the blood, and it remained on her face until she died. You heard Jessica testify that that's the way she found her. Remember, Nurse McGinnis had a single patient. There was no dispute that of nurse to patients in the ICU on October 12th and 13th at St. Elizabeth was 1-to-1. For 12 continuous hours, she had one patient she was responsible for. At 4 p.m., Nurse McGinnis charted that there were no further interventions available for Grace. That's a fancy way of saying dose of lorazepam. An hour and 46 minutes after charting that there was no further interventions available. The Precedex had now been at maximum dose for almost 7 hours. Remember the side effects from the package insert that we talked about? Hypoxia, hypotension, and acidosis. And it had only taken Grace 20 minutes to become overdosed on October 7th at a much lower dose. They should have known that. Some nurses did know that. This time, Grace was fighting for her life against metabolic acidosis. She was breathing incredibly fast in order to lower the acid levels in her blood. Dr. Schara failed to recognize metabolic acidosis.
I hate to interrupt you 2 minutes after we adjourn. All right, so just before the jurors leave, because I'm sort of a type A personality, I'm going to substitute that first page on your verdict form with, I've modified it and changed it. So what I want you to do when you get up and leave is you can leave your packet on your chairs with the verdict form on top. And I'm just gonna have my staff go through it and replace your page 1 so it's up to the current version, okay? And if you could leave those on your chair, I take it that you're gonna need like 20 minutes. Okay, so we'll take a 20-minute break and we'll get you back in here. Jurors are excused.
You guys go back, but I'll give you one of these.
All right, you may be seated. So I handed to each of you the updated page 1 of the verdict form. the final form that's in front of me, the only change was 1C was changed to 1D in that one spot. I'm gonna have Debbie just replace all the page ones. flight, or you're just getting up like attorney and minister?
Yeah.
Okay, so, what we're going to do,
Judge,
one
I
second.
would ask that when the jury returns, you'll indicate to them that the objection was overruled, that this is closing argument,
Sure.
standard admonition.
There's no objection.
I don't think that there was an objection. I made that mistake a couple weeks ago, but I'll let them know that I thought it was proper argument. We had a chance to talk about it, so you're gonna be able to pick up right where you left off.
Thank you, Judge.
Okay,
Okay, quarter till?
quarter two sound good? And then the people that are allowed back in, Kevin? Okay, we're adjourned. All right, everyone may be seated. Welcome back, members of the jury. If you have your packet in front of you, you can look at page 1 of the special verdict form. And on that first bold line that begins with answer, I replaced your page. So the line says answer questions number 1A through 1D. So the only change was that D. But you now have an updated, and that will be the same as the final special verdict that'll come into the jury room. The second thing I just wanted to mention before Mr. Administrator continues is we had a discussion. I made a decision that Attorney Administrator's arguments were proper, and so I'm just going to allow him to continue where he left off. Mr. Administrator.
Thank you, Judge. So, where we left off, instead of turning off the drugs that were killing Grace, Dr. Schokar ordered more. Dr. Holly McGinnis gave the lorazepam. Dr. Schokar ordered another dose, and he never got consent for this drug. This was also a breach of the standard of care. He claimed at trial that the first dose wasn't working enough, but he also admitted that it takes 10 to 30 minutes for lorazepam to reach peak effect. So he really had no idea how that first dose was working when he ordered the second. After 7 hours of maximum Precedex and 3 doses of lorazepam, Grace's blood pressure crashed through the floor. At 6:09 p.m., Nurse McGinnis charted that Grace's blood pressure was undetectable. At this point, Grace was breathing as fast as she possibly could. Her chest was heaving, and she fought against those drugs that were taking control of her respiratory status. Dr. Schokar claims that he looked at Grace's medical records and knew about Grace's prior overdose, but he somehow still failed to realize that Grace was being overdosed for a third time. Instead of turning off the Precedex and stopping lorazepam, Dr. Schokar did the worst possible thing. He gave her a drug that lowered her pressure further and stopped her from breathing. Stopped her from fighting the overdose, which slowed her breathing. At 6:15 p.m., Dr. Schokar directed Nurse McGinnis to administer morphine to a patient without a blood pressure. And he never got consent for this drug. It was a breach of the standard of care. And you heard Dr. Bedeen testify that this was the worst clinical decision he had seen in over 46 years of medical practice. The medical record states that the Precedex was left on at the max rate for 22 minutes after the morphine had been given. Dr. Schokar said that the medical record is wrong because it certainly doesn't make him look very good. He also says that the timing of the 2 lorazepam doses are wrong. And if the times are wrong, how can anyone know when to give the next dose? I'm sure that all of you who have children recognize that it's important to keep track of even how long a span is between a dose of Tylenol. By the way, remember when Dr. Schokar said he didn't know Jessica was the power of attorney? And one of you asked him about it. He said he did remember. These are the types of factors that go toward an examination of the credibility of the witness. Shortly after the morphine, Grace's sister knew that something was wrong. She felt that Grace's skin was cold. And we know now it's because she had no blood pressure and no circulation. Jessica went out into the hallway and asked Nurse McGinnis for help. Once again, this is on the 13th, the last day. Despite the fact that Nurse McGinnis had a single patient, didn't bother going into the room. Instead, she told Jessica to get a blanket and told her to go in there herself and cover her up. Jessica was obviously concerned, and she saw that Grace's numbers had started to crash. She called her parents on a FaceTime call, and her parents told her to get the nurses. She responded that the nurses wouldn't come in. Grace's parents are screaming through the FaceTime, "Please save our daughter." No nurses respond, and the nurses in the hallway that did talk or did respond to Jessica and her plea for help indicated for the first time that Grace was DNR. The entire family was screaming at the nursing staff that she is not DNR and please save our daughter. The nurses said there was nothing they could do, even though reversal drugs can be used. Even if there is a DNR, we now know that. Dr. Berdeen testified about what should have been done.
At the time the DNR was revoked there on the 13th, was treatment futile at that point?
No,
Okay, Grace could have been saved.
yes,
Okay, and even given the overdose that you've talked about in this case on the 13th, what was Grace's chance of survival if treatment would have been given based on your experience of drug overdose?
well, at this time, because you're dealing in part with a narcotic or opioid or overdose, reversal with naloxone, brand name Narcan, it can appear magical. I have seen people brought in who had no heartbeat for 20 minutes and were getting manual CPR.
Relevance. Overruled. Go ahead.
And we're getting manual CPR en route to the hospital. And after an amp of Narcan, in 10 seconds, they sat up out of the bed, went from lying flat, completely unconscious and unresponsive, to sitting up, talking.
Doctor, you just talked about Narcan, the morphine reversal drug. What other treatments should have been given at this time?
There is a reversal drug for benzodiazepines. Its slang name is Reversed, because Versed is a benzodiazepine, so Reversed. I can't pronounce the generic name, but that was available. Unfortunately, there's no reversal agent for Precedex, but Precedex could have been stopped, and that would have been the first step. And since Grace was suffering from metabolic acidosis, the administration of bicarbonate could have been done. And since Grace was hypotensive, the same measures that were taken on the 8th with norepinephrine and dopamine could have been done.
Further, at this time, regardless of whether the DNR was valid or not, the DNR was absolutely revoked. Nurses did nothing. No one came in the room. The total failure of nursing to respond to the family's pleas to save Grace was a breach of the standard of care. This is the first time the family had ever heard that Grace was a DNR. The family had no way of knowing that the DNR was on the record because they didn't access the record until Grace was dead. Play a clip from Nurse Julie Davis, the defendant's nursing expert. Well, you reviewed the medical record, but was the family given access to the medical record in your experience?
No one's ever given access to a medical record when a patient is in the hospital because it's active. You're still continuing to add to the medical record. So no one will ever get access to it until a patient is concluded with care.
Or dead?
Concluded with care, yes.
Concluded with care or death. Dr. Shokar totally failed to properly inform the family that Grace was a DNR. This was, in fact, a catastrophic breach of the standard of care. There should never be any confusion about whether a 19-year-old girl is a DNR or not. There's never any excuse for confusion on that issue. To make matters worse, Holly McGinnis testified that she might have forgot to put the purple DNR wristband on Grace. Then the next time she testified, she said the wristband policy wasn't in effect when Grace was in the hospital. I want you to listen to these clips and decide for yourself whether it sounds like Nurse McGinnis didn't remember the first time she testified.
And I know they're gonna add, what does a paper chart mean?
Okay, so now we do everything on the computer, but we used to have like a book outside the patient room and a shelf that would have this information that you're asking about on. That's the paper chart, maybe similar to a clinic if you've ever been to and they walk into the room with something.
Okay, so just, let me just make sure. So go back to the original question that the juror asked. The DNR order then would be outside of the door in a book?
Correct.
Okay, and then it would also be on the computer and it would also be potentially on a
On her wrist, yep.
Okay, and in Grace's situation, was it in the book outside of the room?
Yes.
Okay. Any other questions from the juror based on that? Okay, Mr. Administrator, back to you.
If she were a DNR, it would not only be in the chart, but she would have a wristband. Correct?
We usually try to indicate that, yes.
But if she didn't have a wristband that said she was a DNR, that would have been simple. The explanation for that would be simply that you forgot to put it on. Is that what you just said?
If she didn't have one on, it would be because I had not put it on. It's similar to what's printed out for an admission wristband.
It's not a metal bracelet, is it?
No, it is not. It's a plastic bracelet.
Thank you.
Any follow-up on that?
What color is the wristband?
Purple.
And is that confused with the admission wristband? What color is that?
That one's white. It is not confused.
Thank you.
Grace died 1 hour and 12 minutes after Holly McGinnis gave her morphine. You can hear how her voice is quavering in that clip. Despite the fact that Grace was about to die, Holly McGinnis left the ICU promptly at 7. Even the break room where she was changing, as according to her testimony, was the distance from that witness stand to the door of the courtroom. And she admitted that she had clocked out at 7:36. You may recall that I asked her to identify her time card. And she testified that she could identify that, and it showed that she clocked out at 7:36. Dr. Shokar left the ICU even before that. The defendants are going to come up here after me, and they're going to tell you a very different story. They're going to try to convince you that Grace wasn't overdosed on October 13th, like she was on October 7th and 8th. And they've hired experts from all over the country and paid them over $100,000 to tell you everything went Dr. Mary Beach came in. She's an ethicist physician, Johns Hopkins. She admitted that the October 8th overdose was in fact a life-threatening event. Nurse Julie Davis, a professional witness, she started making money as a witness within 2.5 years of becoming a nurse, and she said everything was perfect, despite the fact that Dr. Berdine and Dr. Shokar's ethicist agreed that Grace could have died from an overdose on October 8th. She started off by telling you that everything that Nurse Susie Eichinger said under oath from that witness stand, detailing 13 separate breaches of the standards of nursing care, she didn't agree with a single one. Dr. Garibaldi came in and he testified on behalf of Dr. Shokar. He testified that he formed his opinion relying on an arterial blood gas test that actually didn't exist. When he first gave his opinion in this case, he said that this blood gas was definitely proved that Dr. Berdine was wrong. Then when he testified in court, he said that it didn't matter that he was wrong, and no one really looks at those numbers anyway. The blood gas test was the absolute best way to test for the metabolic acidosis that ultimately killed Grace. Dr. Bruce Goldberger came in. He testified from his ranch in Utah, and he offered no opinions about what the standard of care was in this case, but he did admit that Grace was overdosed on Precedex. Dr. Binstock came in on behalf of the defendants. He was a radiologist, and he testified, agreeing that the films that he reviewed, chest x-ray films, were subjective. He testified under oath that the x-ray on the day Grace died showed that she was getting worse. Dr. Berdine disagreed, testified that he read thousands of x-rays on a daily basis in his practice in the ICU at Texas Tech. You'll recall that Dr. Berdine is a professor of medicine, and he teaches students that are learning to be ICU critical care physicians. Even the hospital radiologist and Dr. Shokar's expert disagreed with Dr. Binstock. Compare these experts with Dr. Berdine and Nurse Susie Eichinger. Dr. Berdine wasn't making $1 on this case. He testified that he had never reviewed a case for a plaintiff before, that he had done, I don't know what he said, 100 reviews or more than 100 some reviews, medical negligence cases, always for the defendant. Always. This is the first case he ever came and testified about on behalf of a plaintiff. Let's play Dr. Berdine's clip.
So you're here serving as an expert, but you're not making a single dollar off this case, is that right?
That is correct.
Please tell the jury why you agreed to do that.
This case, so as a background, since I came to Texas Tech University Health Sciences Center 16 years ago, all of the malpractice cases that I have testified in prior to this one were for defendants. I was defending physicians against malpractice claim. This is the first one where I've testified on behalf of a plaintiff. The reasons are because the breaches of the standard of care were egregious, and I could not live with myself without answering the call to review and give advice on this case. So during my testimony, we have gone through a number of things that I've identified as breaches of the standard of care. My reports are very long. The number of the breaches of standard of care I identify in my reports are too numerous to count, but some of them stand out. One was the manner by which the father, Schara, was evicted from the hospital and its impact on the outcome in Grace Schara. And I found this to be shameful conduct on behalf of the hospital. The second issue were the breaches of standard of care related to informed consent. And I find it indefensible that this patient was given medications, very dangerous medications, not theoretically dangerous medications, but medications proved by the medical record to be dangerous to this patient without informed consent. The events on the 13th are very difficult to recognize. The repeated administration of Precedex on the 13th was not just a breach of the standard of care, it was insane. The administration, excuse me, the administration of morphine on 10/13 to a patient who was unconscious, unresponsive, had lost her blood pressure, had no palpable pulse, and whose respiratory pattern was screaming to anybody who would look, metabolic acidosis. The administration of morphine in that situation is, or was, the worst clinical decision I have ever witnessed in over 46 years of medical practice.
Let that sink in. Ladies and gentlemen, mistakes do happen. But when we make a mistake, we need to own that mistake. Instead of owning their mistake, these defendants have spent 3 weeks now denying the obvious. Grace was overdosed on October 7th and October 8th using the same drug that they gave Grace on the day that she died. Except on the day that she died, she was receiving 40% more, plus lorazepam and morphine, which actually do increase the power of that Precedex. People got COVID and people died of COVID. That doesn't mean that everyone who had COVID dies. In fact, it doesn't mean that it was impossible to overdose someone just because they were being treated for COVID. Dr. Berdeen testified that only 1.4% of the people who had COVID died throughout this country. The defendants have tried to tell you that it was impossible to overdose Grace because she was receiving Precedex at a normal rate. How many times did we hear defendants, experts, nurses testify? Great. We use these drugs in the ICU all the time. This was a titratable medication. We were titrating this drug within the parameters that were prescribed, and we use it all the time. Defendants had cold, hard evidence in the record that they were giving Grace too much medication. And just like at this trial, they just kept saying, COVID, COVID, COVID. She had COVID. She died from COVID. There was nothing we could do. Whether or not the defendants have to own their mistakes is now up to you. I'll have a moment where, several moments, where I'll be able to listen to the defendants explain their side of the story. And then I'll have another opportunity, because we have the burden of proof, to come before you and give additional closing argument. Thank you for listening.
Attorney Frankowiak?
A couple of years. Money COVID-19. Johnson. Schara may not fully believe in not. Grace Schara died as a result. Like your death certificate. COVID-19 cannot be placed. Make no mistake. That was the problem. Once you reach the inescapable conclusion, COVID-19 has fixed. The hospital and its nursing staff in this case, it's been my privilege to present the case to you on behalf of the hospital and the nursing staff that performed heroic during this lengthy period. Certainly, Grace's case as well. I want to start off by clarifying things first. There are a couple of things that are not at issue with respect to the hospital system. For example, questions of informed consent for medical procedures, medical administration, or the entry of the DNR. You've heard some terms like informed consent come up before. St. Elizabeth Hospital and its nursing staff had no duty to obtain informed consent in October 2021 of a patient or patient family for medical procedure, administration of medication, transfer to DNR order. That's been testified by the you also won't be asked to answer stated that Jessica, while she was at Grace's bedside, was able to maintain contact with him through the use of telephones, FaceTime, iPads. And this, of course, was consistent with standard practice that the experts in all hospitals was COVID. And people could not just gain entrance to the hospital as they had prior to COVID. Testified as to some of his closely held beliefs as relates to COVID. He noted, for example, his belief that the COVID-19 virus had never been isolated, would not concede that either he or wife or Grace actually suffers from COVID. It was in fact a pandemic, the deliberate result of a government agenda aimed at hastening death. In fact, testified his belief that St. Elizabeth Hospital, in providing care to Grace, was somehow operating as the arm of a larger group or a conspiracy aimed at ending the life of St. Elizabeth. Testified to his belief that the COVID vaccine is a bioweapon. He testified to his general distrust of medicine and of doctors in general. And he denied repeatedly on the stand that Grace was ever really sick at all in October of 2021. Now, he was a little bit more forthcoming in that letter that we talked about, that was written about 2 weeks after Grace passed. He noted in that letter we talked about, based upon his review of the position, that it appeared to him within 2 weeks of Grace's death, reviewing those notes, that Grace was in fact losing the battle with COVID while she was hospitalized. Later in this courtroom, we're still making the case. Schara still making the case that Grace wasn't sick at all. You didn't hear from Jessica. Jessica was there at the time, the last several days with Grace in the hospital. She was not the POA at the time. She was, but we saw the POA back then. Not the POA. We looked a little bit at the wording of the POA, and actually there are individuals listed on the POA. But Cindy Schara was designated as the singular POA, and only if those agents or that agent is unwilling or unable to serve, is removed or is not available, only then are the people listed under the order. They become the. Well, there's been testimony that, of course, both Cindy and Scott were willing and able to serve. They've never been removed, and they were available at all times by iPad, by phone, and in fact, that's how communication was done. We know that. Dr. Schulter was able to talk to Scott over phone and over the iPad. So the decision maker was in fact Cindy, and when she deferred to Scott, the decision maker was Scott. But Scott Schara and Cindy Schara were always the decision makers, and Jessica never became the decision maker because they're not all, everyone on this document is not the decision maker in the order in which they're listed. And as long as decision maker 1 and 2 can serve, they're the decision maker. We want to clear that up. When we talk about POAs, we don't want to talk about that because the decision makers here were Mr. and Mrs. Schara. Certainly Jessica was her sister and was in the hospital with her and was with Grace, but she was not the designated decision maker. The people who were being talked to, the people who were giving informed consent, those were Grace's. Now, Jessica did concede that during the 3 days she was with Grace, she was in the hospital. She observed doctors, nurses, other medical personnel coming in and out of the room many times. She conceded that she did in fact wear PPE while she was in Grace's room at the request of the hospital. She had testified this was one of the things the hospital had requested of her in order for her to come into the room. In fact, that was one of the issues and why the hospital wanted to negotiate, talk to Mr. Schara as representative before Grace or before Jessica was allowed into the hospital, because Mr. Schara had just contracted a very severe case of COVID while being in that. It was important that the hospital understand and everyone involved understand what the dangers were of being in that. and not uncoincidentally, it doesn't appear that she was at the effect. There's a cause and effect there. She was very PPE. Ms. Vanderhayden conceded that while she was present in the hospital, she personally observed the nursing staff, for example, feeding Grace on a number of occasions. This could sometimes be a difficult process because she was so dependent on the BiPAP that was the testimony. The BiPAP mask would be removed slightly, and some feeding would have to be done with a protein shake or something of that nature, and the mask would have to be put in place immediately back on because she had difficulty breathing on her own. She would immediately desaturated. She was so dependent on that BiPAP that she couldn't just sit down with a tray of food in front of her and just eat. This was a problem. There was always an aspiration risk because when we have this forced air BiPAP device, you can't just eat with that on there. It can blow the food particles down the long tube essentially into your esophagus and your airway, and that is very problematic. Nonetheless, feeding was being attempted. We're doing that, and she observed that first of all. She conceded Grace was BiPAP dependent the entire time she was with Grace. We talked about the BiPAP. That's the mechanical breathing apparatus that was upon which Grace was entirely dependent throughout the hospital stay. Needs that Holly, when Holly was in the 12th and the 13th, talked to her and explained that the oxygen monitors were showing that Grace was in fact taking an abnormally large number of breaths. She conceded that she observed Holly helping Grace to eat, providing various nursing cares throughout her 2 days. She concedes that she was never prevented from asking any questions of the nursing staff while present. She concedes that whenever she had questions of the nursing staff, and that would be Holly, since Holly was in the room, the nurses would always attempt to answer those questions for her. She conceded the nurses explained to her what all of the machines were doing in Grace's room. This was even on the 11th. She even recalled seeing a machine at Grace's bedside that was labeled Precedex. She testified that the nurses explained to her that Precedex was an anxiety medication. She concedes that she was able to stay in contact with her father by telephone at all times while she was in prison. She concedes that no one prevented her from contacting her parents whenever she needed question, whenever her parents had a question. She was fully able to get a hold of them and they were able to get a hold of her. And she also admits that it was her understanding at all times that while Grace was in the hospital, her parents did not want Grace ventilated. She concedes that even at the point where Grace was arresting on the evening of October 13th, she understood that no resuscitative efforts were consented by her parents that would involve intubation or mechanical ventilation. Finally, remember that letter that she wrote at the time about when Grace was in the hospital, written, she said, about 2 weeks after Grace. What did we learn from that letter? Well, she did write in that letter that she chose to stay overnight with Grace on the evening of October 12th to the 13th because her parents had informed her on the 12th that the doctors were not giving them much hope. The doctors had told her parents as of the 12th that Grace's lungs were showing more scar tissue, not able to maintain her oxygen. The doctors had told her parents by the 12th that Grace could really go downhill fast. She could not keep up with good oxygenation levels. She was also in the room when Dr. Schara and Holly were at Grace's bedside and when the Precedex was shut off at the bedside. She said in that letter she witnessed this. She saw when that medication was on the bedside. Holly and Dr. Schara also testified to that as well. But the third person in the room was Jessica. There's another direct quotation of note from Ms. Vanderhayden's letter, and that concerns specifically the time when Grace was coding at the time. And if you recall what that quote was, she mentioned, and I quote, Grace was gone within minutes, actually seconds. Why is this important? Well, it tells us that Grace's code went fast. She was gone in seconds. Records back it up. Could we put up exhibit 444? told us about why some of the things that we're seeing here are not consistent with an overdose. But it also tells us how Grace was doing in the minutes prior to her ultimate passing. The more the death certificate. We also see there the rest. Normal for us breathing here today, for me breathing here today, it's about 12 to 20. She was at 45 minutes after administration of the morphine, she was breathing at roughly 36, and then she's above normal all the way until about 1920, and then we get to 2 minutes before her ultimate passing, and she's at 14. That's a normal rate of breath for you and I, as we sit here today. 2 minutes before she passed. There's been testimony that she didn't have a blood pressure. They're giving medication for someone who doesn't have a blood pressure. That's not true. We'll talk about that. She had a heart rate. She had a normal heart rate. She was breathing faster than normal the entire time that we're talking here. We don't see an appreciable drop in these numbers, and she's still at a respiratory rate that's normal, essentially, for you and I sitting on blue air. 2 minutes before she passed. That event went fast. We're not talking about a lengthy period of time. It was a matter of minutes, actually seconds. What do you think? Now, we heard from some experts. We heard from Dr. Burdine. Dr. Burdine told us a number of things. He was initially contacted to serve as an expert for the Scharas because he was part of an email or a text group, however he described it. It was called C21X, and he described it as a group of people who were disagreed with the official narrative on matters related to COVID. It was a group of people who maybe included individuals who disagreed with the official position taken on maybe vaccines or on the official narrative of the vaccines or on hospital protocol. The COVID pandemic, there were patients who, despite receiving treatment that complied with the standard of care, did in fact still pass away. Conceded that the COVID virus created a great deal of illness and indeed did cause. He testified to the mechanism of how COVID pneumonia affects the lungs, how it causes acute respiratory distress syndrome, or ARDS, ARDS. He testified that the hospital in which he worked in 2021 at Texas Tech University routinely utilized ventilators in the treatment of COVID patients. He testified that ventilators did indeed play a role in the throughout the nation in 2020 and 2021. He even told us about alarms in the night. Alarms that help the healthcare provider, specifically with stay on top of a patient so that they don't miss any important information, change information. Also told us that as a private hospital, St. Elizabeth Hospital did have the right to determine through policy who was permitted upon the premises and who was not. He conceded that CDC guidance in 2021 required that persons who were would stay home and not go to the hospital until return criteria were met. He testified that personally own hospital who did not have visitors present in the room with them. He conceded that in caring for COVID patients at his own hospital, it was frequently necessary for him to communicate with family members remotely, similar to some of the times that we were talking about here. He concedes that in such situations, he believes he was able to adequately and accurately communicate with the family members using these even though they were not present. Testified that he believes he was able to adequately and appropriately communicate to family members and patients via telemed. And he concedes that according to the records of this case, there was indeed a process set up in the hospital between Mr. Schara and the hospital on October 10th before he left the hospital, for the nursing staff and doctors to be able to communicate with him and with his wife, the decision makers, via iPad and FaceTime. He concedes that there was no point in time where Jessica did not in fact have open and free access to communication with both her mother and her father via FaceTime or iPad messaging. I want you to think hard about the next couple of points brought up, because I think they're very telling. I think they're important for us. Dr. Verdine also concedes that as a consulting pulmonologist, he did not use precedents. He said during the course of his own practice as a pulmonologist, he had never had an informed consent conversation with a patient or a patient family member. He concedes that he has never prescribed the medication. He concedes that he has never titrated or administered the medication precedent. He's the only one in this case telling us that Grace overdosed on precedent, and he has never, in years of practice, administered that medication. I'd like you to let that marinate. It's important when you come back. Vital signs. Now, what did Dr. Verdine tell us about vital signs? He concedes that a patient's inability to maintain an oxygen saturation above 90% is significant to him as a pulmonologist. He testified that as a pulmonologist, a respiratory rate of 30 breaths per minute or higher would be of concern to him, because that's a respiratory rate that shows severe hypoxemia. He testified he would have concerns that there would be an emergency condition if the patient's respiratory rate were above 50, because that would be a severe hypoxemia. He testified that he would have concern as a pulmonologist with any patient exhibiting a respiratory rate above 50 in combination with an SpO2 or an oxygenation rate below 60. Dr. Verdine, however, seemed oddly ignorant in his trial testimony that these concerning vital signs that he discussed with me actually described Grace's condition exactly on October 13, 2021, as COVID ravaged her lungs and eventually life. Susan Eichinger, you heard from her. She's an expert in the plaintiff as well. She's one of two experts. Nurse Eichinger noted, for example, her experience as an ICU nurse treating COVID patients limited 3 months that she spent working at COVID at her Cape Canaveral Hospital between August and October of 2021. Recall also that Nurse Eichinger told us that she quit that position a week or so after she concluded her 2-month stretch in that COVID ICU. Due to the stress toll taken on her in that COVID ICU for those 2 months. By October of 2021, Nurse Holly McGinnis had been caring continuously for COVID-19 patients for 19 consecutive months. The pandemic began in March of 2020, and the care of Grace occurred in October of 2021. Nurse Eichinger concedes that based upon her review of the records in this case, Grace Schara was indeed ill while she was in the hospital at St. Elizabeth. She concedes that visitation restriction policies were global in hospital countries. She concedes that while she herself was treating patients in the COVID at her hospital in October of 2021, she routinely communicated by telephone with the ICU. She concedes that whether a patient had an activated POA or not, the only way for her to speak to family members or POAs if necessary was to talk by a phone. She feels she was able to comply with the nursing standard of care at all times when she was operating under the use. She conceded that most of the patients for whom she cared in the COVID ICU unit in her own hospital were actually intubated, somewhere on the order of 95 or so. Indeed, were intubated. She concedes that Precedex was used on the COVID ICU unit at that National Hospital in order to treat both restlessness and agitation at the October. She also concedes, and this is relevant, that in her entire career as a nurse, she had never, on even one occasion, titrated the medication Precedex for a patient. She concedes that she cannot say that Mr. Schara was turning off only unnecessary alarms prior to being asked to leave the hospital up to 45 minutes. She agrees fully, as a nurse in an ICU should, that alarms are important to ICU nurses, being able to assess patients, know when there's a change in condition. She concedes that she could point to no evidence in the record that Grace's sleep was ever affected by any alarm while she was in the ICU. And she concedes that there's no evidence that Scott Schara's absence from Grace's hospital room after October 10th precluded the nursing staff from effectively proning Grace when they needed to do so. Testified there's no evidence in the record to suggest that Jessica was in fact inhibited in any way from freely contacting parents via remote means while she was in the hospital. And she concedes that there was nothing in the record to support a contention that Jessica did not in fact have the ability to ask whatever questions she had and to be able to contact and speak with Grace's providers and her parents while she was in the hospital. Now, we also heard from a number of nurses who worked at the hospital. The first of those was Nurse Emily Fisher. You may recall Nurse Fisher. She personally observed Mr. Schara interfering with some pump alarms in Grace's room. She noted in her nursing note of October 10th that Scott Schara had in fact demanded of her that she turn off all monitors and all IV alarms completely in Grace's room. She testified that Mr. Schara had demanded that Grace's SpO2 or oxygenation device. She testified how dangerous that would be. In fact, we heard that testimony from the nursing expert, Nurse Davis, as well. How dangerous it is to acquiesce. Turn it all off. Turn it all off. No expert told us that it would be appropriate to just turn off all of the ICU. ICU patients are sick. Those alarms are there for a reason. Every person who's been asked about alarms in an ICU, every expert has testified, they're there for a reason. You can't just turn it off. She could not comply with that. And her notes indicate that she attempted to explain that. She explained it several times. She attempted to. Now, she also testified that she personally observed that Mr. Schara was visibly ill then. Something that becomes have a conversation with Nurse Bartholtz, and she was one of several people who actually visibly were able to tell that Mr. Schara was suffering from a viral illness that morning. One interesting point, Emily, you'll recall, gained some brief renown in this case when she elicited the shortest cross-examination of the trial. The cross-examination consisted essentially of plaintiff's counsel attorney Mendenhall posing a single question to her, angrily. What did anything you just testified to here have to do with racism? What did anything you just testified to here have to do with racism? That was the extent of the cross-examination of this witness. And I can tell you, Emily was called to testify about what she did talk about, the background facts underlying Mr. Schara. For once, I completely agree with Mr. Mendenhall. What exactly did Mr. Schara's removal from the hospital in October 10th of 2021 have to do with racist death? Nothing. In that cross-examination question, the shortest one of the trial, Mr. Mendenhall inadvertently said the quiet part out loud. What did the removal of Mr. Schara from the hospital do? How did it contribute in any way to racism? We heard from Allison Bartholtz, who's the charge nurse, who heard that she was the one who actually asked Mr. Schara to meet that morning. She testified, she had a calm conversation interaction with him that lasted somewhere between 4 and 5 minutes that morning. She asked him to leave the hospital specifically because he was exhibiting severe symptoms of COVID that she described: cough, weakness, inability to speak in complete sentences because needing to stop and catch his breath as he talked. She recognized these were all symptoms of a severe COVID infection. She was worried that Mr. Schara would decompensate completely right there in the room, and then she'd have 2 severely ill COVID patients in the ward instead of just 1 in a full ICU. He testified she also asked him to leave because he had been interfering with some of the alarms braces, including pump alarms and oxygen monitors. She testified that silencing an oxygen monitor in Grace's room would silence that monitor for up to 5 minutes, not only in Grace's room, but also at the nursing station. And this would be completely unknown to Grace's therapist. But one of the reasons Grace was in the hospital to begin with was to have her oxygen monitor supplement. Silencing the alarms of an oxygen monitor in Grace's case could have been dead. She testified she was concerned for Scott Schara's safety, as well as the safety of Grace when she asked him to do that. She testified, in fact, that she didn't make the decision on her own either. She, in fact, consulted the hospital administrator that was there at the time on that Sunday, and then she consulted her own nurse manager before she approached Mr. Schara and asked him to leave. She also testified she followed hospital policy in conversing with him and asked him to leave that day. She testified that she did explain the visitation policy to Mr. Schara, and she also confirmed that she bore no ill will toward Mr. Schara and that he left the hospital that morning without confrontation. Testified that she did indeed offer virtual visitation to the Scharas, and in fact she voted in the note. Saw that when she testified. And Mr. Schara left the hospital on the 10th. There was a visitation plan that was set up. In fact, we saw later on that Mr. Schara and his wife had multiple conversations remotely with, I believe the nurse was Catherine Hale. She was the nurse who was taking over Grace's care on the morning of the 10th. Sam Haynes, we've heard his name several times. In fact, we saw his face several times because he was called in the defense case, and he was called back during the defense case. He was the ICU nurse who actually commenced the precedent titration on the 7th. That was when Grace was having this period of great agitation where Sam noted that she was thrashing around in bed for hours. This was also the time when Mr. Schara admitted that in order to help get on top of that, he authorized the use of the precedent for the first time. That's when Dr. Murata put that order in for the precedent. Now, Sam Haynes testified that he began the titration at 1.0 micrograms per kilogram, as was required by the order of the ordering physician, Dr. Murata, before he then turned the titration down back to about 0.7 micrograms about 20 minutes later. He testified that the reduction of that initial titration rate down to 0.7 was not at all unexpected. It didn't constitute an overdose at all. This was a man who's done this before. And it's important to realize that when he did that, it was at the beginning of the titration. Doctor put titration parameters in, you could titrate between 0.1 and 1.5, start at 1.0. Doctor's order is to start at 1.0. We need a starting point. We have to start somewhere. Started at 1.0. That's where his nursing, clinician skills get in. His job as the nurse is to implement the doctor's orders and then to see what needs to be done in order to titrate that medication for clinical appropriateness according to what he's seen. He had a RASS scale, R-A-S-S, we heard about that. He had a target under Dr. Murata's of -1. Saw that RASS scale, but it explained what a RASS scale was. So he was aiming for a certain level, and then he was observing what would happen at that level. Well, at a level of 1.0, he noted that the sedation was a little bit more than what he wanted on the -1. He said -1 on that scale. We could put up 442. Now we saw this before. This is the RAS score. And this tells us what each of those scores means from +4 to -5. We'll recall that on the Precedex administration record, at the time that Nurse Haynes changed the prescription or changed the titration from 1.0 to 0.7, he made a note that he was seeing a RAS score of -3. When we look at that, what is -3? It's moderate sedation. Movement or eye opening, voice, no eye contact. Moderate sedation. Dr. Burdine, who knows nothing about Precedex, that he didn't read off of the package insert, called this, as I recall, a catastrophe. A RAS score of -3 put her into a category of moderate sedation. But to Dr. Burdine, that was a catastrophe. Now, Nurse Haynes testified that certain common medications, including atropine and norepinephrine, are commonly used in the ICU in order to manage and mediate a patient's blood pressure for any number of reasons. He testified that nothing which occurred on either October 7th or October 8th was indicative of an overdose of Precedex as they use it in the ICU. Nor did anything that occurred on either of those 2 days constitute a life-threatening or even unusual event. The side effects of Precedex were known and were routinely monitored. Precedex is given because it is a needed medication. It stays on top of the agitation. The key metric here is getting enough oxygen for that patient to maintain the life and get better. In order to do that, sometimes they need prone, sometimes they need to wear a BiPAP mask, sometimes they will not survive without these modalities. Getting that oxygen is the #1 issue. We need to keep these patients oxygenated. We need these sedative or anti-anxiety in order to help us do that. We need to give these medications. All medications have side effects. We've seen that. We've seen the package insert ad nauseum about the side effects. Side effects were recognized. They were known. They are given, these medications are given in the ICU so that the patient can be assessed and constant watch made over. That's exactly what happened here. The known side effect occurred, it was immediately addressed, and nothing else happened. It was not an unusual event. There was, in fact, nothing that needed to be or was required to be communicated because this was standard general ICU care in the management of these medications. If the plaintiffs had called any who had any experience actually titrating this medication, using this medication, they would know that. Heard the testimony from the people who have actually been doing it. Sam Hayes actually did it. McGinnis actually does it. She uses it. Titrates it. She knows the RAS score. She knows what she's doing. She told me. We heard from Nicholas Sylvia. Recall Nicholas Sylvia. He was the director of pharmacy for St. Vincent Hospital. Now, he told us that Precedex, lorazepam, and morphine, the medications, were actually frequently used in the ICU at the hospital and frequently used in combination. He explained how medication orders were captured in the medical record in Meditex in 2020. He explained Meditex, he called it a decision support function, and it automatically checked potential drug interactions from any medications that were ordered. He testified further to the role of an additional pharmacist who was assigned specifically to review medication profiles in the ICU at St. Vincent Hospital as an added check against potential adverse drug interactions. He testified that the Precedex order for Grace in this case would not have tripped any red flags with his pharmacist. He testified that the standing order for lorazepam at 0.5 milligrams would not have tripped any red flags with his pharmacist. He testified that Dr. Shokar's verbal order for morphine on October 13th of 2021, a 2 milligram dose, would not have tripped any red flags for his pharmacist. Holly McGinnis has been with us throughout the course of this trial. She testified on several occasions. Testified extensively, in fact, just a couple of days ago. She explained the care that she rendered to Grace and the amount of time she spent with Grace. She's been an ICU nurse for nearly 20 years. And if we're talking about someone who knows Precedex and has administered it to patients, to hundreds of patients, She's the one. She's the one person we've heard the entire trial who would know precedent. She confirmed that Precedex, lorazepam, and morphine were common medications frequently used singly and in combination in the ICU. Something that any clinician who actually took care of patients and actually monitored patients in the ICU. She testified that medications like atropine, norepinephrine were frequently in common use in the ICU in October of 2021 to help the nursing staff manage patient blood pressure for any number of conditions. ICU patients are sick. They frequently must have their blood pressure monitored and managed. She explained that there was no adverse event involving Precedex in Grace's case on October 7th or October 8th, as Grace's blood pressure was being assessed and managed in a routine and effective manner at all times with the medication she was being given. She also took us through in painstaking detail each of her narrative nursing and the vital signs that she was recording while she was bedside with Grace on the 13th. We looked at those and we had a little discussion of those exhibits. In fact, we put them on these demonstrative exhibits, right? Like remember this chart that we have that showed Grace Schara's vital signs on that last day from about midnight until about 6:37 when she was there. And we can see here, because it also has all of the times when the Precedex and the other medications were given, we could see what the key vital signs are here, the pulse, the respiration rates, and the SpO2. She took us through each of these things, and we talked about those. And if you recall, we saw even when all of these things were being done, and we do see the Precedex was titrated several times. And why was that? Well, she explained to us because in the morning when she came on, she was attempting to prone Grace. Grace's oxygenation was very low. Proning was one way to get that oxygenation up. We needed that. But she was not able to prone. She was too agitated to prone. Precedex was, in fact, one of the ways in which we could achieve that proning. That's why it was done, because you're titrating to effect. Can she now do this? Can we have her prone? You have to give her the Precedex to get that therapeutic modality. We're not titrating to a number, 0.7. Anything over 0.7 is an overdose. We're titrating to a therapeutic effect. Someone who titrates this medication on a regular basis would know that, which is precisely why Dr. Verdine did not know that. We also see the key points here, because after the Precedex is given, and recall, when we were going through these notes and we were pointing out all of these numbers on this chart, we were also looking at the actual entries themselves, and we could see in entry after entry the RAS score was right. The RAS score was indicated, and in virtually all of those RAS scores that we saw, she was right at about -1. There's a couple where she was at 0, a little higher. But even with Precedex running at these levels, at 1.2 and then later at 1.4, we saw the RAS scale at that time. When all of these numbers were showing here, the RAS score was at the target that Dr. Murata included in his original Precedex order, -1. She's titrating to the effect of -1. She's titrating to that. You want drowsy, you're looking for drowsy, -1. That's what she was getting when she was giving these medications. That's what Grace was when she was receiving these medications. It's been represented to you that, oh, she's receiving way more Precedex than she was back on the 7th. That's right, because we're not titrating the number. We're not titrating to 0.7 as Dr. Verdine would have us. We are titrating to drowsy, and that's exactly what Nurse McGinnis did. There's also some testimony that we've heard about restraints on the morning of the 13th. Nurse McGinnis was very honest. She recalls utilizing a non-restraint modality called MITS at some point, and that was to help keep the patient from inadvertently ripping that mask off and really active. She didn't recall specifically from 4 years ago whether restraints were used at any particular time. We do know from the record that restraints were used for a small period of time back on the evening of the 7th when Grace was first going through this really original period of agitation. And we know that Mr. Schara was actually on board with that. Restraints are used only in certain situations, and Nurse McGinnis told us what that is, only to avoid inadvertent interference with a medical device. I don't like that. You do that when you're gasping for breath, when you're not getting enough oxygen to get agitated. It's like drowning. So you're ripping and you're pulling. As restraints are sometimes used in those instances, it would not at all be unusual that a restraint might be used for a short period of time in those instances, because once again, we're trying to keep her oxygenated. The number one goal here above anything else, we need to get her oxygen. We have to keep that mask on her. We have to prone her. This is what the nurses are doing. This is the number one goal of the nurse. Have to keep her oxygen up. If restraints were being used, it's for that purpose. And in fact, the use of Precedex is for that very purpose. The use of Precedex is to achieve a level of drowsing, a level of sedation, so that things like restraints are not used. You don't need them when you're properly under just the right titration level of anti-anxiety medication. That's why we're seeing this here. We're trying not to have to use restraints. We're trying to get her oxygen. That's what Nurse McGinnis is. We also heard some testimony from Nurse McGinnis when she was on the stand there. And we heard a little bit today, too, about having no blood pressure. There was never a point where Grace had no blood pressure. Nurse McGinnis did explain in the record there was a point where the blood pressure would not be detected by the cuff, but it's a cuff. You have to try it a couple of times. Sometimes the cuff is not reading, so you have to unwrap it, flip it over again, and do it again. She did have a blood pressure. There was a notation that the cuff was not reading a blood pressure at one point in time, but we see these numbers here. She had a pulse. In fact, she had a normal pulse throughout all of this time that we're talking about. She had an oxygenation rate. She had a respiration rate. She was not pulseless. She was not without a blood pressure. If she was without a blood pressure, she would not have these numbers. We also saw these numbers. Nurse McGinnis explained what these numbers were and what they meant to us. And she explained in very great detail what these are telling her. These are very bad numbers. They tell us a big story about exactly what's happening with Grace's lungs at that time. These respiration rates are very, very high. By the time we get down to noon, we're into the 50s, the 40s and into the 50s. And they continue then throughout the rest of the day. We have normal pulses. She's got normal pulses, but her respiration rates are off the charts by the evening of that day. Her oxygen levels are very, very low. Recall Dr. Burdine told us that he, as a pulmonologist, would be very concerned about this combination of things that we're seeing there. But this is what they were attempting to manage, and this is what they were attempting to manage without the possibility of being able to utilize a ventilator. We also see where the lorazepam was given, and we also see that the actual vital signs don't budge. In fact, they're actually respiration and SpO2 are going up a little bit, but the pulse barely budges. These two medications are given, and 20 minutes later, her vital signs have not budged. Remember, it's being argued to you that she overdosed, at least in part, as a result of these lorazepam administrations. But the actual records, they show that her vitals did not budge. These two medications had no effect. That's why the morphine. That's why Dr. Schindler takes the morphine, because he's seeing this and he's seeing clinically there is no effect. The clinical numbers on black and white on the paper show those lorazepam doses did nothing to move the needle with her vital signs. Did we see this from Dr. Burdine? Did Dr. Burdine show us any of these? Did we see anything about these vital signs from Dr. Burdine? We did not. Vital signs are Dr. Burdine's kryptonite, ladies and gentlemen. They disprove his theory. This shows how sick Grace's lungs were, and Dr. Burdine doesn't want to talk about her sick lungs, which is a little disappointing coming from us. We talked about a little bit, we heard some testimony indeed from Dr. Bruce Goldberger. He was the toxicologist, and we've heard a lot about Dr. Goldberger's his definition of overdose. But interesting, what we haven't heard during the administration's opening was the actual opinions that Dr. Goldberger offered. He told us that the dose and frequency of these medications, Precedex, lorazepam, and morphine, were appropriate. The doses that Grace received were consistent or were inconsistent with any allegations. This man's entire professional life is dedicated to the study of medication interactions. routine and appropriate. The administration of Precedex, lorazepam, and morphine to Grace Schara did not contribute or cause in any way death. And the plaintiff has not produced a toxicologist to tell us the difference. Heard from David Fisk. Dr. Fisk is an infectious disease doctor. He told us essentially that Grace's case history is highly consistent with severe COVID-19 leading to decline and demise, something he saw over and over in his treatment of patients. He told us the time sequence of her illness was consistent with severe COVID disease, the Delta variant at that time. We talked about Grace's COVID-19 testing. She was positive. Those tests are very accurate. He talked about Grace's symptoms, fever, cough, shortness of breath, confusion, all consistent with severe COVID. Worsening pneumonia, we saw throughout the time on the chest X-rays that we received. He looked at those as well as Dr. Wittstock. He talked about Grace's labs. Remember that D-dimer? He talked about the D-dimer. He saw a 10-fold increase of the D-dimer rate. He said that he'd never seen that. Infectious disease doctors had never seen such a massive D-dimer rise until he saw COVID, and then it became flag, a signal flag for severe COVID. They started to see massive jumps in D-dimer, and he saw that in his record. Put the record up to show that massive 10-fold rise in D-dimer. He also talked about the respiratory failure leading to her inability to adequately oxygen. Testified to standard COVID-19 treatments, dexamethasone, tocilizumab, remdesivir. He noted that the medications received by Grace in this case were indeed routinely used in the treatment of COVID-19 patients back in critical care settings in 2021. He talked about typical adult ICU medication dosing practices. For example, for us that the standard of care does not require a doctor to discuss every modification or every medication that's given routinely to a patient in the hospital once a patient is in the hospital. He explained the role of mechanical ventilators. He identified the likely triggers for Grace's agitation, which were multifactorial. Just having COVID-19, experiencing respiratory failure, having a fever, having low oxygen levels in the blood. These are all things that cause agitation. He recapped hospital visitation policies as they existed, as he was seeing them back in 2021. And he also explained to us at that point that at the point of Grace's cardiac arrest, her chances of survival approached zero, even with CPR. Whether CPR were performed or whether some sort of medication reversal agent were given, mechanical ventilation was necessary, and that was not a modality that was in the toolbox. Met the standard of care. They met the standard of care relative to medication administration. In fact, no expert really has indicated that nurses failed to meet their relative medication in all cases. The nursing staff followed proper orders from the doctors, and there's no one who indicated that that was improper or that proper orders were not followed. She testified about the integration of family into the care plan. She talked about the importance of alarms in the ICU room. She talked about Mr. Schara's own COVID symptoms and the reasons why he was removed from her room. She also noted and gave instances of how Grace was well supported by the staff and how communications between Grace and her decision makers continued. She also talked a little bit about resuscitation guidelines. And she explained as well that you don't have the ability to intubate. You can't aid circulation without oxygenation. It's futile. It's futile to be able to resuscitate. You can't resuscitate someone. You can't get oxygenated while moving. You can't do that. Now, we heard testimony as well from Dr. Binstock, Dr. Garibaldi, Dr. Beach. Recap their testimony in more detail, but I will say that Dr. Binstock, at least, his description of the X-ray imaging for Grace during her hospitalization was quite compelling. In fact, we saw some of the images that he was looking at, both with and without an overlay, and he looked at all of these and took us through these things, what these look like. And they're all there, all of the images that were placed. He went through one by one and showed us all of these X-ray images are bad, from the 6th to the 13th. They show severe and advancing COVID, and it's getting worse as we're going. The findings on these X-rays, notably, cannot reasonably be explained by a medication overdose. We are seeing clinical situations right here on these versions in these X-ray studies that show us, indeed, advancing COVID disease. None of this can be explained by any medication that's used. Dr. Garibaldi's opinions are also medically compelling. You'll recall he testified that Precedex is a medication that was indeed routinely used in the ICU. The administration of medication by the nurse staff in this case was totally different. That was one. He told us Grace did not experience this whole that were administered to her were common, routinely used, and were always given within the parameters that the doctors gave them. He testified that Mr. Schara's removal from the hospital on October 3rd did not. He testified that the resuscitation of Grace following her arrest on October 13th would have been futile in the absence of intubation and mechanical ventilation. Again, come back to that. Only mechanical ventilation would have had the potential to save her life at that time. The cause of her death was COVID-19, and Dr. Garibaldi explained that in great detail. Recall that he was, in fact, during the COVID-19 pandemic, with the one of the top institutions that was dealing with COVID infection. He had very deep knowledge of the issues that were going on. Ladies and gentlemen, I'm going to ask you to do a little reading between the lines as well. First thing I want you to do. Plaintiffs have two experts. They have a pulmonologist, Dr. Verdine, and they have a nurse. Why only two? Why only two experts? Why no radiologists? Why no infectious disease experts? Why no toxicologists? Why no pharmacists? Plaintiff claims that Grace's death was caused by a medication overdose, so why no pharmacist or toxicologist? These would seem to be useful experts when we're talking about potential medication overdose, yet plaintiff relies solely upon a lung doctor, Dr. Verdine, for an opinion on essentially everything. The answer, I think, is fairly obvious. Plaintiff could not find a pharmacist or a toxicologist who would be willing to risk his or her credibility in order to support plaintiff's threadbare overdose. We heard from testified at the behest of the defense. Both that defense toxicologist and the hospital director of pharmacy confirmed these two medications together. The dosages were too small to cause an overdose. Grace's vital signs on the 13th were completely inconsistent with the overdose theory. We saw that. Recall the testimony was that if you're going to have an overdose, you're going to start seeing a respiration in 5, 6. Normal is 12 to 20. You're going to see respirations below that. We're seeing respirations completely the opposite direction, completely the opposite the entire day of the 13th of what we would expect to see with overdose. If plaintiffs had been able to find an expert in toxicology or a pharmacist who was willing to support this overdose theory, you can be sure you would have heard from them. And that's telling. I ask you to read between the lines as well, because neither of the experts that the plaintiff does have has any experience prescribing or titrating precedents. Yet plaintiff's main argument in this case appears to pivot upon a theory of a Precedex overdose. One would imagine that you would want to call an expert who has at least a tiny bit of actual hands-on experience titrating and administrating the medication upon which your entire theory revolves. Dr. Verdine admittedly does not titrate Precedex, does not prescribe Precedex, knows nothing about Precedex beyond what he read in a package insert. Now, ladies and gentlemen, my 18-year-old son could read a package insert. I love the boy, but I would not trust him to take care of me in the ICU. Having an MD next to your name does not make Dr. Verdine an expert on Precedex, and yet he is the sole expert you heard who criticizes the use of Precedex in this case. Essentially, Nurse McGinnis, Nurse Haynes, Nurse Fisher, Nurse Davis, they've titrated and administered more Precedex on any given Tuesday of any given week than plaintiff's two experts have done in their entire respective careers combined. No one who has any experience actually administering or titrating Precedex would support plaintiff's overdose. Anyone who actually had personal hands-on experience with the titration of this medication would know that Dr. Verdine's opinions are simply not consistent with the way this medication. Dr. Verdine insists that the titration of up to any number above 0.7 necessarily is the equivalent of an overdose, but that opinion is entirely without foundation and betrays a distressing level of ignorance. Heard about the concept of titration to effect. The nurse actually titrating Precedex aims for a therapeutic effect, not for a mere number on a page. We saw that when we looked here. The RAS scale, the titration to effect, is exactly what we were seeing, what we were getting when we were looking at this. Even though she was running at 1.2, 1.4 Precedex, we were still achieving that target of -1 RAS score at the time. We're titrating to effect, not to number. Plaintiff claims that Grace died as a result of a medication overdose, yet the plaintiff's nursing expert holds no opinion on the administration of any of the medications either. Again, I think the reason for this is obvious. No ICU nurse who's actually used or titrated Precedex could support plaintiff's overdose. If plaintiff could have found an ICU nurse who would be willing to offer support for an overdose theory, you can be sure we would have heard. We also heard a little bit about Dr. Verdine and his theories. Saw him up there on the screen talking about metabolic acidosis, things like that. You'll recall that it came up during his testimony that theory actually came up for the first time in his rebuttal report, his third report, he had 3 reports, and a rebuttal report that was issued after the defense expert was issued. Dr. Verdine saw the expert reports produced by the defense experts, knew that his original overdose theory, his first 2 reports, would not go into the eye, so he cooked up the present metabolic acidosis theory in a desperate attempt to explain Grace's elevated respiratory rate without having to concede that the elevated respiratory rate that we're seeing on this chart here was due to lung damage. He can't admit that. Because if he does, he'll have to admit that he's death, and he's not going to do that. Dr. Garibaldi, Dr. Fisk, Dr. Shokar, they've all conclusively refuted Dr. Verdine's metabolic acidosis theory. Ask yourself, why did it take Dr. Verdine so long to develop this theory? He had Grace's medical records for over a year. He drafted 2 lengthy reports before he ever stumbled on his metabolic acidosis theory. Dr. Verdine even testified that any competent physician would have recognized metabolic acidosis, yet he didn't stumble upon the theory until very late in the game after he got the defense expert reports. This would make Dr. Verdine either incompetent or. Let's also ask about why these 2 particular experts. Both were hired based on their appearance or their participation in social media or chat groups. Both plaintiff's experts have access to Ryan in terms of the narrative surrounding COVID. Dr. Verdine was targeted by the plaintiff as an expert whose participation in a chat group designed for people who disagreed with the existing narrative surrounding COVID. Nurse Eichinger also had some strong feelings relative to the narrative of COVID. We put up exhibit numbers.
How much longer do you have? Okay, so we'll take our break right now. It'll be, maybe don't want to call anybody out, just by a shaking of a head, would you like the 20-minute break or something quicker than that? Okay, so we'll do our 20-minute break, and then we'll come back in and make the next steps in these closing arguments. The jury is excused. All right, this is a hearing outside the presence of the jury, 11:45, sound good? Yep. Well, Good question. I was thinking maybe like 1 o'clock. I don't know, how long are you gonna have, Attorney Guzzi?
Well, given the territory that Attorney Frank Koyak has covered, I think I will be able to shorten mine up a little bit. I was thought,
The answer.
what?
Just a little bit?
I think it was clocking in at about 45, so it should be less than 45.
10?
Okay, so what we'll do is just probably go that hour and a half, you know, we'll take a lunch at the end of all of it.
I guess, and then can start deliberating at that.
Yes, so we'll be back at 11:45 and the plan will be to finish all of it. Thank you, we're adjourned. All right, everyone may be seated. Welcome back, members of the jury. I think you were told, so I'm just going to tell the lawyers because I base it on their timeline, but your lunch is going to be here at about 12:45 or 12:50. So I expect they'll want you to get it when it's warm. So we'll go until they're finished, but that's going to be about the timeline, 1 o'clock-ish or so. Attorney Francowiak.
We're talking about reading between the lines. Another area I'd like to read between the lines. Plaintiff's exhibits might have noticed in the testimony of the statute, which were notably light on substantive notes from Grace's medical records as well as vital signs. Both Nurse Eichinger and Dr. Burdine issued reports that gave trial testimony that were both very light on reference to the actual provider, actual reference to vital signs. Mr. Schara testified, if you recall, with review of the medical records, counted about 22 different provider notes. This is Schara. A number of those provider notes have been marked for the provider notes of Grace's charge reveal that all of Grace's were essentially unanimous, recognizing that Grace suffered from diseases. Vital signs are problematic. Clearly make it very abstract hypoxemia wasn't that. The vital signs are fully consistent with COVID-19, completely inconsistent with an overdose theory. You see that, for example, as we talked about on this board right here. Grace's pulse, heart rate are essentially normal throughout the 13th as we're talking about this. But the 2 doses of lorazepam don't move the needle in any way. We would expect again to see respiration rates far, far lower than that. The respirations simply are far too high clinically to support this overdose. We also heard testimony that if a morphine overdose would be an explanation for Grace's death, we would have seen clear signs of a drastically suppressed respiration rate within about 5 minutes. Dr. Goldberger talked about that. Instead, we see about 20 minutes after the actually saw a little bit of a clinical improvement. In fact, we didn't see for more than an hour after the morphine was administered. Respiration normal. If we were going to see a overdose, if we were going to pinpoint an overdose related to morphine, we would have seen that within 5 minutes. There were providers at the bedside. Dr. Schultz and Howard were at the bedside throughout that time. We just don't see that. It's not consistent. Clinical respiration rates and pulse are just not consistent with what we would expect to see if we actually had. There's also been some talk about resuscitation. Scott Schara did not want it, did not authorize intubation. So I didn't talk about that. Intubation was discussed with him on numerous occasions, probably about half a dozen times. Grace did not need a ventilator. She needed a ventilator. Plaintiff contends that he requested Grace to be resuscitated at the time of the code, but the only resuscitation that we heard Dr. Burdine testifying was to the administration of some sort of reverse. We know from Dr. Burdine that really only mechanical ventilation been effective potentially. We also know that resuscitation would have been futile in the absence of Dr. Burdine does not even suggest that CPR could somehow have been successful. That would be contrary to overdose. Keeping with that overdose theory, Dr. Burdine just talked about some sort of reversal. CPR could not have been successful at the time of Grace for a number of reasons. primarily due to the absence of sedation, mechanical vent. What's called CPR stands for cardiopulmonary resuscitation, aspect of the heart. As Dr. Shokar noted, we start the heart, but it's just going to stop again. The pulmonary aspect, that's the part that's held in. Doctors and nurses had no way to address that pulmonary aspect. Even so, the plaintiffs are not contending that CPR should have been initiated. The theory here is strictly one of a medication overdose. They contend that they ask the nurses to somehow reverse the medication that Dr. Shokar had more. But a reversal agent would have done nothing at all to fix Grace's lungs, with the actual numbers that we're seeing here. They would have done nothing to change the picture of the x-rays that Dr. Binstock testified about. A medication reversal agent would not have done anything to fix profound oxygen deficit or extremely heavy work. Grace's lungs were damaged. A medication reversal agent would have done nothing that day because Grace's clinical condition was not suitable. Grace's clinical condition that day was driven exclusively by severe progressive coronary disease. Packed her lungs and severely constricted her breathing. Not disputed that a nurse does not have the authority to review a DNR from a patient's chart without a doctor or anything could be done, and that was only done after a discussion with the family. That was even testified to by Nurse Hiking. It's not something that a person can. Grace's code, as we've seen, happened fast. All, again, just as testimony, thought it advanced. Certainly will suggest that that is the case. This is why these conversations occur in advance, pre-authorization conversations, because we need to know what needs to be done. There's McGinnis recognized that on her notes, I think, clarification. Recall also Dr. Fisk talked a little bit about resuscitation. He mentioned that resuscitation, again, is not possible in the absence of mechanical ventilation. He even noticed that even with the administration of a reversal drug in this case, that would have done nothing for Grace's lungs. But in addition, he noted that even when a reversal drug is given, typically that's accompanied by the placement of mechanical ventilation of some sort. But again, that was not in the toolbox. It's really undisputed that Grace's doctors did not have mechanical ventilation in that. The medical evidence, in fact, is compelling based upon Steve. Grace died reversally. I want to talk just briefly at the end now. I'll talk a little bit about it. You've been given a document called a special verdict. Talk about it. You asked to answer a couple of questions. From the perspective of the hospital and its nurses, really the only question. That question asks specifically, were one or more of the nurses at the hospital negligent with regard to the care by Grace Schara? Based upon all the evidence we've seen over the past 2 weeks or so, I would respect this that question. So, when you answer no to that question, you won't be required to answer with respect to the hospital. There's also a question on the verdict. We call it a cause question. Simply ask whether the hospital caused injury or death for Grace Schara. That's question number 6. I need to answer that question. You answer no to question number 5, although I believe it's abundantly clear that there's nothing that the nurses did with regard to Grace's hospitalization cause or resulting respiratory collapse. After all, when we look at the opinion, plaintiff's experts offer very little in the way of criticism after all the actual care that was far more interesting. Grace herself. The care of Grace, however. Question number 5. Now, there's been some suggestion in some arguments that, for example, Nurses caring for Grace on October 8th should have informed Grace or her decision maker about some sort of medical event that was alleged to occur on October 7th or October 8th. The plaintiff claims, obviously, that the doctor designed that Grace experienced an overdose of Precedex on October. First, when Sam Yates was commenced with titration on October 7th, and later when some medication that he actually did for death was administered. Also, indicate Grace's blood pressure on the 8th. Well, Nurse McGinnis, Nurse Keats, Dr. Darabal, several of the witnesses made it quite clear to us that there was nothing that occurred on the 7th. Now, 7th, it was a Sam Yates starting to the titration of the necessary anti-anxiety medication. Doctor started it as he should, starting titration date that the doctor ordered, and then he immediately depression got the level of anxiety and anxiolytic properties. Most instances complete medication were occurred in close observation in ICU setting for known potential side effects. Grace never experienced it. The word that we use when we ICU and explain exactly what was going on there on the set. Unusual about that happens all the time. Sam says now the right dose for Grace on that date. Achieve the level of sedation. In addition, I've not been instructed. You're not going to be asked to answer any issue for informed consent. Nurses don't have an informed consent. I've been instructed that even if some medical event, could have related medication could have to occur sometime wouldn't be nurses on both those days. That would be generally an informed consent. We do advise nurses report to doctors. Doctors have conversations with patients. So the doctors caring for Grace on 7th and 8th are not offended. There's no allegation that they did it wrong. They're the ones who have the conversation. There wasn't, of course, but it's not an accurate statement for that response. Doctors ordered to report to the doctors, they report to the patient, and then the doctor decides what family. No nurse had a duty to such an event occurred and would have required such a conversation, nor is there any required demonstrated conversation. Also, Grace on October 10th. October 10th was the day when Scott Schara was asked to leave the hospital. Even if this argument had anything at all to do with Grace's death, COVID, those barcodes Indian calm conversation. Hospital that day. She in fact took steps to set up a virtual visitation concept with him before he left. That was set up today. She was able to set up to make sure that her schedule keep the Schara's updated on what was going on. This is in fact how all patients were care with all POAs and family members were in that. Communication was done pretty typically. But of course, there was a recognition here that Grace's sister was indeed allowed to come in that day. This is that which you recognized particularly we also heard that Nurse Catherine Hale, she was the RN who took over on. She had multiple conversations with Scott Schara was also given the number of it and the number for Nurse Barclay herself. And if you really look at those nursing communication on other quite and unrelated in any way. It was also suggested and argued that the nurses did not create some sort of plan together with for Scott, or someone coming on to replace Scott. Again, this is has nothing to do with the advancement of Grace Schara. It has nothing to do with the cause of death. First, as Attorney Mendenhall asked, see Mr. Schara's absence from Grace really had nothing to do with her death. She passed away on the 13th. Her sister was there on that day as well. There's also no evidence that any nurse had a creative to get a replacement for Scott on that. See that Allison Markle did in fact sit down and create a plan for virtual visitation for that day that was implemented, and virtual visitation was in fact what occurred on that day. Scott's testimony, or Scott Schara's testimony, is that he dealt with the hospital administration the next day in order to make sure that the hospital and that Jessica understood the parameters, for example, wearing PPE, things like that, to avoid her getting sick. And that was approved the very next day. The nurses were caring for Grace. They weren't caring for her father. They had communication. Certainly they did. Allison Markle certainly did. But the nurse's responsibility was caring for patients. From Nurse Davis, they were not necessarily, or they were not involved in negotiations to find a replacement. Their role was a care role, and certainly a replacement for Scott was in fact found and completed the next day. There was no particular responsibility. There was no standard there that all the nurses having to, take away from their Grace and negotiate a replacement for Scott. In fact, Jessica did come to the hospital the very next day. The nurses weren't involved. The nurses weren't supposed to be involved. The nurses, again, and that's exactly what they did. It's also been argued that the nursing staff somehow failed to communicate with Grace or her POA. That was the day, obviously, when Grace passed away. That would be Nurse Holly McGinnis. She was there that day. Now, Holly had no duty to communicate with Scott Schara. She was the nurse at the bedside. The records show Dr. Shokar was communicating with Scott Schara that day. Now, Holly McGinnis was communicating with Jessica. She was at the bedside. Jessica had questions. She was over Jessica. Jessica admits Holly answered her questions. Jessica was in contact with her family at all times. Holly had no even a reason to discuss anything else. Specifically with Jessica. Jessica wasn't a designated decision maker. Her parents were, which is why Dr. Shokar had conversations. She had no reason, Holly didn't, to have any type of discussion with Jessica at the bedside at that time, because she had a DNR order in the record. She had no reason to question that. She was not involved in discussions. It never came up. And certainly her role would not have been to discuss that with not have an important consent relative to addressing the DNR issue. So there simply wasn't on the part of Holly to give us to have such a discussion with Jessica, who was also the sister, as the representative actually was here with her sister at that time. It's also been argued in this case that the nurse's presence on the unit at the time of Grace's arrest were at least suggested or somehow required to ignore a valid DNR order in charge in violation of the registered It's undisputed, however, that a physician would need very fast vital signs. Nurses are prohibited from acting unless the physician would have a discussion about the DNR with the family and with issues. That would not be consistent with the standard of care for the nurses to act in the absence of actually dealing with it. Dr. Shoker had already left. He was gone from the hospital at that time. So that wasn't the issue. But the nurses cannot just jump. Well, no, it is not. It is undisputed, in fact, that the nurses did not have the ability or the authority to withhold or to ignore the DNR. There simply wasn't enough time. Reach the end of the evidence. The evidence in this case shows that the hospital's nursing staff applied this. There are several defendants on the one end, the one that's actually responsible for Grace Schara's death, is not on. Can't put COVID-19 on the verdict. Medical evidence based upon everything that COVID was caused. None of the defendants breached any standard on the death of Grace. Grace's death was a tragedy, and unfortunately, it occurred all too often during the illness. Every one of those patients, everyone that Dr. Knight testified were all sad versus saw. 19 months out of this year. Following deficit. Nurse Aiken 3 months. Nurses saw that week after week. Over and over again. All of the physicians and the nurses treated Grace actively, or at least give her a fighting chance within the bounds of the wish. I would ask that you acknowledge this fact when you answer no to question 5 on the verdict.
Thank you, Attorney Krakowiak.
To set up.
Take your time. Talked about this briefly on what would happen today once you start deliberating, but when you do, you will not hear from me until about deliberating, but when you do, you will not hear from me until about 4:30, maybe 4:20. If we haven't heard from you, we'll knock on the door, and the question will be, do you want us to order dinner for you? Typically, it takes a half hour, 40 minutes to get it here, and you'll have that opportunity to say, no, we're going to just finish at 5 and come back tomorrow, or no, we don't need dinner, or sure, we'll have dinner ordered. Okay, and I think I mentioned to you, I'm going to do whatever it is that your preference is. And so that will be totally on you. But so when you start deliberating, that'll be the first time you hear from me. But otherwise, if you have questions, whoever that foreperson is, and I'll cover that in a minute, we can only communicate by written notes. So you'd write me a note, and the foreperson will put their number on it, similar to how you've asked questions. And then every note that you give, I will bring it into court here, and we'll talk about it and get you an answer. So it might not be immediate. And that'll be the process that we use in terms of during your deliberations. Attorney Guzzi.
May it please the court, counsel, Dr. Shokar. You know, sometimes it's a challenge going third because you really try to get out your points, but also try to strike the balance of not being overly repetitive. And that's what I'm going to try to do here for you today. I join in counsel's sentiments about the work that you've done over the last 2.5 weeks. Over the years that I've been doing this, I don't know that I've ever had a jury show up every single day, every member show up on time. And that's incredible. We've asked a lot of you over the last 2.5 weeks. We've asked for your time, your patience, your attentiveness, and you've done an amazing job. And on behalf of Dr. Shokar and myself personally, I want to thank you for your service. So closing argument is my opportunity to present to you my view of the evidence that was admitted during the course of the trial and how to apply it, and also walk you through how I think the law applies in this case. When we started this process 2.5 weeks ago, when I stood up in front of you in my opening statement, I mentioned that you were here to resolve a conflict. The conflict between Mr. Schara and Dr. Shokar as to whether Dr. Shokar met the standard of care when he was providing care and treatment to Grace Schara, and whether he met the standard of care for informed consent. That remains the conflict that you are here to resolve. 2.5 weeks ago, we were in the other courtroom going through the process of jury selection. The fancy term for that is voir dire. Voir dire, ask 5 attorneys, they'll all pronounce it differently. But when translated, it means speak the truth. One of the last things you hear before you go back to deliberate is an instruction that contains the phrase, let your verdict speak the truth, whatever the truth may be. And that's what this whole process has been about for the last 2.5 weeks. It's a search for the truth. It's looking at the evidence, applying the law, and determining what the truth is in this case. How do you go about doing it? Well, I think it's very similar to putting together a jigsaw puzzle. Attorney Frank Koyak alluded to puzzle pieces. With brand new jigsaw puzzle, you open up and you dump out the box and all the pieces are on the table. We're the ones that dumped out the box with all the exhibits. I think most people then, when they put their puzzle together, they use the cover as a guide. In this case, the law, as instructed to you by Judge McGinnis, that's your guide. Your verdict, and you've heard it in the instructions already, your verdict must be based on the evidence and not sympathy. And I know that is a hard thing, and we'll talk about that. It is rather remarkable to me, as I sat and listened to plaintiff's closing argument, that it would be said, well, the defense is going to talk about COVID. Yeah, we're here to talk about COVID. Everything you need to know about this case can determine by looking at these images, because these images show you the true story of what was going on with Grace while she was hospitalized at St. Elizabeth. I know a lot of the timeline has been covered. I'm going to try to hone in on what I think are some of the important highlights. Upon admission, Grace, an X-ray was done and a CT scan was done. You might recall that Dr. Binstock prepared an exhibit that showed you Grace's CT scan upon admission. And you probably remember that when Dr. Binstock was here, he had his laptop and he had the special software that he could show you what was actually going on within that CT scan. Call from this exhibit that up here is what a normal CT scan looks like. This is a CT of early COVID. And I do have this up on the board in a later slide, so we'll go over it again. This was Grace Schara's CT scan at admission. Yeah, there's a little improv going on here. It's okay, thank you for letting me know. This is clearly a situation where Grace enters the hospital with moderate to severe COVID. She's been a sick girl for a very long time. Very sick girl. On October 7th, in the evening, Precedex has started due to Grace's agitation. And we all know that Precedex is one of the big issues in this case. I'll talk quite a bit more about it in a minute. Additional x-rays were done on the morning and the evening of the 8th, which show continued progression. On October 9th, Dr. Murata is one of the first of several doctors to bring up the topic of intubation with Mr. Schara. On the 11th, yet another x-ray shows further deterioration of Grace's lung condition. And that kind of sets the stage for when Dr. Schokar begins providing care and treatment for Grace Schara. He takes over on the morning of October 12th, and in the process of taking over Grace's care, he has what's known as a handoff or report with Dr. Carl Baum. And in that conversation, Dr. Schokar learns about Grace's condition, what's been going on with Grace, what the BiPAP say, what our oxygen requirements are. He also learns that there hasn't been a formal entry into the medical records about intubation status. So one of the first things that Dr. Schokar recognizes as he takes over Grace's care is that that situation has to be resolved, because the staff needs direction as to what would happen if Grace went into cardiac arrest. Dr. Schokar also reviewed Grace's medical chart, all the records of her previous care. And after doing so, he explained how he did this. He arrived at a differential diagnosis. And in this case, it was more of a confirmation. After looking at all the information, it was a confirmation of the existing differential diagnosis. Grace in the morning, and he noted that Grace had had a good night. She seemed to have stabilized. Unfortunately, Grace's condition deteriorated over the course of the rest of October 12th. That prompted Dr. Schokar to prepare a note on the afternoon of October 12th, and also have a discussion with the Schara family. Discussion, he relayed to them that Grace's current clinical presentation required BiPAP at max settings, max pressure, 100% oxygen. Counsel, in opening statement, referencing this same time frame, said, well, her oxygenation rates were in the 80s, the 90s. Dr. Garibaldi told you. Dr. Garibaldi told you that we're all in the 90s right now on room air. In order to achieve that level, when we're talking about room air, we're talking about 20% oxygen. So in order to achieve that same level with Grace, they had to have her on a machine that was giving her 100% oxygen. 100%. Grace did not have a good day. She may have had a good morning, but it wasn't a good day. Continued to deteriorate throughout the day. Schara family. If you remember, he initially contacted Cindy Schara and started the conversation. And at some point, the conversation got emotional, and understandably so. And Cindy Schara told him, you need to talk to Scott. So in the course of that discussion, they discussed worst case scenarios. If Grace stays on BiPAP, what happens? Well, at some point, since she's already on max settings, there's going to come a point in time where that machine isn't going to be able to support her oxygen levels. And Dr. Schokar explained to them at that point, Grace will pass. We talked about intubation as well, and those types of scenarios. And I believe Dr. Schokar made it very clear that even at this point in time, given Grace's condition, was not a guarantee, and intubation actually had a very small chance at preserving Grace's life. But he explained what that would look like if she was intubated and if she made it out of the hospital. The likelihood was that there would be long-term damage to Grace's lungs. You saw a note from Dr. Gandev during Dr. Garibaldi's testimony in which he described fibrosis in the lungs, or the beginning of fibrosis, scarring, long-term damage, not going to be fixed. And so even if Grace made it out of the hospital, the likelihood was that at a minimum, she was going to need a long-term rehabilitation and quite possibly the use of supplemental oxygen for the rest of her life. That was all explained to the Schara family. Dr. Schokar told the Scharas that he needed a direct answer on intubation. And then he also started the discussion about intubation in the context of cardiac arrest due to respiratory failure. And as Attorney Frankowiak mentioned, if you can't, and this was testified to by Dr. Garibaldi, was testified to by Dr. Schokar, if you cannot address the underlying cause of the cardiac arrest, in this case respiratory failure, and that means address it with intubation, CPR, defibrillation, all that is futile. Because all you're doing at that point is you're doing compressions on a heart that is pumping unoxygenated blood. Blood has to be oxygenated to feed the tissues, to feed the organs, to keep you alive. And if all you're doing is moving around unoxygenated blood, it doesn't matter. Eventually the heart will die and you're not going to be able to bring it back. In other words, without intubation, resuscitative measures were futile. And Dr. Schokar explained that to them. He documented in his note that all questions were answered and that the conversation took 60 minutes. That brings us to the morning of October 13th, 2021. Again, Grace's clinical condition is getting worse. BiPAP settings again at max pressure, 100% oxygen. But equally important is the fact that they tried to wean Grace down to 90%. They tried that. Her stats dropped down to 80%. She could not maintain her oxygen saturation levels without that BiPAP machine on max settings. Dr. Schokar also documents agitation, pulling at the mask, pulling at the PICC line. And he documents the need for ongoing use of Precedex. Something else in that note, the lab results. I don't know if you remember talking about the lab results with Dr. Garibaldi and Dr. Shokar. But at that point in time, the lab results showed that she'd spiked a fever. Her dimer had gone up from, I believe it was 2,300 to 23,000 on Friday. Indications of what Dr. Shokar referred to as a cytokine storm, or an inflammatory response to the ongoing COVID infection and the ravaging of Grace's lungs. An inflammatory response which, as Dr. Shokar described it, the body starts to do damage to itself. That's what was going on the morning of the 13th. Dr. Shokar has a conversation with the Schara family to follow up on the previous conversation and also to update them on condition. They discussed nutrition, and the family consented to the insertion of an NG tube. Family informed Dr. Shokar at that point that they had elected for do not intubate status, DNI. At that point, Dr. Shokar then had an additional conversation about CPR and the futility of resuscitative measures in the absence of the ability to intubate. Dr. Shokar documented that conversation in his note. He also documented that there still was the goal of improvement. Nobody was giving up on Grace Schara at that point. Absolutely not. Everybody in that hospital that was taking care of Grace Schara was doing what they could within the parameters of the family's wishes to save Grace's life. And so when Dr. Shokar references getting her up in the chair and getting her moving around and watching TV, as he told you, that was a long-term goal. He never told the Schara family that that was going to happen on that day. How could he? She's on a BiPAP machine, basically providing all of her breathing support. She's in a bed. Told them that that was the goal for the day, and he never told them that Grace had a good day, because that wouldn't be true. Throughout the course of the day on the 13th, Dr. Shokar, on his own, and also through the eyes and ears of Holly McGinnis, continued to monitor Grace's condition. And Attorney Frank Koyak went over all the vital signs to kind of bring you up to speed on that. But Dr. Shokar was working with Holly McGinnis to try and figure out the best way to deal with Grace's ongoing deterioration, the high respiratory rate, the low oxygenation levels, and they had limited options. So that respiratory rate is increasing, 40s into the 50s, 55. Nobody can sustain that type of respiratory rate for very long. I don't know how Grace managed to do it for as long as she did, but she did. Obviously, Grace was a fighter. Clearly was a fighter. She was a lot of things. She was a very vibrant young woman with an amazing sense of humor, but she was a fighter. This has now reached the point where we're in an emergency situation. Holly McGinnis gives lorazepam at 1746.5 milligrams, consistent with a PRN order by Dr. David Beck. She realizes that that medication, that 0.5 milligrams, had absolutely no effect on Grace in terms of trying to get her respiratory rate under control. Dr. Shokar brings him up to speed on what's going on, and Dr. Shokar gives a verbal order for a third dose, or a dose of 0.5 milligrams lorazepam to reduce the work of breathing and buy Grace some more time. Unfortunately, that had no effect, change in condition. And how do we know that? Well, Dr. Shokar, after giving the verbal order, comes down bedside by Grace, and he's monitoring her. He's monitoring her to make sure, number one, that there is no side effect reaction after administration of lorazepam. And he also wants to see if that order has any, or that medication has any effect. And unfortunately, it doesn't. Ultimately, is working. Dr. Shokar is in the position, as Dr. Garibaldi put it, the impossible position of having very little in the way of options to address Grace's issue. The respiratory rate, the low oxygenation levels. At 1815, recognizing that Grace is now 50. 55, Dr. Shokar testified that he saw at least one reading at 60 breaths per minute. Dr. Shokar is faced with an emergency situation and he has two options. Since intubation is not an option, two options. Do nothing and watch Grace go into cardiac arrest and pass away. Or do something to try to buy her, get her through this inflammatory response. Dr. Shokar makes the decision to order 2 milligrams, small dose of morphine, 2-3 tablets of Tylenol 3 are the equivalent, to see if that will have any effect. And you know, I saw the clip of Dr. Burdine talking about this being, I don't know if he said it was the most egregious. When you parse out what Dr. Burdine said, and I took notes here, giving morphine to an unconscious patient with no blood pressure, no pulse. That's what he said. Conscious. At best it was somnolent, and there is a clinical difference. Somnolent means very sleepy, but arousable, unconscious means what we all know it means, unresponsive. There's a clinical difference, and Dr. Burdine knows that. He knew that. And that the record doesn't reflect unconscious, it reflects somnolent. No blood pressure. False. How do we know that? We know that through Dr. Shokar's testimony, that when this incident came up where the monitors weren't picking up a blood pressure, he did things the old-fashioned way before we had electronic monitors and everything like that. He went through, checked the pulses and all the appropriate locations to verify that there was a blood pressure and to verify that there was a pulse. So when Dr. Burdine says no pulse, Dr. Burdine, that's false. Not true. So Dr. Shokar administers or orders the 2 milligrams of morphine. He remains bedside to monitor because he knows that if there's going to be any type of adverse reaction, it's going to occur within minutes. But obviously, he also wants to see whether this intervention has any effect on Grace. Her condition improved and stabilized, at least for the time being. Her respiratory rate drops into the 40s, still well beyond what's normal, and still a respiratory rate that in the long run would be hard to maintain. And her oxygen saturation level increases to 95%. As I said, there's only so much a body can take. And when you're breathing that at that level, 40, 45, 50 breaths per minute, you're malnourished. You're fighting inflammatory response. At some point, the body says, I can't do it anymore. I just can't do it anymore. Grace suffered cardiac arrest around 7:25 p.m. and was pronounced dead at 7:27.
Why some of the things that we're seeing here are not
to this case. He said, science is the silent witness. In this case, it's medicine is the silent witness. Well, at least of the case. The plaintiff and Dr. Burdine completely ran away from the medicine in this case. There's a reason you didn't see this in their case. There's a reason you didn't see all the x-rays in the case. There's a reason that they hide from you the BiPAP settings and how desperate Grace's need for oxygen became. Because if they told you any of that, if they mentioned any of that in their case in chief, the jig is up. It's COVID-19, not a drug overdose, not a medication overdose. They couldn't show you that because it doesn't fit with their cherry-picked theories, data from certain parts of the record. It doesn't fit. It's not the real, theirs is not the real medicine. This, you had to wait until the defense started presenting their case to see key pieces of medical information. They kept that from you. Add admission with this. Explain to you that the problem with the admission x-ray or any x-ray is sometimes it's only the tip of the iceberg. He demonstrated that through his radiology software and going through the CT scan. You've seen this multiple times, and like I said, that tells the story of this case visually. So, Attorney Administrator in his opening statement talked about credibility of witnesses. And I think it's fair that we talk a little bit about Mr. Schara's credibility. Ultimately, it's your assessment to make. Odd. So this case is that nobody ever told the Schara family that Grace was on Precedex, right? That's been one of the themes. But let's think about that for a little bit in light of the things we know about Mr. Schara. We know he was a researcher. He was recommended to give Grace tocilizumab. Mr. Schara did research on his laptop, then consulted with a family friend, and based on that, he made the decision to decline tocilizumab. When the topic of ventilators came up, Mr. Schara got on his computer, researched ventilators, came to the conclusion that he came to and decided that Grace was not going to be put on a ventilator. We also know that Mr. Schara wasn't afraid to ask questions. He wasn't afraid to challenge nurses and doctors. We know he was in Grace's room from October 7th to October 10th. And we know that he, at times, was silencing alarms, turning off alarms, however you want to characterize it. When you take that all into consideration, how plausible is it really that when Mr. Schara is in the room on October 7th, when they start the Precedex, that not a single person, doctor or nurse, told him what they were doing? How plausible is that? Maybe even a better question is, how plausible is it, given what we know about Mr. Schara, that he wasn't watching what was going on and asking questions. Really, is it plausible that he didn't ask a single question? Didn't make any inquiries as to what was going on? Supposed over sedation events occurred, which are really known side effects of a medication used routinely in an ICU. Is it plausible to think that he's in that room and there's activity and there's bags of medicine being hung from IV poles, that he didn't ask a single question? That he didn't read any of the names of the medications on the bags? That not a single physician or nurse said a word to him about that? It's not plausible. In fact, we know that Jessica Vanderheiden, immediately upon walking in that room, saw the Precedex machine and asked questions. If Jessica saw it and asked questions right away, is it plausible to believe that Mr. Schara didn't see the machine or didn't ask questions or perhaps maybe even do some research? How about in terms of the DNR, DNI? First, it's important to note that Dr. Shokar's progress notes documenting these conversations are the contemporaneous record of the conversations. They're not just his testimony almost 4 years later. What you heard from Mr. Schara is the testimony that he's given in a lawsuit 3.5 years after the event. He comes here for the first time, he gets on that stand, and for the first time we hear, well, if they had just told me that she needed to be intubated to survive, I would have done it. First time comes into this courtroom asking you to award damages. Mr. Schara's position on intubation and ventilators was consistent up until the time he started this lawsuit. In terms of the conversation on the 12th, Dr. Shokar didn't deny that the conversation was 60 minutes. He confirmed that. He confirmed that Dr. Shokar spoke extensively about ventilation. He admitted that a discussion took place regarding what would happen if Grace's heart stopped. Dr. Shokar asked, would you want us to keep working on it? The response was, do your best, and God will do the rest. But we find out on Tuesday, through Mr. Schara's testimony, confirming his previous deposition testimony, that came with a caveat. Do your best, and God will do the rest, with the caveat that we do not want her to be intubated or ventilated. Now I want to be very clear on something. Medical decisions are personal, and people have their reasons for making decisions. And it's not my place to be critical of that decision. As Dr. Shokar said, in these types of situations, there is no right or wrong answer. That being said, decisions have consequences. And in this case, decisions had consequences for Grace and also for the healthcare providers that were taking care of Grace. Credibility of expert witnesses, Attorney Administrator addressed that. The bottom line is this: in order to find Dr. Shokar negligent in any respect in this case, you have to find that Dr. Berdeen is more credible than Dr. Shokar, Dr. Goldberger, the toxicology expert, Dr. Fisk, infectious disease, Dr. Binstock, board-certified radiologist, Dr. Garibaldi, board-certified in pulmonary medicine and critical care, and Dr. Beach, an ethics expert. As you might expect, I have a few things to say about Dr. Berdeen. First of all, one of the instructions that you received, a couple of them, talk about the actual standard of care. What is the measure? And remind you that it reads like this. Dr. Shokar was required to use the degree of care, skill, and judgment which reasonable hospitalists in the intensive care unit would exercise in the same or similar circumstances, having due regard for the state of medicine or medical science at the time Grace Schara was treated. Emphasis on reasonable hospitalists in the intensive care, same or similar circumstances. Dr. Shokar was a hospitalist. Dr. Berdine was not. Dr. Berdine was a pulmonary consultant in what's known as a step-down unit. Step-down unit was, his step-down unit was taking care of patients who had been discharged from the ICU and were in the process of recovering. Dr. Shokar was taking care of the sickest of the sickest of the sick. Same or similar circumstances, not the same specialty. Heard about metabolic acidosis. And I know Attorney Frank Koyak mentioned this, but I thought it was important to bring it back in the context of what you heard it at trial. I asked Dr. Berdine a series of questions about reviewing the medical records before he wrote his first report, before he wrote his second report. You may remember that. I asked him at that time, Dr. Berdine, can you show me anywhere in these two reports where the words metabolic acidosis show up? And remember his response as well, these are kind of long reports. And so I asked the court for a break so he could review the reports. He did finally admit that they weren't there. Dr. Berdine wrote those reports. He knew that all along. Knew those words weren't in there. It took him 3 reports, 2 years of reviewing medical records, and a deposition taken by me in which I'm asking him questions about his theory of overdose in context of the vital signs. That's when the light bulb all of a sudden went on for Dr. Berdine about metabolic acidosis. 2 years of those medical records, and he comes up with it at the last minute. How credible is that? Precedex. We know he never ordered, never set titration parameters. We know his opinion on Precedex is based solely on the package insert. A package insert which Dr. Garibaldi told you, no critical care doctor who uses that medication every day considers that to be standard of care. It's not even used as a guideline. It's clinical practice. It's how it's used in clinical practice that sets the standard of care. And Dr. Garibaldi was clear that the manner in which Precedex was used in this case is the standard of care. The guy who's never used the medication in clinical practice, or the guy that uses it every single day. Experience with the drug itself, possible side effects. One. If Grace had gone home, she would have survived. How on earth can that be an accurate statement, given the condition of her lungs? It's absurd. Garibaldi's testimony about what it takes to maintain someone on BiPAP at 100% oxygen. He said, there's no way you can do it in a home setting. Even if you daisy chained oxygen concentrators together, you could not come anywhere near the level of oxygen that Grace needed to survive. And that doesn't even touch on the point that there'd be no critical care there. If that wasn't enough for you to question Dr. Berdine's credibility, mind you of the statement made in in plaintiff's closing about just because you raise your hand, swear to tell the truth, doesn't mean you tell the truth. Remember that? Remember this one. For the proposition that, look, this 50 or 55-year-old or 54-year-old patient, his lungs were worse than Grace's look like. But remember what Dr. Burdine didn't tell you and came out on cross-examination? That man was intubated. He was on a ventilator, and the ventilator helped him survive. Dr. Burdine could have been fair and objective with you and honest with you and tell you, well, you know, all fairness, this man was intubated and survived. Counsel could have made that clear, but they didn't. Dr. Burdine didn't. Aside from the fact that that x-ray proves a good portion of this case, that ventilators save lives when people have COVID, this was a deliberate attempt to mislead you. And when an expert witness engages in a deliberate attempt to mislead you, that ought to have you question everything he says after that. Everything. What is he not telling me? What else did he hide from me? You know, if you are an expert witness like Dr. Burdine, and you're going to come in and accuse that man of committing malpractice, it seems to me that you owe him the duty to be fair and objective and not be an advocate. More importantly, Dr. Burdine owed it to this process, and most importantly, he owed it to you. You violated that duty. So let's talk about the defense experts. You've seen Dr. Binstock's qualifications. You know all about him. You've seen his work through these x-rays. Oops, went too far. Dr. Binstock's opinions. She was admitted with moderate to advanced COVID-19. The imaging establishes that her lungs continued to deteriorate through the 13th. The images are consistent with COVID-19 and ARDS, and that by the time she got to the 13th, her lung capacity was 20%. Dr. Garibaldi, again, to try and dispatch of this whole absurdity of metabolic acidosis. Remember, Dr. Burdine cherry-picked data, in particular one, bicarb of 19, and they talked to you about base excess and all that. Dr. Garibaldi came in and told you, number one, nobody uses base excess to determine metabolic acidosis. It's determined by pH. He also told you that he looked at the ABGs up until the 12th, and he, I think to his credit, admitted that he did make a mistake in his report. That he looked at the medical record wrong and failed to distinguish between the 12th and the 13th. But he was honest about that with you. That I made a mistake. Because the ABGs up to the 12th tell the story. And instead of a metabolic acidosis, Grace was experiencing a opposite. Dr. Garibaldi and Dr. Shokar talked about the concept that there could be a secondary metabolic acidosis, but it's not the metabolic acidosis that Dr. Burdine was trying to sell to you. The kind of metabolic acidosis that Dr. Garibaldi referenced is a response to her alkalotic state and is completely appropriate. Dr. Garibaldi, you know about his qualifications, where he went to school and all that, but I think what he brings to this case that nobody else does, and certainly not Gilbert Burdine, is his vast knowledge about COVID-19. You might remember that Johns Hopkins during the COVID pandemic was front and center. They had the data that showed the ongoing cases, and it was like a heat map. You could see where there were outbreaks and where there were surges. He was involved in that. He has dedicated a substantial portion of his time since COVID, since COVID started, researching, writing, and giving presentations on everything related to COVID. Dr. Garibaldi testified that the care and treatment provided by Grace's healthcare team met the standard of care. That when she entered the hospital on October 6th and the ICU on the 7th, she had severe COVID-19 and her lung condition continued to deteriorate over the course of her hospitalization. Confirmed that Dr. Schokar did not need to obtain informed consent to use lorazepam or morphine. Number one, because their medications routinely used in the ICU. And number two, Dr. Schokar was confronted with an emergency in which his only two options were lorazepam or morphine, or do nothing. Ordering lorazepam and morphine on October 13th to reduce Grace's respiratory rate was reasonable and did not violate the standard of care. That's what Dr. Garibaldi testified to. Dr. Garibaldi also issue of the do not resuscitate order. He told you that he's had these discussions. He's seen notes from other discussions, and the notes prepared by Dr. Schokar were some of the most detailed notes on these types of conversations he's ever seen. Dr. Garibaldi was clear in that intubation was the best option to preserve Grace's life, and that without it, resuscitative measures would be futile. He also told you that Grace Schara's death was caused by acute hypoxemia due to COVID-19 and not a medication overdose. Dr. Beach. Dr. Beach has dedicated the last 20 plus years of her career researching all kinds of issues involving medical ethics, DNRs, informed consent. She told you that at the time that Mr. Schara consented to have Grace admitted at the hospital, that was implied consent. Implied consent includes use of routine medications, in this case, lorazepam, Precedex, morphine. And that the use of those medications did not require a separate informed consent discussion. She also told you that since Dr. Schokar did not order the Precedex, he had no duty to have any type of informed consent conversation with Scott Schara. She confirmed that the orders for lorazepam and morphine, since they were given in an emergency situation, did not require informed consent. She confirmed what Dr. Garibaldi said about the appropriateness of the conversation on the DNR, that it was within standard of care, was properly documented, and that it's clear that the family gave consent to enter that DNR. She confirmed that standard of care when it comes to a DNR does not require a witness, does not require a document signed, in this case by Mr. Schara as the patient representative, require the use of a bracelet. So we're at the portion of the case where it's now time to look at the law, discuss the law a little bit. 15 minutes.
Rush anybody. This is too important to try to cut somebody off by 10 minutes or 15 minutes. So I want them to have their final say to however long it takes. Same thing on how the whole trial works. But the food is there for you. It's 1 o'clock. You know, you haven't eaten since 8 o'clock, so I want to be respectful. I know the attorneys are going to want to get something to eat. So what I'm going to do is the minimum. I know you guys would probably like to eat and get back in here. But the minimum I'm going to do is 30 minutes. And when you go back to the jury room, if you'd like more, so that you can do the things, the phones will be given to you as well. Just let the bailiffs know right away that you'd like more than 30 minutes. Tell us how much you'd like, and then that's the amount of time we'll take. The jurors are excused. You may be seated. This is a hearing outside the presence of the jury. You know, about 10 minutes ago, I was gonna give them a break for lunch after you were done, because you had said 40 minutes. And it's been 51, but I figured it was plus or minus 30. So how much time do you? Yeah, 30 minutes plus or minus 20. That's good. I'm bigger than that. I told Dr. Shokar I need to lose. Okay. How do you guys want more than a half hour? Okay. I only see Mr. Boylan saying yes. So you're good, Mr. Administrator, if we give the jury 30 minutes? You're the one who has to do something to Mr. Guzzi. Does that work?
I can do it, sure.
Okay, so let's do 30 minutes. If we hear something, we'll let you know right away and it'll be longer. I'll do that email to the group.
Okay,
Otherwise, let's plan on 1:30.
all right.
All right, we're adjourned.
I can do it, sure.
Okay.
see the key
You by the greater weight of the credible evidence to a reasonable certainty. Keyword is credible. Can't be just any old feather. It has to be a credible feather. Reasonable certainty means that you are persuaded based upon a rational consideration of the evidence. Absolute certainty is not required, but a guess is not enough to meet the burden of proof. If you have to guess at any answer, plaintiff has not met their burden of proof. Burden of proof. So let's take the evidence and now apply the burden of proof to the evidence. On October 12th and 13th, Grace Schara was in the final stages of COVID-19. Her lungs, 20% lung capacity. She was dying and her condition was emergent. Respiratory rates in the 60s, low oxygen sats. For Dr. Schokar, he was in the impossible situation based on honoring the Schara family's wishes for a DNI. But for him, doing nothing was not an option. Did not breach the standard of care with regard to the care and treatment he provided to Grace Schara. Whether it's the order for lorazepam or the order for morphine or his monitoring of the Precedex on the 12th and 13th. As you saw, Dr. Schokar was in contact with Holly McGinnis. Holly McGinnis was charting the RAS score, the vitals, and Dr. Schokar was making notes in his record about what he was seeing as far as the level of Precedex and why it was needed. And when it came time at the end, before he ordered that morphine, he ordered that the Precedex be shut off. Not because there was anything that he felt was, that Precedex was causing. It's because he wanted to take it out of the equation before he administered the morphine. The overwhelming evidence in this case is that the cause of Grace Schara's death was acute respiratory failure with hypoxia due to COVID-19 and not an overdose. That's the overwhelming evidence. That's the credible evidence in this case. As far as informed consent, Dr. Schokar had no duty to obtain conformed. I'll have to talk to my legal assistant about that, which is me. Informed consent regarding Precedex. Dr. Shokar's notes established that he was monitoring the continued administration of Precedex and the continuing need for Precedex to keep Grace calm, anxiety and agitation, to allow her to focus on breathing. I mentioned that Dr. Schokar ordered the Precedex be turned off. The orders for lorazepam at 1749 and the order for morphine were given in an emergency situation and no informed consent was required. And that's not only coming from our experts. Although Dr. Berdine was talking about different forms of medications, he acknowledged that medications can be given without consent in an emergency. He also acknowledged that it's the physician at bedside who is in the best position to determine whether a situation is an emergency. When you put those pieces of testimony together, there really is no dispute in the record that this was an emergency situation as determined by Dr. Schokar. And because it was an emergency situation, the administration of those medications did not require informed consent, and Dr. Schokar did not breach the standard of care. Burden of proof on the DNR, the evidence. Dr. Shokar's progress notes and his testimony established that the discussions he had with the Schara family on October 12th and 13th were within the standard of care. That's confirmed by Dr. Garibaldi, who has had similar conversations, and Dr. Beach, who is an expert in ethics. Further, Dr. Schokar testified that he has never entered a DNR order without the consent of the family. And in this case, He testified that he would not have entered a DNR order in this case if he was not absolutely sure that the Schara family can time, patience, attentiveness. There's one more thing I ask of you, and that's courage. Courage, because the feeling of sympathy could be overwhelming. I don't think there's a single person in this entire courtroom that doesn't feel sympathy for the Schara family at the loss of Grace. Not a single person. And if you feel that way, that's okay. But I'm asking you for courage. Courage to build a wall between that feeling of sympathy and your job, your duty to decide this case on the evidence. Courage that if the conversation in that jury was Dr. Gavin Shokar negligent with regard to the care and treatment he provided to Grace Schara on October 12th and 13th, 2021. Ladies and gentlemen, the overwhelming evidence in this case establishes not only that there was no breach of the standard of care, but that Dr. Shokar met the standard of care and did everything he could possibly do in the parameters that were placed upon him by the DNR order to save Grace's life. That's the evidence. That's the truth. So that question one, no. 100% no all day long. Question three, was Dr. Shokar negligent in informing Grace Schara and her power of attorney about the availability of reasonable alternative medical modes of treatment and about the risks and benefits of these alternate treatments with regard to the care and treatment on October 12th, 13th, 2001. Again, Schara has not met his burden of proof on these issues. In order to answer that question, yes, you'd have to guess. The opposite is true in this case. The overwhelming evidence based on testimony, expert testimony, Dr. Shokar's testimony, is that he met the standard of care when it comes to informed consent, not only with the medications, but with the DNR. Answer those two questions, no. And with Dr. Shokar. Counsel has an opportunity to address you in rebuttal because plaintiff has the burden of proof. I want you to consider the following while he's giving his rebuttal. The argument, or are the arguments he's making based on sympathy or based on the evidence? To the extent he raises any new arguments, why are these arguments now being raised in rebuttal? Why weren't they raised in the beginning? What was it about these arguments that they didn't want me? Ladies and gentlemen, this case has been going on now for 2 years, the lawsuit 2 years. But Dr. Shokar is known about the allegations of negligence. He was responsible in some shape, manner, or form for Grace Schara's death. He's known about that for almost 4 years. He has sat through hours of deposition. He's been present in this trial almost the entire time. He has heard the allegations over and over and over again for 4 years. But he's here defending himself. He's defended himself throughout those 4 years. And he's done so with the unwavering belief in this country's justice system. A justice system that says that justice isn't just for plaintiffs, it's also for defendants that come to these courtrooms. He continued to fight and defend his reputation, although all these things were being said about him, because he had the firm belief, the unwavering belief, that there would come a day where he would be in a courtroom and a jury of his peers would listen to his case and render a verdict in his favor, finding him not negligent. Ladies and gentlemen, today, you are that jury. Return a verdict, answering questions 1 and 3, no. Verdicts speak the truth. Thank you.
Attorney Guzzi, and then Attorney Administrator, if you remember that microphone.
Yes, sir.
And your opportunity to do a rebuttal close.
Are we ready? I'm not going to be using these because you will recall the testimony of Dr. Binstock. Therefore, these are worthless. Dr. Binstock admitted that his analysis was purely subjective, that the read of those types of x-rays are not at all objective evidence, that it's one person's interpretation of films. And it's almost impossible to get two people to agree on what they show. Having said that, I think it's probably imperative that we start back with Mr. Frankowiak. You know, he's talking about the theme of the case and being sympathy. Mr. Guzzi mentioned that to you. They're trying to play on your emotions, that all we have is sympathy here. We don't have just sympathy. We're not running away from the medicine at all. In fact, we're the ones that put up all the medicine that is credible, that is reasonable in this case. And all they've talked about is COVID, COVID, COVID. They just want you to believe that this was a pandemic and therefore she was going to die. She was going to die of COVID. She had COVID. It was an irreversible course. You're intelligent enough to know that that is absolutely, positively what we call a red herring, right? Why else did Mr. Frankowiak spend almost 30 minutes beating up on Scott Schara, bringing up all these things about, you know, his research and, you know, trying to show that he's some sort of a kook, right? None of that has anything to do with Grace, not a single thing. Doesn't have anything to do with proving how Grace died. You just witnessed by Mr. Frankowiak a classic definition of red herring. That being that which misleads or distracts from a relevant or important question, leading toward a false conclusion. That's what a red herring is, and that's what you saw in that entire discussion that Mr. Frankowiak put before you. You know, I'm reminded of that phrase, you can't see the forest for the trees. And what we saw during that dissertation was a whole lot of pretty trees. That's all he talked about were trees. Why is that? Because he's got to focus in on trees so that you don't look at the forest. Keep that in mind when you begin your deliberations. I believe he was the one that said that Mr. Schara would not have allowed for a mechanical ventilation, quote, at any point. Now, these are my notes as Mr. Frankowiak was talking, and I put it in quotes, at any point. Mr. Goosey then stood up and he talked about the fact that we were running away from the medicine, that we weren't willing to talk about the medicine, and that Mr. Schara refused to consider intubation or mechanical ventilation. Well, let's try and, yeah, there we go. So this is Scott Schara's sworn testimony. And we're starting, would that have changed your thought process on whether or not you'd have Grace intubated? They're talking about a discussion between Mr. Schara and Dr. Shokar, right? That whole, you've heard about it countless times. And the question, would it have changed? And his answer, if he said to me, the only way to save her life is with intubation, would it have changed my mind? Yes, it would have changed my mind. So that's the testimony of Mr. Schara. And that question was posed to him by Mr. Goosey. He sat there face to face with Mr. Schara and asked him that question and got that answer under oath. So for him to come into this courtroom, along with his partner, Mr. Frankowiak, and try to claim that Mr. Schara made a reasoned decision with informed consent, being that he was not going to allow for intubation under any circumstances, is a blatant falsehood. And he knows it because he got that answer over a year ago under oath. Mr. Schara said he wasn't willing to give pre-authorization. And I think he used the example, that's like if I were to go into the hospital with a sprained ankle and they asked me to give a pre-authorization to amputate my leg. I thought that was a pretty good way to describe it. Why would you do that? I think I've got an ankle sprain, so no, I'm not going to give you an authorization to amputate my leg. The audacity of the hospital lawyer to beat up on Dr. Bourdain as if he's some sort of a paid expert. He told you under oath he's not even taken $1, and he gave you a succinct, reasonable description of why it is he decided to take this, the first case he's ever taken for a plaintiff, because it was insane, because it was indefensible. He used those exact words when he described what he saw here with regard to the administration of Precedex and the continued use of Precedex, despite a proven example on the 7th and the 8th of October of her overdose. And yet these defense lawyers want to soft pedal it. Like Mr. Frankowiak kept saying, well, if it's a medical event, it wasn't even a medical event, really. They're still coming into this court after all the evidence you've heard about the medical facts, not sympathy, but the medical facts that occurred on October 7th and October 8th. And their own expert, Dr. Goldberger, testified it was an overdose. And their own expert, the ethicist from Johns Hopkins they're so proud of, testified that this was a, quote, life-threatening event. So it's not some illusory manufactured occurrence. It happened. We know it happened. It's in the medical record. And their own experts admit that it was a life-threatening event and it was an overdose. And why didn't they learn from that? I mean, wouldn't a reasonable person think, This particular patient had a terrible reaction to a set of medications at lower dosages than she received on October 13th. And she suffered that type of a, quote, adverse medical event. It's an overdose, and they knew it, and they should have learned from it. And had they learned from it, they wouldn't have prescribed it, they wouldn't have used it, or they would have been absolutely vigilant to the highest degree to look out for what happened to her in terms of the loss of her blood pressure and her hypoxic event. We're not running from the medicine under any circumstance. Mr. Goosey indicated to you under this made-up topic of running from the medicine that this was an emergency situation. Well, let's look at the Precedex side effects that they knew about. You've seen this exhibit before. It's exhibit 37, I believe, and this is the insert for Precedex. And it indicates on this insert, hypotension, 24.6%, an adverse event for vascular disorder. That's 1 out of 4 people are going to suffer hypotension or low blood pressure. And that's exactly what happened to Grace. Why didn't they know that? Why weren't they aware of it? Why weren't they vigilant about it? They could have avoided this whole thing. He wants to say this was an emergency situation and therefore they should be absolved from any liability because they had to do whatever they could possibly do under this emergency situation. Well, if it was an emergency situation on the 13th, what the heck was it on the 10th, on the 7th and the 8th, on October 7th and October 8th? Was this a continuing emergency situation that took place over a period of 6 days, nonstop emergent situation? Of course not. Of course it wasn't. And their own records indicate that they didn't believe that. So who's telling the truth? Which side of the aisle here is bringing you the truth? Which side of this aisle is bringing you the actual medical facts that allow you to make a well-reasoned decision? We are. I'm really outraged that Mr. Frankowiak took such great pains to beat up on Dr. Berdeen. You want to attack his qualifications because he doesn't personally order Precedex? Well, neither does Dr. Garibaldi. Why? Because they're in the ICU, okay? Because they're critical care physicians. They treat people who are on Precedex occasionally when it's used, when it's mandated, when it's considered to be a potential benefit. But just because he doesn't use it himself, well, guess what? He recognizes that figure. He recognizes the dangers and the likelihood of an adverse event when you use Precedex. But this is the same lawyer that brought you Julie Davis. Wants to argue about Dr. Berdeen and that he's got some agenda and he's not qualified to render an expert opinion in this case. I guarantee you that if Dr. Berdeen was not qualified to bring you an expert opinion for your consideration in this verdict, that man would have made that decision long before you came in and took those seats. That's what happens. That's why Dr. Berdeen was permitted to testify. 46 plus years of experience as a critical care physician. Yet they brought you Julie Davis. Wants to talk about Dr. Berdeen or why we only brought 2 experts in this case? Well, guess what, folks? We're now on Thursday. Is it Thursday already? 2.5, almost 3 weeks of trial testimony. If we had brought you as many experts as they thought they could load up on, we'd be here until July 1st. There's no need for that. The medical facts in this case dictated that on behalf of the plaintiff, we made a concerted effort to examine what we needed to present to you. We made that decision. And that decision was one nursing expert who was well qualified and a critical care physician with 46 years of medical practice. They brought you Julie Davis. They have absolutely no basis to try to tell you that our experts were unqualified. When they brought Julie Davis, they couldn't find a nurse in this entire country that wasn't working through some expert search service with 2 middlemen that were taking a cut of the fees. Come on, you could see through that. You could see that that woman was so unqualified to render a reasonable opinion that it was screaming out at us. Came up from Snellville, Georgia, had started doing this kind of work when she was a 2.5-year nurse. It's outrageous. We never saw any invoices for her work. Remember that? We talked about when she admitted that she couldn't understand exactly why her hourly rate was different from what she claimed it to be. Oh, that must be because there are 2 middlemen involved here. She didn't even know anything about Vident Partners, the expert witness search firm that tracked her down. And the last invoice we saw from her, if you recall, was December 15th. And she admitted she'd done a lot of work after December 15th. But we never saw an invoice. We have no idea as we sit here today what that law firm paid. It's outrageous. I guess you get what you pay for. Mr. Frankowiak kept saying to you, I want you to read between the lines. I want you to read between the lines. He made a comment about Dr. Berdeen betrays a distressing level of ignorance. How dare you? COVID caused her death. That was Mr. Frankowiak. COVID caused her death. Well, we brought into evidence the fact that they didn't want to give you that 1.4% people nationwide died from COVID. That fact is in evidence. He kept referring to those overdoses of October 7 and October 8 as, quote, some medical event of note. What? Some medical event of note? This is an overdose. Your own experts admitted it was an overdose. And because your clients refused to accept it, refused to look into the medical record, and refused to learn from what happened when Grace was overdosed on the 7th and 8th, and learn from it, you want to call it some medical event of note. Outrageous. He also said that it was false, quote unquote, false for Dr. Berdeen to tell you that there was no pulse. That statement by Dr. Berdeen was false. Well, guess what? Another to hide from the truth. The reason Dr. Berdeen said that in that synopsis, that brief played on the screen for you earlier, where he included those words insane and indefensible, was because they were trying to put an arterial line into her. And it is just what it says, an arterial line. And you've heard as the medical facts have come out, you know, you've got veins that take the blood back to the heart. You have arteries that take oxygenated blood out to the extremities, including your brain, if you're getting sufficient oxygenated blood, and all of the organs, all of your major organs. If you can't get an arterial line in when you're pricking the skin to find an artery, you have no blood pressure. That's what Dr. Berdeen was referring to. They couldn't get an arterial line. Remember I told you about the hose? I used an example of a hose. You turn the water off and a hose is just gonna lay flat. That's exactly what it looked like. Her artery was a hose when you turn the water off. They brought you 6 experts, among them a radiologist, Dr. Binstock, who I just referred to, admitted that his business, his life's work is looking at these films and that it's totally subjective. Think about that word. They brought an ethicist, and the best thing we got out of that ethicist was this was an overdose event on 10/7 and 10/8. They brought an infectious disease doctor, Dr. Fisk. We've got a slide on Dr. Fisk. He didn't know a thing about Grace except she had Down.
Is it the standard of
That's good. Go ahead.
care to administer morphine to a patient who is without a pulse?
So in most situations, it is, I would say, it depends upon the cause of the lack of a pulse. But in general, morphine administration is not given to someone without a pulse.
And ask for the computer screen to be brought up. I'm sorry. And it's page 209 of the deposition transcript. Here you gave me a really not a straight answer, but in February you did. I asked you the question, is it standard of care to administer morphine to a patient who is without a pulse? And then it says there's some objections, but you're the witness. What was your answer?
Is no.
Is no. When forced, he tried to sort of wiggle out of it. There was an objection. He was allowed to answer the question. No. No. Judge is giving you the law, and we harped on this a little bit in my first opportunity to talk to you. with regard to credibility. That's why we played that. Witness credibility. The clearness or lack of clearness of a witness recollection, the reasonableness of the witness testimony, bias or prejudice, facts and circumstances which tend to either support or discredit the testimony. Dr. Fisk knew, and he didn't want to have to admit that until he was forced to, and until he was presented with the answer that he gave, the correct answer, which he had given in his previous sworn testimony. What does that help you to do? It helps you to determine those witnesses are not credible. You didn't see them able to do that with Dr. Berdine or with Nurse Susie Eichinger. Couldn't do it. Because why? They came in, they told the truth, and they were consistent. And their manner of testifying was such that they were direct, they were to the point, they answered the question. Who has credibility? Do we have credibility? Do our experts have credibility? Or do their 6 experts that they brought in to gang up on 2 when you only need 2? Okay, let's talk about the visitation policy briefly, and we can just get through this, John, on the video screen. We clear up this issue. We're putting up what's already been in evidence regarding the Ascension Hospital's visitation policy. I mentioned earlier, why do they have a policy if they're not allowing visitation? And why would they allow a policy if you've got an advocate with a power of attorney that's treated like a visitor and kicked out at 7 p.m.? Visitors are not allowed unless they meet the following exemptions. Designated support person, i.e., or example, a caregiver who tends to the needs of someone, concerns of a person with short or long-term limitations due to illness, injury, or disability. Clearly, Grace fit that category, and therefore, so did Jessica as a visitor. She wasn't actually a visitor, she was a power of attorney. Grace had Down syndrome. She was entitled to a support person. And it's undisputed from the evidence that for 47 hours, we counted them all up, we talked about it, for 47 hours, Grace was without an advocate or a support person. The entire day of October 10th was a failure by the hospital when they barred Jessica. Now, there's been some attempt to talk about those jury instructions and the verdict forms. If we could go to page 8, John. Let's zoom in on that paragraph that says, if you conclude. The judge has already given you the instructions. You'll have them. If you conclude from the evidence that the death of Grace Schara was caused jointly by Dr. Shokar's negligence and also by the natural progression of Grace Schara's COVID-19, then you should find that Dr. Shokar's negligence was a cause of her death. Doesn't have to be the cause, was a cause of her death. Let's go to the page 13. Paragraph where the judge cites you to the law if you conclude from the evidence that the death of Grace Schara was caused jointly by the negligence of the registered nurses at St. Elizabeth Hospital and also by the natural progression of Grace Schara's COVID-19, then you should find that the registered nurse's negligence was a cause of her death. That's the law. We also want to look at the page 13. A person's negligence is a cause of a plaintiff's injuries or death. That's the section that says, if you conclude from the evidence that the death of Grace Schara was caused jointly by the negligence of the registered nurses at St. Elizabeth Hospital and also by the natural progression of Grace's COVID-19, then you should find that the registered nurse's negligence was a cause of her death. You can find that based upon the evidence. All of this discussion about COVID-19 is a distraction because these actual jury instructions tell you that even with COVID-19, you can still find that Dr. Shokar is still on the hook. The jury instructions tell you that even with COVID-19, you can still find that the hospital, through its nurses, is also on the hook. Let's go to the verdict itself, because that's what's going to help guide you when you begin your deliberations. When we look at the verdict form, question number 1, was Dr. Gavin Shokar negligent with regard to the care and treatment he provided Grace Schara on October 12th and 13th? That question does not relate to October 10th. It doesn't even relate to October 7th or 8th. Was he negligent with regard to the care and treatment on the 12th and 13th? Answer is yes. You then move on to question 1A. I know the judge went through this with you, but I need to make sure you completely understand how you're going to go about answering this verdict form, because at first blush it looks a little bit complicated, but if you work your way through it, you'll find that it makes perfect sense. I've been working for 2 days to get this right. Question 1A, we find Dr. Gavin Shokar violated the standard of care by allowing the ongoing administration of Precedex to Grace Schara on October 12th. Answer is yes. We find that Dr. Gavin Shokar violated standard of care by allowing the ongoing administration of Precedex October 13th. Answer is also yes. We find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam on October 13th. You've already heard so much information about the effect of combining these medications, and that's what this question gets at, and the answer to that question is also yes. We find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam. Question 1C, yes. Question 1D, we find Dr. Gavin Shokar negligent by ordering the use of morphine on October 13th. The answer is emphatically, all caps, yes. Dr. Burdine told you the worst clinical decision he has seen in over 46 years of medical practice. That's how you answer that question. Answer question 2 if you answered yes to question 1, of course you have. Was such negligence by Dr. Gavin Shokar a cause of injury or death? So this is the corollary question after you found that he violated the standard of care, that he was negligent. Then you're asked, was it a cause of injury and or death? And the answer to that has been proven yes also. Question 3, was Dr. Shokar negligent in informing Grace and or her power of attorney about the availability of reasonable alternative medical modes of treatment and about the risks and benefits of these treatments with regard to the care and treatment on October 12 and 13? Yes. How do you know that? Because he continued Precedex. He ordered lorazepam. He ordered morphine. And he failed to notify the family that he had placed a DNR order in her record. And you heard Julie Davis, their nursing expert, say, when I asked her about the ability to see the record, which I thought was really kind of a dumb question, but she gave it to me. Of course, the family can't see the medical record, so how would they know that a DNR had been ordered, that a DNR was placed in the chart? And Nurse Davis said, well, you don't have access to the chart until the conclusion of care, or if the patient is dead, and her answer was the conclusion of care. Then we go to question 3A. We find that the standard of care required Dr. Shokar to get informed consent prior to ordering morphine on October 13th, and he failed to satisfy that standard of care. There's been plenty of testimony on that point also, and the answer is yes. Question 3B, we find the standard of care required Dr. Shokar to get informed consent prior to verbally ordering lorazepam on October 13th, and he failed to satisfy that standard of care. Of course he did. Answer is yes. Dr. Shokar violated the standard of care by placing a DNR order without informed consent. We talked about this. What does informed consent require? The answer to that question also is yes. Question number 4. Was such negligence by Dr. Shokar in informing Grace Schara and or her power of attorney a cause of injury and or death? Yes. Once again, continuing Precedex, lorazepam, morphine, and failed to notify the family that a DNR order was in Grace's chart. Question 5, were one or more of the nurses at St. Elizabeth Hospital negligent with regard to the care and treatment provided at Grace Schara between October 6th and October 13th? Note that in this question, the judge is asking, were one or more of the nurses negligent? Answer is yes. Question 5A, we find the standard of care required the nurses at St. Elizabeth Hospital to inform Grace Schara or power of attorney of the medical event on October 7th involving Precedex. Failed to inform Grace or her power of attorney. And of course, they failed to satisfy the standard of care. The answer to question 5A is yes. Question 5B, we find the standard of care required the nurses at St. Elizabeth to inform Grace or her power of attorney of the medical event on October 8th. So 5A goes to the October 7th overdose, and question 5B goes to the October 8th overdose involving Precedex, and they failed to satisfy that standard of care. The answer is yes. Question 5C, we find the standard of care required the nurses at St. Elizabeth Hospital to communicate with Grace or her power of attorney, and they failed to satisfy that standard of care on October 10th. Why? Because Jessica had been barred from entering the hospital as the patient advocate. You recall that the Schara family had to hire a lawyer in order to get Jessica into Grace's room. Answer is yes. Question 5D, we find that standard of care required the nurse at St. Elizabeth to communicate with Grace or the power of attorney in creating a plan to get a replacement for Scott on October 10th, and they failed to satisfy that standard of care. Answer is yes. Question 5 E, we find the standard of care required the nurses at St. Elizabeth Hospital communicate with Grace or her power of attorney, and they failed to satisfy that standard of care on October 13th. Why is the answer yes? Because they failed to notify the family of the DNR order, and they failed to place a DNR bracelet on their daughter, on Grace Schara. Question 5F. We find that Grace Schara's family revoked the DNR order on October 13th and communicated that decision to the nurses at St. Elizabeth Hospital. Further, we find that the standard of care required the nurses at St. Elizabeth to take immediate action at the time they were informed of the decision to revoke the DNR order, and they failed to satisfy that standard of care. Answer, yes. So, question 6, only if you've answered yes to question 5, right? Was such negligence, this is the cause question, was such negligence by one or more of the nurses at St. Elizabeth a cause of injury and or death to Grace? The answer is yes. Then you go to question 7. If you've answered yes to 2 or more, question 2 and question 4 and or question 6, assuming that the total negligence caused Grace Schara's injury and or death to be 100%, what percentage do you attribute to the following? And your choices are to establish a percentage of negligence between Dr. Shokar and the nurses at St. Elizabeth Hospital. The amount must reach 100%. You have, based upon your collective wisdom and your review of the evidence, the ability to attribute this negligence either 50-50, 100%, however you want to do it. Question 8, what sum of money will fairly and reasonably compensate plaintiffs for Grace Schara's death with respect to? And the court has already put the number for the funeral and burial expenses in, because that number is not in controversy, and therefore you don't have to decide it. It's already there for you. And now the issue becomes, what amount of money do you attribute to the personal injuries for the lack of informed consent? And in C, pain and suffering. And this gets back to that very difficult question that we deal with in these cases, and that's why I was in a position to say to you during the jury selection process, if you're selected to serve on this jury, and what I was getting at is, if you end up sitting here now at almost 2:30 on a Thursday afternoon, will you be able to award a monetary amount? And I mentioned the dollar amount of $10 million. I'm suggesting to you that based upon how egregious this case is and what she suffered, that amount is a starting point. You have the ability to go up or down. You can award more than $10 million. The evidence showed that she suffered life-threatening events where she was almost gone 2 times, and then the 3rd time she died. And if you've heard people talk about seeing my life pass before me in those moments before death, she suffered 3 times that life passing before her. What is that worth? Ask yourselves, what is the life of a 19-year-old daughter, sister, aunt, a lovely girl who enjoyed life? What is that life worth? I recognize that it's a difficult question, but it's one that the law in this case requires you to answer. Ladies and gentlemen, we have been together for a long time. We're into our third week, and you are now about to have this case delivered to you to decide. We've been working every day to try to show you the truth in this case. I am so proud of the lawyers on our team who have worked tirelessly, many hours outside of what you even observed in order to get this case to you. I know it's been hard, and I know you spent time away from your jobs, away from your family. We know that you're not making $12,000 a day to sit here. We understand that. We know that there's been a lot of complex medicine in this case and a lot of red herrings. And it's going to be your job now to go back into that jury room and sit down. And your first task is going to be to select a foreperson of this jury. And when that happens, I'm going to ask you all to reflect deeply and ask yourself whether you're best equipped to do that. That you are the most fair and impartial of your group to do that. And it can be a difficult job at times. You're going to have a lot of competing voices. There's going to be a lot of conversation. There's going to be a lot of discussion. It's going to be the foreperson's job to manage that discussion, to keep it orderly, and to keep it focused on the evidence and the law, and to return a fair verdict on behalf of the plaintiff. I encourage you to volunteer as a foreperson if you feel you're capable, and consider the opinions of the other jurors, but do not give up your position merely to be congenial or polite. Stick to your guns, but return a fair and just verdict. I trust that you will. And I trust that you recognize that we have not only proven this case by a single feather, but by a whole flock of feathers. Thank you.
Thank you, Attorney Administrator. Members of the jury, this case is now ready to be submitted to you for your serious deliberation. Consider the case fairly, honestly, impartially, and in light of reason and common sense. Give each question in the verdict your careful and conscientious consideration. In answering each question, free your minds of all feelings of sympathy, bias, and prejudice. Let your verdict speak the truth, whatever the truth may be. When you retire to the jury room, your first duty will be to elect a juror who will preside over your deliberations and write in the answers that you have agreed to. The vote of the presiding juror, however, is entitled to no greater weight than the vote of any other juror. When your deliberations are concluded and your answers are inserted in the verdict, the presiding judge will sign and date the verdict, and you'll let the bailiffs know that you have a completed verdict. And at that point, all of us will return into this courtroom to have that verdict read into the record. I would like the clerk to announce the alternates.
Alternate number 1, juror number 386. Alternate number 2, juror number 2749. And alternate number 3, juror number 2419.
Okay, the three of you have been selected as alternates, and we're going to start that process in just a minute, but I'm going to ask that the bailiffs please come up and have the clerk swear you in.
And each of you do swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon. So help you God.
Ask one of the bailiffs is going to take the three alternate jurors down to the jury room. The alternate jurors, the process for right now will be for you to grab whatever is yours out of that jury room, your notebooks, your jackets or purses, whatever you have, and then you're going to come back down into the courtroom, and the rest of us are going to be waiting for the three of you to come back. So will the bailiffs please take the alternate jurors? For the remaining jurors, just a couple of things, and we can always go through this, but I just try to short circuit some things. So I said it earlier that if you have any questions for me or you need something, you probably understand that I'm going to do what I can to get you what you need, you know, an exhibit or something else that you need. If you write me a letter by the foreperson, be as specific as possible. And that might be challenging for you, but if you can be specific as possible, most of the time I'm going to meet with everybody and then you're going to get my answer in writing, signed by me, and I'm just going to give you that same sheet of paper back. If it gets more complicated, every once in a while I'll bring the 12 of you back in here and I'll give you some verbal answers, just if it's going to take too long to write down. When you're waiting for me to answer that, continue your deliberations. Because it may take 15 or 20 minutes for us to get everybody together and then answer it and get it back to you. The other thing, and now that it's relevant for you, is we will knock at 4:30. So if we don't hear from you before 4:30, you should understand that one of the bailiffs will knock on the door and ask you that question about what you want to do today. That is not intended to bother you or disrupt you, and you're not going to hear from me in any other circumstance than that. So I'm just going to be back in my office. I'm going to wait to hear from you. And that'll be the same case, you know, if we show up tomorrow, you're only going to hear at 11:30 or, you know, half hour before lunch and then a half hour before dinner. And that's just the normal process. When you go back to the jury room, these original documents will be brought in it'll be a couple minutes after you get back there, because I want to talk to the attorneys and make sure I get approval. Is there any objection? Attorney Frankowiak?
No, Your Honor.
Okay, so then I will give those to the bailiff now. These are the original ones. They're not stapled. They have paper clips on it. So you all have stapled copies. When you're done with your verdict, I will need the originals back of the verdict and the instructions along, well, the verdict will be completed. All right, the alternates are back. And so at this time, the 12 jurors who have been selected to serve as jurors, you're going to be free to go to the jury room, begin your deliberations, take your verdict forms and the instructions that I gave to you this morning with you. So you can take your sheets that I gave you. The jury is excused. Bill? All right, everyone may be seated. The three alternates are here. The 12 jurors are excused. I can't say much to you because it's as if you're in deliberations, but like what I will tell you is the plan right now will be that the three of you are going to go down to a separate jury room. You'll have your phones and whatever else you need. You just continue to contact with the bailiff. The rules are still the same, so you're prohibited from speaking with each other or with anyone about anything, involved in this case. So you're still part of this case. And I told those jurors that the first time I'm going to bother them or contact them is at 4:30. And so when we get their answer at 4:30, a bailiff will let you know what their answer is, so you know what the plan is. If you need anything, there'll be a juror or a bailiff outside your door, and just communicate with them, and I'm going to be in the back and answering questions. I hope that's enough, but if you have additional questions, write it down, put your number on it, get it to a bailiff, and then I'll answer it in writing. Are the alternate jurors free to leave, Mr. Administrator?
Approach.
Yes. Make mistakes and I forget to say something, so the attorneys just reminded me, because you probably are sitting there going, well, why did I get picked or something? Yesterday when I was in the middle of our meeting, somewhere in the, like around 1 o'clock or 2 o'clock, we put all 15 names of the jurors, or we didn't put your names, put your numbers into a basket, and the clerk spun it around, which is the format that we use. The clerk reached in and pulled out the 3 numbers that are yours. So it wasn't done by me, it wasn't done by the attorneys, it was done in that method. You're not, in fairness, you're not excused yet. So, you're still our jurors, and should be ready to go, because it's not unusual that something happens and one or more of you are going to be asked to go into that room. Okay. Thanks for that reminder, counsel. The alternate jurors are excused. All right, everyone may be seated. Any issues, questions, concerns? Start with you, Mr. Administrator, regarding the reading of the instructions, the closing arguments, or anything that we did today.
No, Your Honor.
Attorney Guzzi.
No, Your Honor.
Okay, Attorney Frankowiak.
No, Your Honor.
Okay, I received from you during that last break, Attorney Boylan, a request to seal. Have people had an opportunity to review that? Okay. And so we should probably talk about it at some point. I think if you guys want to take a break, but nothing's published yet, I don't believe. And so. Okay. Oh, you filed, I didn't get it until noon, the noon hour. So here's a question. Is there any reason not to seal all of the medical records? I think that was part of the request.
Yeah, absolutely.
Okay, and if there's anything else sealed, or you want to be sealed, like when I was going through that list, like Ms. McGinnis's time card, for example, that wouldn't be part of a medical record, so it's not in that batch. But I don't know if I'm gonna provide you a list right now that I just went through as you were closing, Mr. Administrator. You guys can write them down, and if you think there's something in addition to the numbers that I'm giving, I'd like you to kind of speak out or And then exhibit 430 through 440. Exhibit 441, 445, and 446. Exhibit 86 and 87. Exhibit 205, 212, 214, 217, 218 through 220, and then 222. Exhibit 366. Exhibit 1, which I think we've covered. Exhibit 362 and 363. 372 and 442. 372 and 442. 103, 100, and 102. And I don't think that includes the 259 and 413 that you asked for in your letter, Attorney Boylan. So remind me what those two documents were.
Portions of the medical record as well that have.
Okay. Oh. Okay, the death certificate is, yeah, 413. Any objection including that? Okay, so 413 is sealed, and then what's 259? And so as you're looking for that, what I want the attorneys to know is that list that I just gave of the medical records. My understanding is those are all of the medical records other than exhibit number 1. If you think there's something more, do that soon, because if they ask a question about getting medical records, my thought is that those are the numbers we're going to give them. Instead of giving them exhibit number 1, remember that discussion during the trial? If they ask for something specific, we'll give them that specific medical record. But if they were to say, well, we want like the notes from the nurse, you know, those are the numbers that are here. And if you want to go through those, you know, I'll keep these out or with the clerk during the break. But what she did was just got to me each of the exhibits day by day, and I just highlighted yellow, and then the yellow's attached. So like this stack could be ready to go to the jury, and I think those are the medical records. What's 259? Okay, so 259 will be sealed. So all of the documents that we just numbered will be sealed based upon the agreement of the parties. Anything else on your letter, Attorney Boylan, then? Anything else on exhibits from the plaintiff?
No, sir.
Anything else on exhibits from the defense?
No, Your Honor.
Okay. You know, what's the process or what do you guys want to do? Because I'd like everybody to stick tight for 15, 20 minutes in case you get a quick question and we can respond. And then at some point, I'd like a lead counsel that's going to be back here, you know, within 10 or 15 minutes if we need you to be back here. And a cell phone number that you leave with the clerk so we can call, you know, that number. If the parties want to be here, they're not required to be here. And so it's up to each side to decide who wants to be here. But they should also be under that same rule. So if there's a question, I'd want them to be back within 10 minutes if they want to be part of it. Is that any issues with that, Mr. Administrator?
No, sir.
No, Your Honor. No, Your Honor.
Okay. Anything else? Okay, we'll wait to hear from them and then we'll be in touch. We're adjourned.
and a jury of his peers would listen to his case.
So we're still here in deliberations. I have a feeling it's going to be in deliberation all day and probably tomorrow. I'm going to keep it going just in case they happen to come back. But to be honest, I don't expect them to come back today. Closing arguments took less time than I actually expected them to take. Oh, what's going on now?
I think each of you have received a copy of what's been marked as Exhibit 5. Are you requiring the names of the dissenting jurors to each question, which I interpret to be dissenting? When I heard about this, my thought is we shouldn't require names. It's just numbers, right? I don't know if that's how everybody else is reading it. Okay. So do we want to bring them in and tell them that, or just write it on here? Okay, and same with the juror, the foreperson too? The foreperson should just put their number down, or do they have to disclose their name?
As the foreperson, did that come from the foreperson?
It doesn't say the foreperson, but I instructed them that it should come from the foreperson.
Yeah,
And
right.
that's,
If there is, what I would say is have them sign it, read the verdict, and then file it with redaction.
okay,
Sure, we're okay with that.
okay. So
What's the
maybe
juror number?
262. And you should have a copy, Mr. Mendenhall, you have a copy.
Oh, right. I'm sorry. I didn't realize that. Yeah.
I don't know if we want to put on there, why am I requiring the second reason that it might be, thought about is because I want to make sure I get a consistent verdict. A verdict that's legal. So I don't know if we want to go to that level to explain it to them or just juror numbers are sufficient.
I think the gist of their questions, we refer to them by number throughout this entire process.
Oh.
And I think they're thinking, well, why all of a sudden we have to give them names?
Okay.
That's the gist of it. If that's the gist of it, then I don't think there's anything.
Okay, so I'm going to write on here, I apologize for any confusion. Any dissenting jurors should use their jury or use their juror number and not their name. Is that good? I will sign it. I'll give it to the bill to take back in.
Judge,
Yes.
I think to avoid the next question, you might be able to add that the that information about the foreperson also at this time. Foreperson can also list their juror number.
I think what we just said is have them use their name and then we redact it because if it needs to be signed. Isn't that what you just said, Mr. Guzzi, and everybody seemed to agree?
The signature is different. I do think it must be signed, but they don't have to list their name. They'll sign their name. I can't read my name. They list their number without.
Meaning sign their name and then on the line that says printed, they just put their number?
Put the juror number rather than print their name.
Okay.
For the foreperson.
I think.
For right now, why don't we just focus on the dissenter since
Right.
that's what they asked? Okay, but we may get another one, so I'll hand this to the bailiff to take back in and I'll keep in touch with you guys. We're adjourned.
So it looks like we are going to wrap up, at least for the moment. They're just answering some questions. It looks like they're actually starting to vote. They're wondering on how to actually do that. So we'll keep this going for a little while longer. Maybe they'll come back again this afternoon. Again, I doubt that they're going to come back this afternoon, but we'll give it a shot. In the meantime, let's talk about coffee. If you still haven't tried 1775 coffee, now's your shot. 1775 starter kit just dropped, only 1,000 units. You're getting the bold dark roast that hits harder than a CNN fact check, the smooth medium roast, and the vitality mushroom coffee for clean energy and laser focus, no crash. All single origin, small batch, toxin free and mold free, plus you're also getting a gold spoon clip because freedom isn't scooped with plastic. A frother strong enough to stir up your coffee and your mother-in-law's political opinions. And a black 1775 tumbler that says, I don't take life advice or caffeine from a woke sea witch. $170 worth of coffee and gear, yours for $99. This is for the ones who've been watching 775. Oh,
I just noticed that it doesn't have a jury number on it, so I'm going to give it to the bailiff to give back to the juror. But I'll read it now so you can get ready for it. It says, why are multiple nurses being accused of negligence in the questions when the original complaint only names Holly McGinnis? Shouldn't all accused nurses be here to defend themselves? So we'll hand that back into the jury room, ask them to have whoever wrote it put their number on it. So we're going to have to respond to that.
That's a good question. We haven't made it clear the status of Holly because it wasn't mentioned to them. I don't know. Her name might even still be on the verdict form, like on the caption.
Probably is.
Right.
What exhibit was the last one?
Yeah. Question. That's a very in-depth explanation.
We would have an answer from the plaintiff's side,
Okay.
which is that the hospital filed a motion saying that the hospital is liable for the actions of all of its nurses, and only the hospital. And so the names of the nurses are not relevant.
Yeah.
And won that motion. That's not it, but that's not accurate.
No. It's
Well, I think the accurate part would be the hospital is liable for all of the negligent actions of its registered nurses. So he's missing the negligent part of it. And then explain that at the beginning of the trial, Ms. McGinnis had the battery claim still pending against her, and she'd have been individually responsible for that.
I think it would be
So let's just, I have a question back, and that question is from juror 2495. And I'm marking that as exhibit number 588. We'll have the clerk make copies of it so you see that. We should keep copy files too, I think.
what's that? Well, we
Okay.
haven't yet, but I mean that's not really the question they're asking. Technically, they just want to know why.
So you're being handed a copy of exhibit 588. In addition, I received another sheet of paper, which will mark as exhibit 589. And it's from juror 2495. And that question says, in regards to question number 587, which is the exhibit 587.
Oh, okay.
Okay, why do you need the juror number? Which is that, gets into that consistency issue that I thought I was gonna answer. So I'm marking that as exhibit 589. I'm just gonna have the clerk photocopy that, so each of you have a copy of it, and we'll have to somehow formulate a response to 588 and 589. How would you know it by elimination?
We've got 12 jurors, 10 signed off, yeah.
Well, they're not signing off though. I mean, I think what we should do is, selfishly, we should get them back in here. Because I don't think letters should be coming from everybody. Right, so you know, a reminder that it comes through the foreperson.
Right.
Because if you have a runaway person in there, that they should have to filter it through a foreperson who's managing the communications with us. Okay, so like that one issue, and I don't know who's the foreperson, and maybe none of them are, but and then I think we, as they're out here, we should answer exhibit 589 seems easy. I'm going to explain to them that it's absolutely critical for me to be able to know that at least 10 of the same jurors answered each of the questions. And that's in order for me to receive the verdict, I need to look at it and make sure that that's the case. So we're not trying to call anybody out. We're not trying to make it difficult, but you know, if they want a dissent, they have to let us know they're a dissenter.
Maybe there's a concern about having their names out in the public.
I would think so.
Get that impression? I mean, and maybe we should let them know that that's not gonna happen under any circumstance. Right?
I don't know if I can assure them that their name isn't gonna get out in the public under any circumstance.
Yeah, that's true. That's true. That may be going a bit too far.
I mean, we've taken efforts during the course of this trial to protect their identity and their appearance. But to tell them that there's no circumstance where that's gonna be the case. I'd be careful. And so I think that's an easy one I can just blame it on me that I need to look at it. I need to make sure it all works out to be a legal verdict. And then 588 is the more challenging one. Do you have the screen on for the overflow? So 588, I don't know if there's any reason not just to be brutally honest with them. You know, so, you know, what, just be brutally honest. I mean, that's a really good question, as we've all seen, you know.
Yeah.
And I'm not trying to favor one side or the other, but why not just say, I mean, I think the truth is the hospital is responsible for the negligent actions of its nurses, if there are any.
Well, the hospital employs the nurses, or
yeah.
I think that probably at the hospital employs the nurses and therefore represents them on the verdict for.
Except as it relates to a battery, and at the beginning of this case, that issue was still pending, which is why Ms. McGinnis was sitting at the table. But at the end of the trial, I dismissed it. And so that's why she was treated different than everybody else.
Yeah, I don't have a problem with telling them that that's the case, but I think that's the way how did we word it? The hospital represents the nurses. The hospital employs the nurses, and therefore represents them on the verdict.
As it relates to negligent actions.
With respect to the allegations of the complaint.
Well, they're gonna say, well, okay, fair, but why was Ms. McGinnis sitting at the table and the other nurses weren't? I think that's their question.
Yeah, well, I don't have a problem with telling them that the claim against Nurse McGinnis was dismissed if we haven't told them that yet.
They did in their closing.
Oh, they did, okay.
Yep. And so they can maybe connect the dots that at the beginning of the case, she was able to defend herself, like they worded it, because she had a case, a potential cause of action against her that was different than what was covered by the hospital, her employer.
Right. I mean, we can make that distinction. She was a specifically named party at one point.
Okay.
And whereas the hospital employs the nurse that represents them on the verdict for the allegations in the complaint.
what I'd like you to do is bring the jury back in. Do we bring the alternates in too?
Yes, and Judge, I would like to hear them.
Okay, so yes, and then none of them should bring anything. So all notebooks and pens and papers stay in the room. And then when you get to the outside, just look in and we'll let you know if we're ready. Okay? Okay, go ahead, Mr. Boylan.
Second part to that question about why but the also question was so that they could be here to defend themselves, and I do think it would be appropriate to include in that in your honor's explanation to the jury that all of its nurses are being defended by.
I think that's probably accurate.
I'm sorry?
That by you representing the hospital, you represent all of its employees.
Right, I guess that would be that would be an accurate statement that I am representing the hospital and therefore all of its nurses.
Okay, so I'm gonna, when they come in, I'm going to talk about the foreperson is the only one who asks questions. And then I'll start right with 587 and read it off and read my answer so the alternate jurors know it. And then I'll probably skip to 589 just so we're talking about that same issue. And then I'll come back to 588 and then we'll excuse them without anybody saying anything. If you want to talk, let's do a sidebar. Don't say anything in front of them because they're in deliberations.
Are you gonna identify the foreperson?
I don't know who the foreperson is.
Right,
That's them that from now on, the notes come from the foreperson.
right, okay.
We are, the jurors may come in. All right, everyone may be seated. All 15 jurors are back in the courtroom. So we included the three alternate jurors. Here's the thing, and first thing I want to say is, because you're in the middle of deliberations, it's extremely important that none of you say anything in response to anything that I'm about to say. Okay, but we've agreed that we're gonna bring you back in and give answers verbally. And then counsel can approach after and they'll let me know because they're not gonna say anything while you're deliberating either. So I don't think the alternate jurors know the beginning of the three notes that we've received. So I'm gonna start from that one. I received a note which has been marked as Exhibit 587 from Juror 262. And the question was, why are you requiring the names of the descending jurors to each question? And I wrote an answer on it that reads as follows. I apologize for any confusion. Any dissenting jurors should use juror number and not their name, signed Judge Mark McGinnis. And so if that question was intended to mean, why do we have to use our name when we've been using our numbers the whole time? That's a really good question. And you go, yeah, I apologize, it's your number. You'd put your number and then whatever question you dissented from. The foreperson will print their name, write their name, and then next to their name, put their number. Because in order for me to receive a verdict, I need to have it signed by the foreperson. I will represent to you that as soon as I receive it, your name, both where you sign your name and where you print your name, will be redacted and will not be able to be viewed by the public unless it's an order of this court, which is not likely to happen, but I can't guarantee anything, okay? On that same note, whatever communication comes out of that jury room starting right now should only come from the foreperson. So there should be one person, and if you haven't selected the foreperson yet, then you probably shouldn't write me questions unless your question has to do with, we can't agree on a foreperson, you know, what do you recommend? okay? Because there needs to be one person that's writing the notes to me and that level of communication. There was another question that came in. It was actually the third question in order, so I marked it as Exhibit 589, but it has to do with what we just talked about. And that question says, in regards to question number 587, which is, we took it as Exhibit 587, why do you need the juror number? And I don't want to get in the weeds and make things too challenging or difficult for you. But when your verdict comes back, I will look at it before anybody else looks at it. And one of the things that I'm going to check, and then when I'm done checking it, I'm going to let the attorneys look at it, is it needs to be a legal verdict. And that's a complicated issue given the issues in this case and the way that that verdict form was drafted. But in essence, I need 10 jurors to agree on each cause of action followed through down the order. We tried to give you introductory paragraphs talking about that so that it would minimize any risk that there's some issue. But if we have dissenting jurors, what I'm going to do is I'm going to look, and I don't really care who they are, to be honest with you. I just want to make sure that the 10 people that are answering the questions for each cause of action are consistent and are the same. Okay, so that's the reason for it, and and it's important. Okay, the last question, which is a really good question too, is Exhibit 588, and it says, why are multiple nurses being accused of negligence in the questions when the original complaint only names Holly McGinnis? Shouldn't all accused nurses be here to defend themselves? And the answer to that question is the following. The hospital, St. Elizabeth Hospital, employs the registered nurses. We call them registered nurses on the verdict form, but they're employees of the hospital. And if any employee commits a negligent act during their employment, the hospital is responsible or liable for that. So in this case, right from the beginning of the original complaint, hasn't changed. Attorney Frankowiak, the gentleman sitting with Ms. McGinnis, he represents the hospital. So he represents all of the registered nurses. So they've been defended by him. They've made strategy decisions for whatever reason to handle
service with two middlemen.
something. The reason that Ms. McGinnis was treated different in this case, if you want to call it that, is because when this trial started 2.5 weeks ago, the cause of action against her for battery was still a cause of action. And if you remember the discussions about it, it was intentional conduct that caused harm. And so if an employee does something intentionally, they're not covered by the hospital or by their employer. And so as a result, when this case started, Ms. McGinnis was treated different than the other nurses because she had a battery claim against her that she would have been liable for had she lost on it. At the close of the evidence 2 days ago, I dismissed that cause of action against Ms. McGinnis. And so at that point in time, the battery cause of action was gone. That's why you didn't see it on the verdict form. And she is now at the same level of every other nurse. So if she did something negligent or any of the other nurses did something negligent, the hospital as their employer will be liable, and all of them are represented by Attorney Frankowiak. So that's a lot of information. I think it's consistent with what the attorneys asked me to give to you. And so at this point, I don't want to say does that all make sense because remember, you're not talking and you're in deliberation. So I'm going to ask the 15 of you to return to the 2 separate jury rooms. The 12 of you continue your deliberations. The 3 of you that are alternates, I want you to hear this in case one of you gets put in the place, so you're up to date on what's happened here. And then if you have any additional questions, we'll be waiting to answer those. I hope that this was effective in getting you the answers that you needed. The jurors are excused. So this is outside the presence of the jury. Attorney Administer, anything about that discussion?
No, Your Honor, thank you.
Attorney Guzzi?
No, Your Honor.
Attorney Frankowiak?
No, Your Honor.
Okay, so exhibit 587, 588, 589 are received. The bailiff, okay, yeah, go ahead.
I do have something.
Okay.
And based on the number of questions coming in, I could anticipate that there won't be more questions. But I believe the court said, but I would certainly, the court reporter will know. I believe the court said at one point that the same 10 jurors for each cause of action are the same. We wanted to be sure that the same 10 jurors for each cause of action.
I think that's what I said.
As opposed to the same 10 jurors for any one cause of action are the same. And it's a fine line, but next time a question comes in, I think that would be addressed.
Okay, I'm not sure what the difference is.
Well, if the jurors think that the same 10 for count 1, for count 2, for count 3, and count 4, for example, all need to be the same 10 people, that's different than you can have 10 jurors could find that Dr. Shokar was Shen, and 10 different jurors could find that the hospital was Shen. It doesn't have to be the same 10 jurors for each part. Or not.
Fair enough. I think I was told by the bailiff in between when I was being handed those questions after we adjourned on 587 that they wanted menus and they wanted to stay tonight. So menus have been now provided to them. I don't know if they'll order. So, you know, I read that first question from 587. I thought maybe they have their verdict done already, right? So we might hear from them quickly and they just wanted to understand why a dissenter would have to have their name on it. But I don't want to read too much into it. So if I get that chance, just remind me, Mr. Boylan. And then we'll let you know when they order, if they do. And if they order, then I would say, you know, feel free to go somewhere if you guys want to go somewhere, if you need to, and because it would be at least a half hour. And then stick around in case we get another question. You know, I think it's going to be up to them because that's what I told them, and given what they've done, and they know better. I always think, you know, they're in that room, so they know if they need 15 minutes or an hour. So if it gets to 9 and they say we want to stay, I trust that they're saying we're close, you know, without having to say it. So I'm not going to have a hard deadline, but I would think, you know, at 7 o'clock or so, right? It would make sense to come back tomorrow.
Sure.
Is Mr. Schara planning? I know he's not here and he hasn't been here for any of these jurors questions, but is he going to be here at the end?
Oh, yeah.
Okay, because then he should make, because I don't want to be unfair to either side, but if we get a verdict, you know, we're not going to wait too long to go with it, right? So,
Right.
Okay,
No, he's aware of it. He just took Mr. Flyer to the airport
okay,
and he was coming straight back.
okay. Anything else then from anyone?
Is there a good place to eat within walking distance?
There's a lot of good places.
Where he is. That'd be the first one I'd say, but I'd order ahead
Kind
and
of
maybe go
concerns me
pick it
that
up.
there wasn't one that came to the top of your.
We like to tell you.
We like the Red Ox, and we went to Mark's German restaurant.
Be careful about Victoria's because in May.
Now they're talking about what to
tried
choose for
do
dinner.
lunch there and they were very slow. Of course, for
This is all on the record in the court.
Yeah, I mean, if you really want my recommendation, so where I go is to JD's. I don't know, they probably know. So try that, Mr. Guzzi, and let me know what you think. It's where my wife and I went last night for a little date too.
I'll show up tomorrow.
It's a hamburger joint that's probably beneath your standard, but
No, that is within my standards.
Yeah.
Well within my standards.
JD's, it's just right across the bridge. You know, you can get there in 5 or 6 minutes.
I
But
drive a truck there on
that's if I go out for lunch, which is once every other week, maybe that's where I go. Yeah. All right, good. We're adjourned.
I think that actually means they're going to come back with a verdict tonight. Uh, I don't think this is going to go till tomorrow. Judge said that he'll give them up till 7 p.m. That is Central Time, so it's 8 o'clock Eastern for those of you watching, before he calls it for the day. But at this moment in time, based on those juror questions, it sounds like they're getting pretty close. And if they're getting pretty close, that means they're the majority in agreement. There's clearly at least one dissenter. That's why the question was asked, if they have to include their name as a dissenter. But I think we're on a pretty good track to potentially get our verdict tonight. So thanks for sticking around, and we'll be around for just a little while longer. Let's get into another sponsor while we sit here and wait. This sponsorship is from Rumble, one that is incredibly important to the survival of the company. When Rumble first started in 2013, they built the platform for the small creator. They didn't censor or have biases. They were fair and treated all creators equally. No one thought platforms would censor political conversations or censor opinions on COVID, but they did. Facebook admitted they felt pressure from the Biden and Harris administration. Rumble did not. They held the line. They are attacked daily for giving us a voice to talk to you. They are attacked in corporate media. They are attacked by governments like France. They are attacked from brand advertisers who refuse to work with them. Corporate America is fighting to remove speech. Rumble is fighting to keep it. Rumble won't survive without brand advertisers. They don't get much of it. Watching our show on Rumble is the most they can ask from you. But if you really believe in this fight and you have the means, one major way you can help Rumble survive is by joining Rumble Premium. Join the community that believes in the First Amendment and believes in our human right to free speech. Rumble is offering a $10 off with the promo code STUDIO when you purchase an annual subscription. Go to rumble.com/premium and use promo code STUDIO. Like I said, if you have the means and believe in the cause, now is the time to join Rumble Premium. If you don't have the means, we are just happy you watch us here on Rumble. So it looks like we're going to have a long stream tonight, guys. I'm glad to see you guys here. This will be an exciting night to wrap this up. I don't know about you guys, but I'm pretty excited to see what happens here. This has been an interesting last couple of weeks, me starting my first channel and first streaming. The fact that you guys are all watching this feels pretty freaking cool. I'm appreciative that you guys are all here to watch and see this thing through with me. Expected to be instant. They did say they were going to order some food, so I do expect this to take at least a little while longer. But at this point, been surprised so far about the speed of some of this stuff. We're actually looks like we're going to finish at least a day ahead of time, which is a week ahead of time from the original estimate at the beginning of the trial. So stick around and see what happens. Once this trial wraps up, I will be reposting day one. You'll notice that it's not on my channel. I actually didn't start my channel until day two, so I will be restreaming day one and specifically focusing on Werner Mendenhall's amazing opening statement. I was able to catch most of that, and Barnes said it brought him to tears. It was one of the best he's ever seen. So I will definitely be adding that to the channel. Also coming up sometime this week, I will also be doing a profile on the judge, Mark McGinnis. I've done a lot of research on him. I didn't want to publish that while the trial was ongoing. I didn't want to potentially interfere if that got any type of views or anything like that. So I'll publish a nice profile on the judge once the trial is over as well. Starting next week, I do have another trial that will be going, scheduled to start on Monday. As soon as I get confirmation of its actual start time, I will be announcing that and post that on the channel. So there should be a court case streaming live just about every day moving forward. I've got cases planned out over the next couple of months, and I may start airing some older trials, some very interesting ones during the breaks in between some of the big, more high-profile cases. Anyway, thanks for sticking around. Probably be here another hour or two tonight before calling it a night. Thanks, everybody. To answer your question, Anna Banana, there is not a verdict yet. They are deliberating, and they have signaled that they're very close. It doesn't look like that they're actually going to take until tomorrow. Chances are they would have said, we're not going to figure this out tonight, and we're ready to go home, and we'll start again tomorrow. But that's not what happened. They actually asked for menus and are ordering food to finish their deliberations. Judge said if they don't hear anything as far as a verdict by 7, he's going to call it for the night, send everybody home. So we're just going to kind of hang out and see what happens. And it's been interesting. There's jury questions have come in. They've just restarted. So any moment now, we may get another jury question. The stream come back live and talking about whatever the question judge is going to read and answer live. So it's kind of interesting. I guess we'll see what happens shortly. This is interesting. We're already back again after being adjourned. Turn the cameras back on. Everybody's sitting back down again. This is moving much faster than I expected. I think it's either going to be we're not going to get this done tonight, we're going to adjourn for the night, or we've got a verdict. I don't know about you guys, but I'm on the edge of my seat. I would have to say that it would very likely be in the Schara's favor if they came back this early. Thank you, Liam Sturgis. It says, here's to a good verdict and justice for Grace. Totally agree. I hope we're getting that today, it looks like. Not quite sure if they're back yet, but the fact that the stream came back on and everybody's sitting back down in their seats, something's happening. Neurodivergent one in the chat says, let's hope they aren't of the COVID cult. I totally agree with you. Chances are, though, again, I think if they're coming back this quickly, they're all in agreement. To have all of those people be in agreement that something went wrong, to me, this speaks in our favor. But who knows? Been surprised by these things before. One thing to know, while everybody else is sitting down, the judge is not sitting down at the moment. So we shall see. I think the closing statements were great. As you can see, there's quite a few people watching at the moment. Don't think most of you watched today during the day. Highly recommend going back and watching the stream from the beginning today and watching those closing statements. Very impactful. The fact that they were quite moving. So I don't think that the defense had as good arguments. My take on it is just going off of emotion alone. Plaintiffs are winning. And maybe that's just my hopeful exuberance, but I guess we'll find out shortly. Zach the Cat says, I'd make a good lawyer. I don't know. I don't follow the rules too well. I'd probably make a shitty lawyer just because of that. Pretty good at making some arguments, though. And thanks for sharing the stream. I definitely want to get people to watch this. It's actually the reason I even started this channel, was because there weren't many people talking about this case. There weren't people covering it like this. So I wanted to make sure that it got out there in the public zeitgeist and people talk about it. Good question in the chat. Question is, were they able to come up with a number that quickly if ruling for the plaintiff? I hope so. I hope so too. Not quite sure what'll happen, But I guess we'll see. And it's always possible for these things to come in two parts, where they find the cause of action and then later find damages. So they don't always do that at the same time. Maybe they do here, maybe they don't. Charge the doctor with negligence causing death. Yes, totally possible for potential criminal charges. I had actually asked Barnes about this early in the case and asked if there was any criminal culpability, and he said, "While it's possible, it's highly unlikely. Chances are that they wouldn't actually bring charges against anybody." The sheriff is a staple in every courtroom in America. I have a feeling we're going to come back with a verdict tonight. And chances are there's more juror questions. I've watched a number of trials over the last few years. I have never seen a trial like this one where the jury was so involved in asking questions, the judge reading them, and then being actually aired to the public. This is definitely a first for me. And the judge is back. Let's see what we got. Ago that they had reached a verdict, and then it took them some time to have. They said they needed more time, and now they have reached a verdict. Is anybody have any questions before we bring the jury in? Here we go. We've got a verdict, everybody. Okay, so obviously there's officers present, and I just encourage everybody who's in the courtroom to act quietly and respectfully. No outbursts and no comments to anybody, including the jurors. So we may bring the jury back in.
All right, everyone can be seated. Welcome back, members of the jury. I was told that you have reached your verdict, so if the poor person could hand the verdict and the instructions to the bailiff, please. All right, at this time, I'm going to ask that the clerk read the special verdict form into the record. After the clerk is finished reading the special verdict form, we're going to do a process that's called polling the jury. I'll explain that what that means after that, after she gets done reading it.
Grace Schara, individual, as the administrator of the estate of Grace Schara, versus Gavin Shokar, MD, Ascension Medical Group, Fox Valley, Wisconsin, Inc., Holly McGinnis, RN, in Ascension, Northeast Wisconsin, Incorporated, doing business as Ascension Northeast Wisconsin, St. Elizabeth's Campus, case number 23 CV345. Question number 1. Was Dr. Gavin Shokar negligent with regard to the care and treatment he provided to Grace Schara on October 12th through 13th, 2021? The answer, no. Question number 1A. We find that Dr. Gavin Shokar violated the standard of care by allowing the ongoing admission of Precedex to Grace Schara on October 12th, 2021. Answer, no. Question number 1B. We find that Dr. Gavin Shokar violated the standard of care by allowing the ongoing administration of Precedex to Grace Schara on October 13th, 2021. Answer, no. Question number 1C. We find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam on October 13th, 2021 to Grace Schara. Answer, no. Question number 1D. We find that Dr. Gavin Shokar was negligent by ordering the use of morphine on October 13th, 2021 to Grace Schara. Answer, no. Question number 2, not answered. Question number 3. Was Dr. Gavin Shokar negligent in informing Grace Schara and/or her power of attorney about the availability of reasonable alternative medical modes of treatment and the risks and benefits of these alternative treatments with regard to the care and treatment on October 12th through the 13th of 2021? Answer, no. Question number 3A, not answered. Question number 3B, not answered. Question number 3C, not answered. Question number 4, not answered. Question number 5, were one or more of the nurses at St. Elizabeth's Hospital negligent with regard to the care and treatment provided to Grace Schara between October 6th, 2021 and October 13th, 2021? Answer, no. Question number 5A. We find that the standard of care required the nurses at St. Elizabeth's Hospital to inform Grace Schara or her power of attorney of the medical event on October 7th, 2021 involving Precedex, and they failed to satisfy that standard of care. Answer, no. Question number 5B. We find that the standard of care required the nurses at St. Elizabeth's Hospital to inform Grace Schara or her power of attorney of the medical event on October 8th, 2021 involving Precedex, and they failed to satisfy that standard of care? Answer, no. Question 5C, we find that the standard of care required the nurses at St. Elizabeth's Hospital to communicate with Grace Schara or her power of attorney, and they failed to satisfy that standard of care.
Take a break, but nothing's
2021. Answer, no. Question number 5D, we find.
Okay.
To satisfy that standard of care? Answer, no. Question number 5E, we find that the standard of care required the nurses at St. Elizabeth's Hospital to communicate with Grace Schara or her power of attorney, and they failed to satisfy that standard of care on October 13th, 2021. Answer is no. Question number 5F, we find that Grace Schara's family revoked the DNR order on October 13th, 2021, and communicated that decision to the nurses at St. Elizabeth's Hospital. Further, we find that the standard of care required the nurses at St. Elizabeth's Hospital to take immediate action at the time they were informed on the decision to revoke the DNR order, and they failed to satisfy the standard of care on October 13th, 2021. Answer is no. Question number 6, not answered. Question number 7, not answered. Question number 8, not answered. Verdict is signed by juror foreperson number 2495. Dissenting jurors, as to question number 1, juror number 587. As to question number 5, juror number 587.
What we're going to do is call on each of you. It's called polling the jurors. When your juror number gets called, I'm going to ask that you stand. And when you stand, you're going to be asked 2 questions. The first question is going to be, you have heard a reading of the verdict. Is this the verdict of the jury? And you answer that yes or no. And then, is this your verdict? And your answer is yes or no. And so what that question is asking is, based on what you just heard, is that what the jury agreed to? And then, is that what you agreed to? Yes or no? Okay. When you're done answering, I'd ask that you sit down, and then the clerk will poll the next juror. Clerk, please poll the jury.
Juror number 2412. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat. Juror number 2495. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat. Juror number 1602. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat. Juror number 2377. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat. Juror number 2375. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat. Juror number 2746. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat. Juror number 1989. You have heard the reading of the verdicts. Are these the verdicts of the jury? Verdicts. Please have a seat. Juror number 630. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat. Juror number 1214. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat. Juror number 587. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts?
And remember what you said, so stay standing and we'll start again with you. So if what she read into the record is accurate, then the answer would be yes. And you were listed as a dissenting juror for questions 1 and 5. And so then it would be your verdict too, because the verdict is the whole verdict. Does that make sense? So yes, so I'll have the clerk re-poll juror number 587, please.
You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts?
Okay, stubborn. Let me just try to explain it without influencing you one way or the other. So if what the clerk read into the record and you heard her go through question by question, if that was accurate, then it would be your verdict too, meaning that you voted no on question 1, or I'm sorry, you would have voted yes on question 1 and you would have voted yes on 5, and that's on the verdict form by being a dissenter. Does that make sense? Understood. So you can answer, if you agree with that, I think when it's, is it your verdict, your answer would be yes. That's your verdict because you're part of the jury and you're a dissenter of it. Okay, so we'll try again. Will the clerk please poll juror number 587?
You have heard the reading of the verdicts. Are these the verdicts of the jury? Yes. Are these your verdicts?
Okay. Okay, thank you.
Please have a seat. Juror number 262. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat. And juror number 1026. You have heard the reading of the verdicts. Are these the verdicts of the jury? Are these your verdicts? Please have a seat.
Mr. Administrator, any questions about the polling of the jury or any concerns? Okay, Mr. Guzzi?
No, Your Honor.
Mr. Frikowiak?
No, Your Honor.
Okay, members of the jury, your service in this case is now complete. Many jurors ask if they are allowed to discuss this case with others after the verdict is received. Because your role in this case is over, you are not prohibited from discussing this case with anyone. However, you should know that you do not have to discuss this case with anyone or answer any questions about it from anyone other than this court. That includes the parties, lawyers, media, or anyone else. If you do decide to discuss this case with anyone, I would suggest that you treat any discussion that you have with a degree of seriousness, that whatever you do say, you'd be willing to say in the presence of your fellow jurors in this courtroom while you're under oath, because that very likely is what could happen. And that you do so under oath here in open court in the presence of the parties and everyone else. It is in the public interest that there be the utmost freedom of debate in the jury room and that jurors be permitted to express their views without fear of incurring the anger of any litigants or the criticism of any person. I would encourage you to respect the privacy of the views of your fellow jurors. Finally, should you have any questions before leaving today, you can tell the bailiff and just wait back in the jury room and I can stop back there momentarily. Just let the bailiffs know and I can come down and have that conversation with me. You may confer with me at any time before answering questions. The last thing that I want to say is the following, and I say it in every case, but it probably applies to this case more than others, is that if from this moment forward you have any problems with anyone concerning your involvement in this case, I would encourage you to contact the Outagamie County Sheriff's Department immediately. You can tell there's a presence of deputies here. And they've been present for the last 3 weeks. They've been kept out of view for the most part, out of your view and everybody else's view, but they've been around. And so if that were to happen, I wouldn't mess around with it. I wouldn't wait. And I would just get in contact with the Outagamie County Sheriff's Department, let them know you're on this jury. And they're all very familiar with it. The sheriff has been involved in the planning and the day-to-day operations of it, along with all of his staff. Hopefully that's not going to happen. But that'd be the thing that you do if that happens. The last thing is just thanks again for your service. I appreciate it. The parties and the litigants and the attorneys appreciate it. And I thought you did your service, like the attorney said in their closing argument, with the seriousness and the sacrifice that I have never seen. So I just want to say thanks to all of you, and the jurors are free to leave. Mr. Administrator, anything? Mr. Guzzi?
No, Your Honor.
Okay, and Mr. Frankowiak?
No, Your Honor.
I imagine there'll be filings coming in. You'll be filing documents for the judgment? Okay. Yeah, understood. It's just, I'm not gonna do anything then until I, get something received. I just want to say to you, Mr. Schara, and maybe to your family, I never met Grace, but I'm glad I got to be a part of her for these last 3 weeks in a sort of an unfortunate way. And I know that the world was a better place with her in it, and our community was. Good luck to everybody. We're adjourned.
Well, I am absolutely blown away. I am sad. I am upset. I am angry. I've been so invested in this for the last 2 weeks, and I have watched all the testimony, listened to all the evidence, have followed every part of this trial from beginning to end. And it was very clear to me that not only were they guilty of negligence, I think that they were actually guilty of actual battery and murder. I think that they killed this girl because they wanted to. Beyond negligence, they overdosed her multiple times, and then they stacked on top of that even morphine after that. Yet they blame COVID. Today was not a good day, and sorry that it went the way that it did. I'm looking forward to seeing what Barnes has to say as far as a post-mortem is, because I can tell you I sure don't understand why the jury ruled the way it did. I hope someone smarter than me and who knows this better than I do can explain it, because I sure can't. On that sad, sad note, I'm going to bid you guys adieu, and we'll come back and show a new case next week. Neuro has a channel that we're going to raid into after this one. Go ahead, please hit that, and we'll see you guys next week. It's a good comment. They will have to live their conscience. I think everybody in the chat who's been following this for the last couple of weeks with me are all in agreement. I haven't seen one comment saying that there was no negligence. Anybody who paid attention could see it.